She's hoping.
Thank you.
Yeah. Senator Tyson, Chairman Tyson, I get to see you.
Good morning, everybody. We're going to go ahead and get started this morning. Okay, for the third time, good morning, everybody. That's your opening bell. Or you can tell where mine is, the opening bell. We're going to go ahead and start with introductions. We'll start over here. Senator Starnes, are you online with us? Not yet, so he may be driving in. Okay, Senator Bowser.
Senator Craig Bowser, District Number 1.
Senator Klemp, District 5.
Representative Turner, District 28.
Senator Ethan Corson, District 7.
Thank you, Madam Chairman. As a parent, the freshmen don't know how to introduce themselves, so I'll just give them a little brief lesson here. Virgil Peck, Senate District 15. I live in Montgomery County, but the district includes Chautauqua County, Elk County, Montgomery, Labette, and Neosho counties in southeast Kansas.
Well, thank you, Senator. I do think they do know how to introduce themselves, but Representative Smith.
Thank you, Madam Chair. It's a good thing I'm not a senator in Bellinger's district, or I'd be listing 14 or 16 counties, however many. He rattles them off pretty good. But Representative Adam Smith, I'm from the 120th district up in the northwest corner of Kansas.
Thank you, Madam Chair. My name is Shannon Francis, and I'm from District 125, the opposite of District 1, and I'm the Liberal Republican.
Good morning, Representative Marty Long from District 124, which is the 6 counties in the southwest corner.
Good morning, Don Wolf, District 107, and I am North Central Kansas. Oh. So, good morning, Representative Stephanie Sawyer Clayton. I represent the illustrious taxpayers of District 19, which includes Prairie Village, Overland Park, and Leawood.
Thank you. Senator Tyson, District 12, and I would say that the representative from Liberal is the most conservative Liberal I've ever seen. I was just out there Monday, so it's a good place to be. I love Kansas. So I'm going to start with Eddie.
Eddie Penner, Legislative Research.
Jillian Kincaid, also with Legislative Research.
Sharday Kane, Legislative Research.
Taxation.
Adam Siebers, Office Supervisor of Statutes.
Amelia Kovar Donahue, Office Supervisor of Statutes.
Thank you. And our IT guy? Sorry.
Carter Montgomery, IT.
Thank you, guys. We couldn't do it without staff. You guys know that. That's how the wheels turn up here. So committee, we've had welcome introductions, and we're going to have a review of the committee charge. Thank you, Eddie.
Thank you, Madam Chair and members of the committee. In front of you, the first page after the agenda is a document that is an excerpt from a large memo that our office prepares for the LCC every year at their meeting where they approve interim committees. This is the page that includes the relevant information for this committee. It details the charge of this committee. This committee has 8 assigned topics to it this year. I'll go through those very briefly, but over the next 2 days, the goal for the agenda at this meeting was to get all of these topics in front of you so that for your latter 2 days you can kind of assess what you need more information on. But the first of those is to review countywide retailers, sales tax authority, and apportionment, reviewing the mass appraisal process and its uniform application across counties, reviewing case administration processes and appropriate staffing at the State Board of Tax Appeals, review the progression of and source of authority for property tax exemptions, and review the repeal of sales tax exemptions and creation of an endowed permanent fund to provide for future tax relief as proposed by 2025 HCR 5014. I'm going to pause here just very briefly and explain that within the request letter that the two chairs put together, those 5 items were kind of a first set of bullet points, and then they kind of delineated that these latter 3 had a bit of a different focus, and that's specifically on the taxation of energy and energy-related issues. And so the first of those was to review all points from which the energy industry is subject to and exempt from taxation, examine possible issues related to renewable energy generating property becoming subject to property tax following the expiration of tax exemptions, including possible alternatives to property tax. As a bit of background there, very briefly, almost 10 years ago, the legislature changed what had previously been a permanent lifetime exemption to a 10-year exemption. And so this is kind of one of those, if somebody had set a reminder 10 years ago that, hey, you did a policy change that will have impacts 10 years from now, this is the reminder alert going off. And then the final one is to study issues related to motor fuels taxes, including tax rates, taxation of electric vehicle charging stations, and the distribution of motor fuel tax proceeds to local units of government. So I would stand for any questions on any of those items.
Any questions, committee? Seeing none, thank you, Eddie. Committee, I would also draw your attention, Senator Peterson is online. He's in the Sedgwick County area, District 28. So welcome, Senator Peterson. Next up is Kristen Wheeler, Chairman of the Board of Tax Appeals. Welcome.
Never know, some turn red, some turn green. Pleased to be with you today and have an opportunity to talk to you about the Board of Tax Appeals. I have a couple of goals this morning. One is to not take all of the time allotted to me. As some of you who've heard me testify before know, I can talk forever about BOTA, and I will also write you a book anytime I provide you with information. So Eddie is kindly passing out some information that I've put together for you that expands on the agenda that I provided ahead of time today. I have given this to you so that you would have the more in-depth picture of the overview that I'm going to go through today. I suspect that you will be seeing a lot more from us. The budget narrative that you will all see at some point in the near future is very in-depth. So this is just intended to be a little flavor of what we've got going on at the board and a little update for you. Before I start with that, I wanted to give just a brief overview of what the Board of Tax Appeals is for those of you who I haven't testified in front of before, or for anybody who may be listening who isn't very familiar with the work that we do. We're a specialized administrative tribunal within the executive branch. We have 2 divisions, a regular and a small claims division. Our regular division hearings are conducted pursuant to the Administrative Procedures Act, Kansas Code of Civil Procedure, and the Rules of Evidence, so similar to any sort of court case that you would envision happening in a normal court. Our small claims division is intended to be very informal. There is no record kept. Those hearings are held by telephone or video conference. They're typically very short. All single-family residential properties must go through the small claims appeal process, so that's one thing I want to remind you when you look at the numbers of appeals that we're processing on an annual basis. Both divisions have certain statutory requirements that we have to meet concerning scheduling of hearings and issuing decisions. That's not part of my presentation. Happy to talk to you about that at some point if you'd like more information. We have 3 board members and 1 chief hearing officer. Our 3 board members by statute must be an accountant, an appraiser, and an attorney. That's not a joke. That's what it sounds like the beginning of a joke, but it's not. Our chief hearing officer must be an individual who has some experience in taxation or real estate. The chief hearing officer supervises our small claims division and sits in the event that a regular board member isn't able to participate. The 3 board members preside over all matters that are heard in the regular division. We have statutory jurisdiction over 13 types of tax-related appeals or applications. The most common or familiar to you would probably be number 1, tax exemptions. Nearly all of the exemptions in the state come through our office. Equalization appeals, those would be appeals of valuation or classification of both residential and commercial properties, agricultural use properties. Those are made before taxes are paid. And payments under protest, which are very similar to equalization appeals, but the timing is different. Those are appealed after taxes are paid, either in part or in full, depending on the timing. About 57% of our funding comes from state general fund. I know that might be a topic that comes up at some point. The remainder is from our fee fund. We are currently using fees that have not been raised since 2014. Okay, now to go on to where we're at in terms of case filings, we've put a little chart in the materials that shows you a comparison of fiscal year 23 and 24 to 2025. So the first chart that you have in those materials is our regular division case filings. You'll see here that we are a little bit down on our total number. We went down from 5276 to 4869. I would note that that 4,800 number is still the highest total, excuse me, since fiscal year 2019. So we are still extremely high, even though we have gone down a little bit in overall cases. I think of particular interest to this committee is going to be the fact that we are still seeing an increase in equalization cases, which are those valuation appeals, which have been quite related to property tax concerns. I can tell you anecdotally from sitting in all of those hearings. Going on to our small claims division numbers, this is what I think is really interesting for this year. We saw a dramatic increase in small claims appeals in fiscal year 2023. We had about 700 more that year. I know my numbers don't go back as far in this chart, but they do in the narrative. We had a little bit of a dip last year. This year, we have seen more than 1,000 new small claims appeals compared to the year before. Again, single-family residential appeals must go through small claims. I can't get you an exact percentage right now, but I would suspect that a lot of those 1,000 new appeals are going to be your residential valuation appeals. So 3,500, the previous high total that we had in small claims appeals was about 3,000 in year 2020, fiscal year 2020. So we're seeing near, I don't want to say all-time highs going back to the beginning of time, but at least since back to 2019, which is when my tracking sort of starts, we're seeing highs in both regular division and small claims division in terms of number of filings. All right, and then just to give you a perspective, the low value of, or the low number of filings we had was in fiscal year 2022, we had 6,300 about aggregate between the two divisions. So this year we're sitting at 8,390. I want to give you some overview of what a case goes through when it comes into our office, because we can talk about numbers of cases that are filed and how long it takes to get those processed, but it's hard to understand if you don't live that on a daily basis like we do. So I brought this chart with me, and I think you might all have a copy of it. Now, I don't want to get into the weeds on this chart because the purpose that this chart was prepared for was as part of our content management system project. So you'll hear me talk in a minute about our technology that we are trying to implement in the board to help streamline these processes. This was something we went through and tried to document every step that an appeal goes through from the moment a piece of paper or an email hits our office until the time that it leaves. This is one subset of that. This sheet that I have in front of you represents maybe the most basic level of processing from the time that we receive a piece of paper or an appeal to the time that it leaves the office, assuming that it's not set for hearing, it doesn't have any discovery, nothing unusual happens, it's not dismissed for lack of jurisdiction, there's no reconsideration, just this is kind of bottom line. It goes through this many different processes. And this was meant to help the people who are building the software and coding this system out to try to set that up for us. Now, my staff has told me that it takes about 5 hours of staff time to process a basic, single-family, uncomplicated residential appeal. Not to say that they're all uncomplicated, but base level, we're talking 5 hours of staff time to get through one case. Now, if you look at the 2,600 cases that we had, the 2,600 just equalization appeals that we had in the past year, that would equate to 13,000 staff hours required to process those cases, or 325 40-hour work weeks. So if you translate that into the administrative staff that we have 7 administrative staff to support the board's operations. One of those is a receptionist type position who is not actively involved in case management type processes, and one of those is a finance position who has many responsibilities over budget and bill payment and those sorts of things, who can't devote full time to case management. So given the remainder and allowing for vacation and sick time and holidays, I've assumed we have about 245 work weeks that our staff can put in any given year. So at current levels of case load, we have a deficit of 80 work weeks a year. And that's to process one type of appeal that we have jurisdiction over in one of our divisions. If you read through the more extensive documentation, I have numbers in there. If you assume that we can reduce our current processing speed by half, so even if you assume we're a little bit inefficient, which I will grant you there are always things we can be doing to be more efficient, and even if technology helps with that, reducing our processing speed by half would be aggressive. And I don't know if that's possible, but assuming that we could, we are still running on 130 work weeks to process one type of appeal with 245 available on current level of staff. So we are still, even if we could do more with less people, we're still, I think, short of the staff that we need to really get cases processed in the speed that everybody would like to see them processed, including us. So the point that I really want to drive home here is that, we are investing in technology, which I'll give you more detail on in a minute, but I think technology is only going to get us so far. There has to be an investment in personnel too, and a lot of what the board does still relies on human intuition, human judgment, and good, qualified, dedicated employees who are there to do that work. But moving to the technology, and again, I don't want to get into the weeds with these things, but we are implementing a new content management system. Those of you who've heard me testify on the budget for several years know that I have been working on this since about 2021 when I came to the board. It was a couple-year process to get the grant funding to do this system. It was another several months process to find a vendor to do the system, and then it was another 9 months beyond that to kind of get through the procurement process to the point where we could get the project kicked off. We have kicked off the project. We now think it's about 9 months until that system is installed. Probably another several months to a year beyond that before everybody is sufficiently trained and we've really figured out how to use that system to the best advantage. What it's replacing is a defunct system. So if you think of our case management system that we use, it's called LawBase. We're not the only agency in Kansas that uses it. It is a very souped up database. helps us keep track of everything that's filed, deadlines, parties who are involved. The content management system keeps track of all the documents that are associated with all of those cases. So any of the appeal documents, any notices that are exchanged, any communications that we get from the taxpayers, any orders that we issue, any evidence that we take and hold, the record that would be provided to the Court of Appeals, all of those documents are maintained and organized in that content management system. We have been operating without anything like that for 2 years now because our old technology was installed in 2008. The vendor on that technology went out of business, and it has taken us this long to get something new in place. We have been doing many workarounds, but part of the inefficiency is that none of the workarounds substitute for this kind of custom, semi-custom built system that we are going to have. So that is one thing that we're working on. We have redesigned our website. I'm expecting that to go live in 30 to 45 days. That really has nothing to do with our ability to process cases, but it is very much a user value initiative on our behalf, is that we want people to have a better experience using our website and to be able to get better information there. We also have been working to upgrade or replace our IT infrastructure where necessary. Again, most of that infrastructure was put into place back in 2008 and hadn't been substantially updated since then at the time that I came to the board in 2001. So we're working through that. Again, some of the issues there are not so much case management operational issues, but they are security concerns. And it is a concern when nothing is working in our office, we can't do our jobs without technology, unfortunately. I do want to point out that in our fall 2024 3-year IT plan, we had 15 strategic objectives that we'd hope to accomplish by the end of this year, this calendar year. We're on track to do 14 of those. So I think that we've done very well with our IT. The remainder is one that we are waiting on OITS to hopefully provide us with a product, because buying a standalone is cost prohibitive. Now, along with the technology, there are things that we are doing within our own internal staff to try to improve our case management processes, to increase that processing speed, to make the experience a little bit better for everybody. One of the key reasons that cases tend to languish or linger on our dockets are continuances. Now, some of those are unavoidable. Continuances happen for a lot of reasons. A party decides at the last minute they need to hire a lawyer. That lawyer's not prepared on a week notice to take the case to hearing. A party decides they need to get an appraisal at the last minute. The parties haven't had a chance to discuss settlement. The attorneys or the tax representatives or the parties have conflicts. There's an illness, an emergency. There are all sorts of reasons why continuances happen. But there are some reasons that I think we can do a better job of controlling. And one of the things that we want to do is give our staff attorneys more time to engage in active management of cases on the docket, so that we can identify those where maybe the parties need a little nudge to put some time into working the case. Maybe the case looks like it's going to settle and it doesn't need a hearing set necessarily. Maybe we need to be more actively involved in that case. Maybe we need to be setting deadlines, giving them some scheduling orders. Maybe that case would be amenable to mediation. There are all sorts of different things we can learn, but we need to give our staff attorneys the time and space they need to work those cases, which is going to require us pulling them away from other duties we currently have them doing, such as hearing small claims cases. Our attorneys in the summer, and one of them is with us today and could tell you, they spend a significant portion of their time, if not all their time, in the summer months handling those small claim cases, because those have a very tight statutory deadline to turn around. Our entire office's process basically gets shifted to small claims between about May and the end of October every year, and that time period keeps growing. As you see, we keep getting more and more small claims cases every year. We are actively working to get more hearing officers so that we can free up our attorney time to do more case management, but we're also going to ask you in a minute to give us a legal assistant position. That legal assistant is going to free up some of the clerical time that our staff attorneys spend because our administrative staff can't do everything for them, to give them more time to do the things that attorneys are uniquely positioned to do. We're developing a new case management survey. This would be something that we send to parties early on in the process, and we ask them to give us information about their case. It's going to force the parties to sit down and really think through some different aspects of their case. It's going to give us some information that will tell us, does this look like it's likely to settle? If we do something, is that going to push them toward resolving this faster? Does it look like there's no way this is going to get resolved faster, it needs a hearing? How many days does that need to be set for hearing? Lots of information we can get there. Again, we need our staff attorney time freed up to help process the results of this survey. That's another area where a legal assistant could make a lot of difference for us in helping. It doesn't do us any good to send a survey and get the results if we don't have someone to sit down and work the results and figure out how to invest our time. We want to research the potential of a mediation program in the board. Part of the question that we're going to ask our bench bar committee to answer for us is, would parties be interested in some kind of mediation process? If that's something that would be helpful, we likely need some kind of change to our governing statutes, because I'm not sure that we have the authority to do it now. But we could certainly come up with a proposal to you all on how the statutes need to be amended to allow for that. And finally, I get to the bench bar committee. Mr. DeFries is going to come up and speak to you here in a minute, but the board historically has had a bench bar committee comprised of practitioners from all different sectors, from private practice to government to taxing entities. And they have many years of experience, and we have asked for input, and we take that input on questions like, would you use mediation? How do you envision that working? Would this case management survey be useful to you? Would you actually respond to this survey if we sent it? If the answer is no, nobody's interested in mediation, it does us no good to spend our time creating that program. So we need answers from the people who are actually going to participate in those things. So to give you some idea of where we're at on staffing, we have 16 FTEs right now. 4 of those, like I've said, are board level positions. One of those is our executive director, who I should have introduced my cohort, but our executive director, Jonathan Roberts, is with me. We have an IT manager. We have 3 legal positions, 1 general counsel, 1 senior staff attorney, who is Erin Hatton. She's with us today. And 1 brand new attorney, Mr. Daniel Bruzina, also with us today. It's his first time here in the building, by the way. So if you have any suggestions on what he needs to see other than the John Brown mural, let him know. We have a finance manager. We have a few general administrative positions, 1 small claims scheduler, 2 docketing positions, a mail desk / records assistant, and a receptionist. So we run on a pretty lean staff. I want to point your attention to some vacancies and retirements we've had over the past 18 months. The key here is that we turned over 25% of our staff in an 18-month period. So we had a staff attorney retire in June of 2024. That individual had more than 33 years of experience. Our executive director retired in December of 24. She had over 15 years of experience, possibly more with the board. Our finance assistant was on medical leave from September 24 to June 25 and then retired in June of 2025. She was with the board for more than 20 years. That position was filled by an internal applicant. We had another administrative assistant who had many years of experience retire in July of 2025. That position was filled internally. So as of about 2 weeks ago, we had 2 empty positions given those retirements and the internal promotions. We have just since hired individuals to fill those positions, which means we will be fully staffed for the first significant period of time since I have been chair of the board. And if there was any point in time in the past 4.5 years where we were fully staffed, it was a brief and fleeting moment in time. We have never been operating with a full staff in the past several years. So the question that you're probably wanting to know, and which I want to give you some sense of, is how hard is it for us to operate with those 16 FTEs. Well, we had, 8,300 filings in the last fiscal year. Each of those filings takes at least 8, if not 12, different administrative processes to get it from the entry to the exit of our office. So at a minimum, we had 67,000 different administrative processes that we had to go through on those cases. We have been doing that for the last 12 months or so, primarily with 3 FTEs on the administrative side and 1 part-time temp position. I expect that our caseload will continue to increase, just anecdotally, given the level of, frankly, dissatisfaction with property taxes right now, which I think is why you're all sitting here. I don't see those cases going down anytime in the near future. I could be wrong. But certainly without some level of staffing increase, we will continue to see delays in case processing. We will continue to see taxpayers and taxing entities be frustrated with the speed at which we can get cases out of our office. That is just the reality. It is not that we're inefficient. It's not that we're not trying. It's that we are maxed out at what we can do right now. And here is my purely anecdotal observation to you. And I am in no way making any sort of judgment about the Office of Administrative Hearings or what type of cases they involve or whether the workload to resolve those is similar. But I went and looked, and the Office of Administrative Hearings, just as an example of another administrative hearings board, they had 2,500 cases in fiscal year 2024. They had 12 FTEs and 4 part-time board members at the same time. So that's around 208 cases per full-time employee. We had 8,300 cases last year with 16 FTEs. That's 519 cases per full-time employee. Again, purely anecdotal observation. You can do with that what you will. I'm going to wrap up with some things you're going to see in our budget requests this year. We are asking for additional positions, for additional administrative positions for the first time in a long period of time. We did get an additional IT position a few years ago, and we thank you all for that. We needed a new administrative assistant. We need someone who's available to step in when we do have vacancies for illness, vacation, that kind of thing. That individual would be cross-trained and be able to step in any area of the process. We need a legal assistant who can take some pressure off of our staff attorneys and allow them to do the things that are best suited to attorney time. And then my last suggestion to all of you, and this is something that Senator Tyson knows a little bit about, is a taxpayer advocate. It's become apparent to me over the last several years that self-represented taxpayers are at a disadvantage when they go to navigate this system. For various reasons, the board members, its staff attorneys, its staff cannot give individuals legal advice. We can give very basic advice on navigating the process, but when it comes to questions like, is it even worth appealing this? Is the board going to grant my relief? Which is a question we get asked fairly often, and our staff cannot answer that question. You don't want them to answer that question. I think we need some kind of taxpayer assistance. We have proposed a position in our budget to give you some idea of what that would look like if that position was in our office. I'm not saying that that's the best way to establish some kind of taxpayer assistance. It's an alternative. An alternative would be to establish a clinic at one or both of the law schools, to have law students who are in their second or third year represent individual taxpayers. There could be avenues of locating that position in another government agency. There are probably lots of ways to do that. I'm giving you a depiction of one alternative in the materials I've provided, and I think that that would be something that needs a lot more conversation between a lot more people before any decision is made there. But I do think that would be a great benefit to the taxpayers who are making advantage of this tax appeal process. And with that, I would stand for questions.
Thank you. Representative Sawyer.
That is so funny that you all just looked at me instinctively. I really appreciate you for being here and really strongly support the addition of a taxpayer advocate. My question is this: can you tell us what area, or at least which county, most of the residential tax appeals come from?
Residential, not specifically. I can tell you what county most of the appeals in general come from, and it's Johnson County.
Shocking. Yeah.
In the past, I've had specific numbers on that. I didn't pull them for today, but historically, Johnson County is the highest. Quite frankly, Wyandotte County may be creeping up this year. I'm not sure, but usually it's Johnson, Wyandotte, Sedgwick, Shawnee are our top 4, which is, you know, that you would expect the most populous counties to have.
And I realize that asking for a taxpayer advocate is a relatively new thing. Do you think that one would be enough? I only see an increase in these sorts of appeals going up as we have, you know, changes, especially, you know, with valuations and all of that. So I realize that you're kind of lowballing the initial offer, but how much time would that hypothetical taxpayer advocate be consumed with?
That's an answer I don't know. We have had that discussion internally where we have said, is one enough? I don't know that it is, honestly, but this is the sort of position that it's so new. The idea of this is so new either to BOTA. I think that, you know, revenue may have some kind of taxpayer advocate in their office. I don't know how that position works, to be perfectly honest with you. This idea is so new to BOTA, I don't know how it would work, quite honestly. It's one of those things that if we go full throttle and try it, I suspect you need to try it, and you may try it and figure out one way doesn't work. Or you may try it and figure out this poor person that we've hired for this job is so overwhelmed that they can't, you know, they can't make headway either because there are 5,000 people who want help and there's one assistant. It's one of those things that I think requires some. If you decide to go the route of having a person in our office, we're more than happy to try it. It requires some willingness to allow, you know, experimentation and failure and try again before we decide, you know, whether it's a viable option.
Are you able to have partnerships with some of the local entities, in particular, say, the more populous counties where more of these appeals are coming from? And are these partnerships able to help you all save money? Can you collaborate? What does that collaboration look like, if it indeed exists?
We do. I think my staff particularly work with the different taxing entities on filing processes. We've had a number of conversations with Johnson County in the past year. They've turned over the counsel who was responsible for all of the tax appeals that are coming to BOTA. They've had their appraiser has turned over. We've had some conversations with them about things that we could do that would benefit both sides in terms of, you know, filing procedures and that sort of thing. We do try to be mindful and careful not to step into the realm of something that is legal advice and just to keep it very much on the process side. But we do work with the entities like that. We work with Department of Revenue and with property valuation. We share information with them in terms of the underlying data that we need to make our database run smoothly when we're inputting things. You know, we've exchanged that, and we've had good conversations with their IT department about piggybacking on their new I don't know where Bob Kent went with their new their very impressive new system, their website, which I can't remember the name of to save my life, but we have talked about how we might utilize that. So we do try to do some sharing.
So, and if I may, the committee may not be aware, the person that was attributing to the bottleneck, if there was a 5% discrepancy in the evaluation, they were forcing it to BOTA, and that's part of what caused, I mean, 5% such a minimal difference, and instead of trying to negotiate it, they were sending it to BOTA, and that's created a lot of this bottleneck. But also, Chairman Wheeler, you had talked about going to the universities, and I'm hoping that that can happen too. That might be an option also. Representative Turner.
Thank you. Yes, thank you for being here today. My question, I heard you say you're 57% funded by SGF. Is the remainder fee funded?
Yes.
And you also mentioned that small claims have a statutory timeline that causes you to deal with those? Apparently, there is no similar constraint on equalization in other cases.
In regular division, there is no similar constraint in terms of the time that they have to be set for hearing and the time that they have to be set for hearing. So what compresses this small claims process is that once a case is filed and received in our office, that matter has to be, excuse me, set for hearing within 60 days. It has to be heard within 30 days. The decision has to be issued within 30 days. So that's a very short time frame to resolve all of those. The regular division doesn't have that kind of constraint on setting cases for hearing. And I'm not sure that it would work because regular division cases run the gamut from a small residential valuation that may not need a lot of discovery process to very complicated, highly complex commercial valuations where the parties want to depose experts and they're each going to have different appraisal experts and they may have multiple witnesses. And those are set out further by design to allow the parties time to do that discovery and go through that process. Sometimes there are summary judgment motions, sometimes there are discovery disputes, and it's very hard for us to determine, even looking at something on its face, whether it's going to settle immediately or whether it is going to turn into a very protracted dispute. And Mr. DeFries might be able to talk to some of that too as he handles some of the more complex cases. I would suspect that's why there historically hasn't been a specific deadline on regular division must be heard within X many days. But we do have constraints on once we hear that case, we render a summary decision within 14 days unless the parties waive the deadline. And we render a full and complete opinion once it's requested within 90 days, again, unless the parties waive the deadline, which they do sometimes because certain cases, the complexity of them doesn't lend itself to us being able to make a decision within 14 days. Sometimes they want a transcript and they want to submit briefs to us before we make that decision. Frankly, that process can take a year in and of itself, getting a transcript and getting the briefs submitted. So it's just a little bit different beast.
Well, thank you. Yeah, if I may, Chairman. You know, there's one aspect that I didn't hear. You mentioned that people were frustrated with the speed of these hearings, but they also create a financial hardship. For example, I have a constituent that owns a storage facility in Labette, and I don't know what the eventual, I know it was well over a year, and the valuation had been raised 300%. So they were paying and almost in jeopardy of losing their business. Because these things just kept coming and kept coming. So they were having to pay at the higher valuation, even though the eventual case was heard and decided all that was incorrect and you'll get refunds. But, you know, that waiting period is very difficult, you know, for folks to pay at a higher valuation level. So there's a real consequence. And I didn't hear in your recommendations anything specific to constraint or relief on that side.
I am completely sympathetic, and I also hear those concerns from people. It's a hardship both on those individuals, and we hear it on the side of the taxing entities, that it's a hardship for them sometimes that we don't get exemptions decided quickly enough, and then they may be having to issue refunds that they didn't necessarily budget for sometime down the road. We are not necessarily happy with delays in processing either. It is the reality that we're struggling with on a daily basis. And I don't know, in terms of specific relief in those instances, I think it would be within the legislature's power or prerogative to enact some kind of, you know, a relief in terms of a stay and taxes being due, perhaps, if an appeal has been filed. There could be different solutions to that problem. Nothing within our jurisdiction that as it currently exists in statute, we don't really have any ability to alleviate those concerns other than just to try to get through cases quicker so that we're not having things sit on the docket for a year or more. But, you know, it is a problem in the sense that we see quite frequently commercial cases where, you know, a 2024 tax year appeal has been filed and then for whatever reason, and there could be 100 different reasons, it hasn't been heard by the time the 2025 appeal is filed. And then we have a case where the 24 and 25 appeal get sandwiched together and passed along to us. We've had cases go to hearing where we've had appeals back to 2018 or 2019, all the way up through 2025, where they continue to just be stacked and stacked and stacked and stacked. We don't particularly prefer that either. It's really hard for anybody to go back and remember what in the world was happening in 2019, especially after 2020 happened, right? So I understand the concern. I am with you that I'm a bit stymied, I guess, and need to sit down with other smart people and figure out what the solution would be.
All right, I've exhausted my questions, but thank you, Mr. Chair, or Madam.
We can come back to you if you want. So Representative Francis.
And I hope the chair will indulge me a little bit. I have the same problem, only on the opposite side. I represent Seward County, and, they're currently at district court on some claims from 2018 to 2020. I know the chairman was out and heard some of those concerns also. So do you think the definition for the business machinery and equipment exemption is clear and appropriate? Do you have any thoughts on that? I think that creates some of the issues in my district on the large appeals.
So may I interject
Sure.
here on this? Representative, that is a critical question. Would you mind if we scheduled that for the October 13th meeting and delve into it? But go ahead and ask your question. But I just don't know that we have that purview right now, that information.
And I'm just scared may have a conflict that day, but I guess I can watch online.
No, we need you.
I would
That's
love your
critical.
thoughts at some point on the appropriateness and clarity of that exemption, if you don't mind. And I would also love your thoughts about what we do when we don't make the deadline, because that's another one of their concerns. And what do you do on the deadline for the small claims? I mean, and I'm sorry if I'm stepping on you.
This is perfect, Representative. And would you briefly explain to the committee what went on with the plant out there, what you're talking about, so that they understand the valuation? We have an issue with our valuation process. Not pointing fingers at anyone. Every process can be improved, and that's what we're looking at trying to do here. So would you explain that situation?
Yeah, we've dealt with this over a number of years. We had a helium plant that they're large industrial processes. Currently, we're dealing with it on an ethanol plant where the county appraiser comes back and they come up with one value, and then, that definition of what is business machinery and equipment seems to be in contest. And I guess that's the easiest way to put it. And currently, our county is trying to deal with the fact that they won in Boda, or I shouldn't say they won. There was a settlement in Boda for 18 through 20. Now it's been appealed to the district court. There's still no settlement. They're paying interest. Everybody's kind of at a loss on it. So did I kind of say it correctly?
Very well explained. And one of the possible solutions could be to bring the ethanol plants under valuation at the state level, like we do the utility companies. But I think, if you want to respond, I think we'll definitely save the details of those, maybe the November, whichever meeting you can be at, or maybe we.
And I always have to prioritize, so I may.
Okay. Okay.
So a couple of things to your point, Representative Francis. One, I think that question, you may have more than one entity that has some stake in answering that question. We certainly have the jurisdiction and authority that we have, but PVD also has some authority over issuing its directives and guidelines over valuing certain types of properties, and if there is a specific guideline as to business and industrial machinery and equipment, that might be something that they would want to weigh in on as well, as far as clarity in the definition of that and how different counties are interpreting it. I am a little hesitant to give you my personal opinion on it, because our board is subject to the judicial canons, which specifically prohibit us from giving an opinion as to how we may rule, or that telegraphs how we may rule in any given case. So to the extent that that question were ever to be in front of us, I am a little hesitant to give you my personal opinion, because I feel like that may be giving you a sense of how we would rule. I'm also not entirely prepared to give you my personal opinion on that today because I just came in here with a different focus. But I would suggest that that question be discussed with perhaps myself or another representative from BOTA and with PVD and with other interested parties. And the third thing I'll mention is that this does happen when we get a case like that has been decided or settled at BOTA for some reason and it's appealed to the district court. A lot of times what will happen is that subsequent tax years are also appealed and those come to our office, but they're generally stayed, either because the parties requested or because we do it, because we know the district court or the Court of Appeals, as it may be, is going to issue a ruling on that case at some point in the future. And we don't want to issue a ruling in the interim that conflicts with that opinion that is going to come from a superior court. And so that is a further delay of that process. Once that leaves our office, we don't have any control over how long the district court or Court of Appeals takes to resolve a case either. But that does happen a lot of times in these larger, more complex cases, which results in further tax year appeals kind of sitting on the BOTA docket for a long time until something else is resolved.
So just real quickly, what happens if you don't make your deadline on the small claims? What happens?
The statutory remedy for us missing a deadline is that if a filing fee was paid to file a case, the fee is refunded. Small claims residential appeals don't pay a filing fee, so there's nothing to refund in those cases, but that is the remedy if we miss a deadline.
So basically, if you get behind, they still have to wait. There's no they don't take one value or the other.
No, there's no, the case still has to be heard, the value still has to be set by us.
And I promise this is my last question. Is there any percentage, do you have any percentage or data on the number of your rulings that are changed once they reach the district court and appellate level? Is there any data on that?
I don't have any data on that in front of me. I could potentially find it for you, at least as to the percentage that come back from the Court of Appeals. It's very hard for us to track what happens with cases once they get to the district court, because once they go to that process, we are no longer a party and we don't get notifications of what happens with those. So unless the parties tell us, or unless we were to go to every individual case that we know of and go on the website and pull the information ourselves, we don't always know what happens in those cases. So I'm not sure I could get that data for you with any level of reliability. That's actually something I would like to be able to track a little bit better, but I need to coordinate more with the IT folks in the Kansas court system to see if there was a way that we could tap into the back-end IT systems and do something like that.
Thank you for your indulgence, Madam Chair.
You're welcome. Representative Smith.
Thank you, Madam Chair, and thank you for your presentation. Excellent information. I was scribbling all kinds of notes. In the interest of time, I won't ask all of my questions, but I wanted to just kind of segue off of Representative Francis's question. In the first few tables, we've got the case filings. Do you have the data on what the result of those filings? How many of those are ruled in favor of the applicant, the taxpayer? How many of those are rejected? How many are settled? If you had that information, that would be interesting for me to know, and hopefully for the committee. When you were going through that, that was my initial thought. Is there some way, if there's a lot of these that are either settled, and you also addressed that in talking about your new case management processes, if there's a process or something we can put in there to maybe short circuit some of those that may have an opportunity for a settlement, those cases don't have to go all the way through the process. Do you have access to that data?
We do. That's actually data that we put in our performance-based budget measures, which they're mostly finalized on Monday. The Division of Budget has requested some changes or updates to those that I didn't quite get put in. I can provide that to you. I didn't bring it with me today.
Okay. Madam Chair, I've just got another, maybe two other questions, but they'll be short ones. Regarding your software issue, it sounds like you've got a plan in place to kind of hopefully make that more efficient. It was a little concerning to me. What happened there? We know you said something about the vendor that had the software went out of business. You're kind of making things work right now, but it seems like maybe a ball got dropped there. Could you go into a little more detail on what happened with that?
Yeah, it was a perfect storm of bad things happening, I think. The vendor, the system was slated for replacement prior to my coming onto the board with a different vendor, and frankly, I couldn't tell you what the process had been to find that other vendor. That was scheduled to happen right before COVID. So COVID happened and threw everything into whack. Once COVID was sort of resolved, we were working with OITS on whether the board was going to migrate its operations into OITS or stay separate. And there was a lot of back and forth as far as whether the conversion of that specific system needed to happen before we were subsumed into OITS or after. And somewhere during the time of that back and forth and trying to figure out how that was going to work, the new vendor who was going to replace the old system was purchased. So that company was purchased by a new company who refused to honor any of the contracts that existed. So our alternative, we could have gone with the product, the new product that they have, but it would have been twice as expensive. And it kind of threw us back into, that's no longer really an option. So while we were then trying to figure out what kind of other system do we get, because we don't really want the one that they're offering now, the system that we had that had been limping along went, in layman's terms, kaput. And like I said, it was just sort of the perfect storm of unforeseen things happening.
Well, it certainly sounds like you did the best you could with the resources that you had. My final question, Madam Chair, I love the idea of a taxpayer advocate. I don't know how much you've kind of brainstormed that or worked through it, but it seems to me like if that office was within your organization, that could appear to a taxpayer as a conflict of interest. So I didn't know if I know we do have some folks at Department of Revenue that have kind of that purview, but just curious if you've had any discussions on where you think that would fit the best.
That is one of my major concerns with locating it in our office, is that there is an appearance of bias. Also, the practicality of how we would screen that person from knowing any of what is going on in the rest of the office, or from any of us knowing what that person is doing. That's a concern of mine, and a reason why I would tell you I don't think having that person in our office is the best idea. But if that was the way that it needed to go for efficiency's sake, sure, we'll do it. But yeah, I do have that concern. I also have concerns over whether that person should be a lawyer or not be a lawyer, and you know, what difference does there's good things and bad things on both sides of that. So I agree with you that I think a lot of taxpayers would be concerned that they're maybe not getting the best advice, or that it's biased advice, something like that.
Okay. Thank you. Thank you, Madam Chair.
Okay. Any other questions, committee? I have a couple, and one of them is on your fee. Could you give us the breakdown? Could you send Eddie so he can so that we know what those are?
Yes, there's 35 different fees, so I will send you the list.
No, that would,
yes.
because there's some application fees also for tax exemption, that
Yes.
type of stuff. Yeah, we'd like to get I'd like to get my head around all of that. Also, you have hired some contractors for the small claims, and that's helped. I mean, you're doing as much as you possibly can with the resources you have, and it's
Yes.
very much appreciated.
Yes, we did, and I didn't mention, we have hired a part-time temporary attorney to try to alleviate the backlog on exemption cases. That individual, I think, doesn't necessarily want to be doing that long-term, but we have tried to do that. So yes, 100%, we're doing the best we can with what resources we have.
No, I appreciate it. And this is not necessarily a question for you. It may be research, revisers, or Department of Revenue. Could you put together a flow chart for the property tax appeals process? And this is very extensive because it would have all of the fees, all of the options of if you go this route or the other route. The reason this comes to mind is listening to the questions. I had a family member ask me the process, and I'm like, I'm not an expert in the process. So I think this would be helpful and maybe something that we could actually post online for taxpayers at some point. So it's probably not a BOTA task, but we'll
Certainly something we could be involved with other
definitely
people in
involved.
creating.
Absolutely. Any other questions, committee? Seeing none, thank you for your time.
Thank you very much.
Yes. Committee will welcome Lucky DeFries.
Well, it's good to be with all of you here. I am Lucky DeFries. I'm a partner with the Morris Lang Law Firm, their Topeka office here. Main office is in Wichita. We've got one in Augusta and one in West Palm Beach, Florida, too. I think I've been contacted. I guess somebody thought maybe I could offer some perspective with respect to what goes on at the Board of Tax Appeals. When I first got out of law school, I started with the Department of Revenue, and I was informed within 10 days that I was going to have a case at the Board of Tax Appeals, and I had to do some quick checking to figure out exactly what was going on at the Board of Tax Appeals. It all turned out well, and I've been practicing there for 46 years since that time. I think I kind of view myself really as kind of a resource for all of you folks. I guess having been involved for that long, I think I've seen and observed just about everything. You do have a good internal resource here too. Amelia and I have known each other for just a few years, and since her days both with the Board of Tax Appeals and with PVD. But I think I've overseen the transition from the board to the court back to the board again. I think the chair did an excellent job of identifying kind of where they are right now and some of the things that she is wanting to implement, and I would concur with really with all of those. I think probably most people would agree that technology is probably the single most important factor in agencies such as this. They're critical. For those that know me, technology is not my forte, but I fully appreciate all the benefits that it can bring. And so I think the types of things that they're looking to do at this point will help. But having said that, I think you've already gotten a good sense of the manpower issues. And I think manpower is a close second to technology. I can remember times when the board head count was in excess of 60. I can remember some specific times when I had conversations with the then chair when they were at 58. One of my current partners was a former chief hearing officer, general counsel, and then he was a judge on the courts. And during his tenure there, they oversaw a significant technology upgrade. They brought in a consultant. They got a grant. And in the aftermath of that, over a period of years, they were able to work their head count down to, through attrition and other things, they didn't have to have any, mass terminations or anything like that. But they got down to around 30 to 35, approximately. Well, as you've heard, over a period of years now, the board has ended up down to 16. And at any given time, with retirements, with medical issues, departures or whatever, they've been at 13 or 14. That simply is not enough for what you've heard described. I can't sit here and tell you exactly what the magic number is. I know there's a request for some additional positions, but I would suggest that certainly someplace between 20 to 25. And then in addition, I guess when it comes to the manpower issues, over the years, the board had 5 or 6 attorneys. As you've heard now, they've got 3, and they had, one of the vacancies for over a year. So during that time period, they only had 2 attorneys there. Those attorneys are extremely important in terms of processing the cases, helping to write the opinions, and as you've heard, also they've been pulled into some of the small claims hearings. So they're wearing a lot of hats at this point, but I think they could definitely benefit from some additional attorneys. And then I would also suggest that it's very difficult, I think, for those of us in the state and local tax arena, you don't find people that have much expertise in that area roaming around the state here. It's very difficult. So it's not likely you're going to find attorneys with a lot of experience. But the board has historically had 2, at least 1 and 2 law clerks. And many of those law clerks have gone on to very distinguished careers. I think some of them have ended up staying with the board over the years. And so that would be an excellent opportunity. Those law clerks can handle a variety of different things. It also gives you kind of that internal training ground. And the hope is, in many agencies, that some of those people might be willing to stay on to one of the attorney slots. And so if one of your attorneys were to depart after 4 or 5 years, you'd already have somebody from within that's become familiar with the systems, that has some knowledge of the subject matter, that could then step into those kinds of positions. So I think between increasing that head count, adding, a few attorneys, and having some law clerks that could assist with a variety of different things. I think we've heard some talk about a lot of your constituents are calling the Board of Tax Appeals all the time. They've got concerns about their property tax issues. I get calls from people all the time, primarily about residential issues, and they really can't justify hiring me in most instances. But I can tell you that they appreciate when I take the time to walk them through and say, okay, I know that you're upset that your neighbor, their house is valued at $20,000 less than yours, and theirs is nicer than yours. But when you walk them through and you explain what the implications are from an actual tax standpoint, they realize that there's probably a limit as to how much they're going to be able to do. I've sat in the reception area at the board many a time when I'm listened to the receptionist patiently walk through somebody and explain it. And I think even if they don't like what the situation is, they appreciate having somebody that will respond to them and walk them through. And I think it's important for the board to have people available to answer those kinds of questions. So I would certainly concur that time assistance would be very, very helpful. I'm not going to spend a lot of time. I think you've heard some of the initiatives that the chair talked about. The taxpayer advocate, I think, is an excellent idea. It is a little tricky. The Department of Revenue does really have somebody that they're within the department, but they do an extraordinary job. It's somebody I've known for 40 years. And I can't tell you the number of times that myself or other individuals, friends of mine from around the country, when they call me and say, Lucky, I need to check on something, he is able to, he knows the answers, or he can get to the answers, and he wants to get to the right answer without encountering any unnecessary hurdles for somebody to overcome. So I think it's probably possible to come up with something. You do have to be careful about the appearances, and how far they can go. But I think there's some things that could be done. I think that the chair also talked about mediation. I think that's something that is certainly worth looking at. It takes both sides to be willing to implement something like that. I've had many cases over the years where I've thought it would be helpful. Sometimes the other side's not interested. I have utilized that, and it can be successful. I think you heard some discussion about the real versus personal situation. In full disclosure, I represented the taxpayer on the helium plant out there. We were able to reach an agreement on that, and I think that's been helpful. I think that is an interesting topic, one I've spent I think, as Mr. Kent can confirm, I've spent a lot of time talking to PVD with himself and some of his predecessors, talking about that issue. The good news is that there really are not very many cases still pending. There are a few out there. It's primarily been the ethanol cases. I think the only two that I'm aware of right now that are being litigated are the one that you referenced, and one other that I think is still pending that's been around for a long time. But I think we do have more clarity with respect to that statute. I worked when we tweaked the statute a little bit. There's still some areas that are difficult to get your arms around there, but it's at least a lot better than it was before. I think I would also suggest that I think there's a role for agreed orders. I have been utilizing those to the extent I could for years now. If there's something that the other side is willing to agree on, I talk to them and say, look, the board will be eternally grateful if we can come up with an agreed order on this, especially on exemption cases. I've used that with regularity. I won't name the county, but I called up a good friend of mine years ago. I was helping a major not-for-profit on a little pro bono matter and kind of a high-profile situation, major county, and I said, what about an agreed order on this? I said, it doesn't appear that the county has any objection. And the individual said, that's the first time anybody's ever asked us about that. And I was kind of flabbergasted, really, that, that there had never been any discussion about that. I use those all the time. I think, and if counties could be encouraged to do that, I think sometimes counties tend to just say, look, rather than make a decision ourselves, we'd rather just toss it to the board and let them make the decision. If everybody is really not in disagreement, it seems unfortunate to force the board to expend their time and effort, when it really could be resolved. And so I think that would assist. I think there were some questions somebody, asked, beyond kind of what's in the board's control. Clearly the counties, I think, have a role in this. I think there's some improvements. I think it's been discussed. There are only, 3 or 4 counties account for 90, probably 5% of the appeals in the state. I won't break it down more, but I think you can all figure out kind of where the big numbers are. So I think the discussions that we're talking about, need to be had with those individuals. And I think, as you just heard, I think there have been some discussions that have been initiated, and I know myself and others, and I know the chair here has been, pursuing some discussions with respect to the property tax area. So I'm hopeful that, with some continued discussion, that there's some improvements that can be made at the county level, because if they can do some things to resolve some of these cases through their informal process at their level, that greatly minimizes the cases that matriculate up to the Board of Tax Appeals, and that helps solve some of the problems that we're talking about. We've talked about technology is important. We've talked about manpower. You need to have the bodies, but it's also important to have the right people. And let me tell you, I've observed a lot of what's gone on at the Board of Tax Appeals for 46 years. I think it was important when we created the different requirements. We've got both the geographical requirements, we've got the political consideration in terms of the parties being, there being some balance there. And then we also came up with the requirement that you had to have an attorney, an appraiser, a CPA, and then we have a different set of requirements for the hearing officer. But it's important to get the right people in those slots. And I can tell you that there have been times over the years where life has been a little bit more exciting than we would have liked at the board. There have been times when we had some extraordinarily nice people, well-intentioned people. They just didn't maybe have the kind of background and experience that you really need if you're going to effectively deal with what can be some very complex cases, complex property tax cases. I've handled many, many corporate income tax cases. Sales and use tax cases, those cases can be extremely complicated. We haven't had as many of those in recent years as the statistics, but there have been times when we've had a lot of those, and those take a lot of time and effort, staff time, briefing, discovery, whatever, and we may have another time when we have a lot of those. But you need to have the right people, and I can tell you that I hear all the county counselors are good friends of mine. The attorneys that practice in this area are good friends of mine. Over the years, they'll call, they'll talk to me. You'll hear chatter about, if there's discontent, problems. I've not been hearing any of that. I think not only do we have people that are in the appropriate slots, but we have people that had distinguished careers, prior to their tenure with the board. Some of them I knew very well. Others I knew by reputation, families, maybe the owner of one of the firms there that they had been with. They are people that aren't just attorneys, accountants, appraisers, whatever. They're people that had served with distinction with what they did. And I think that has accounted for the fact that I'm not hearing the kinds of things that I've heard in the past. And I think the consensus, if you were to poll the people that I talk to on a regular basis, whether you're talking with the county or the, the private bar, you'd hear that, I mean, there's always going to be people, somebody loses in a case, so somebody's not going to be happy in most instances. But I'm talking from a global, high-level perspective. I simply have not been, hearing the kinds of concerns that we perhaps have at different times over the years. And I think that speaks well of the people that some of you have confirmed over the years.
Appreciate it, Lucky. Thank you. I'm sorry, we are running a little bit
I
behind
knew that,
schedule.
so I was trying to kind of move
I saw
through
you go
and
through
pick
your
and choose
notes.
some
Thank you.
things. I would be happy if anybody has any questions, or I'm happy to talk to any of you, so feel free to reach out to me. I'd be delighted to talk to any of you if you have any questions about the board.
Wonderful. We may have you back for the machinery and equipment also.
Be happy to
That would be
speak
great.
to you on that.
Committee, any questions for Lucky? Seeing none, thank you, and thank you
Sure.
for understanding.
Sure,
Yeah.
absolutely.
Committee will turn our attention next to the overview on motor fuel taxes. Secretary Reed, thank you for coming. I have to compliment him. He's willing to take our calls almost any time of day. In fact, he almost got one another at 11 p.m. on Monday evening. I was trying to get on the interstate and it wasn't marked again. So I was so frustrated. I'm sorry, Mr. Secretary. I know you guys are trying really hard, but yeah.
Well, thank you, Madam Chair, and happy to take your calls any time of day.
And I know you have,
Anybody
but
on the
I thought
committee.
11 was too late. So, but you are so responsive. I just appreciate how hard you guys work. So thank you.
We appreciate that. So as we get started, first of all, I'd just like to thank you for the opportunity to speak here today. Thank you, Madam Chair, Vice Chair, members of the committee. We do appreciate the opportunity to discuss motor fuels tax. Looks like we're on the second slide already. We're good. Thank you. Looks like I'm in control. I'm going to get a little training on this first. I am not moving anything here, guys. Is that me? Lag? Okay. All right. Okay, we'll be good. All right, so I'm going to just provide an overview of motor fuels tax. We talk about this some in our transportation committees. It's my first opportunity to speak in front of this committee, so it's good to see all of you. I'm going to start by providing some background on motor fuels tax. Most of you are probably well aware of it, but just kind of refresh. Provide some data about some of the long-term trends we've seen in motor fuels tax. And I'm going to finish by talking about the Special City and County Highway Fund, which is something we don't talk a lot about. It is part of the KDOT budget, but it is often a part that we just overlook. So I'm going to talk a little bit about the details of the Special City and County Highway Fund. I also want to take a moment to recognize that I am up here speaking. I am not a subject matter expert on this. We've got some folks from KDOT and also some folks from the Department of Revenue here. If you have specific questions about the mechanisms or collections, I will probably defer to them. And Madam Chairman, if you're willing, I'll take questions at the end just to try to speed up the process. Okay, high-level overview. I'd like to just kind of set the stage by looking at how we fund transportation in Kansas. And when you look at this slide, you should note that motor fuels tax is really only a component of the revenues that are used to fund highway improvements across our state. You'll also notice the two pots that I've discussed, one, the Special City County Highway Fund, and one, the State Highway Fund. As I said, State Highway Fund is what we often discuss when we come to our budget hearings during legislative session, but the Special City County Highway Fund is out there also. I'll talk a little bit more about the Special City County Highway Fund and how motor fuels tax gets directed into it, but just real quick, high level, about 1/3 of motor fuels tax gets put into the Special City County Highway Fund to be distributed to the cities and counties all across Kansas. You'll also notice a red dashed line. This is new this year. House Bill 2122 was passed in 2025, which dictated a portion of registration fees from electric vehicles, plug-in hybrid electric vehicles and hybrid vehicles goes to the Special City and County Highway Fund. Like I said, that was new this year. Impacts will be seen in coming years. And then I also just want to note, we talk about how we fund transportation in Kansas. What this slide really indicates is how we fund state system transportation in Kansas. As a reminder, I like to remind people about this all the time. We have 138,000 public use roadway miles in the state of Kansas. Only 10,000 miles are maintained by the state of Kansas. The rest of them are maintained by our local jurisdictions. They have revenue sources outside of the Special City County Highway Fund that they use to help fund their transportation systems. I'm not going to talk a lot of detail about that because that's going to be specific to each jurisdiction. Statutory authority for motor fuels tax, really it starts with the Constitution. The Kansas Constitution authorizes a special tax to be levied on motor fuels. That was adopted in 1928. The Kansas Legislature has enacted statutes over time imposing an excise tax per gallon on all motor fuels, and that's defined as gasoline and gasohol that are used, sold, or delivered in the state. The use of special fuels, and that is defined primarily as diesel in any motor vehicle, and all liquefied petroleum gas fuel placed in fuel supply tanks or tanks on any motor vehicle. Collection of fees from interstate motor fuel users, and issuance of trip permits to interstate motor fuel users who are exempt from interstate motor fuel use reporting. A lot to say there. What does that mean? So this is something that I've actually learned a lot about. This is something that just happens in background. This is probably really something that the Department of Revenue can speak in more detail about, but just real high level about the interstate motor fuel user tax. It is a component that we don't discuss often, but Kansas, along with all lower 48 states, is a member of the International Fuel Tax Agreement, or IFTA. The purpose of IFTA is really to help simplify and standardize the reporting and payment of motor fuels tax when an operator is running in multiple jurisdictions. Like I said, it's really about standardizing and simplifying benefit on both sides, right? Benefit from the state side and also benefit from the motor carrier side. As part of this agreement, a motor carrier registers their vehicle in a single state. Every quarter, that motor carrier remits a motor fuels tax to the state of registration, and that tax paid is based on where the fuel was used, not where it was purchased. I think that's an important distinction. It is where the motor carrier is actually driving, not where they purchased the fuel. The state where the vehicle was registered then distributes the motor fuels tax to the other states based on that usage. And in lieu of the motor fuels tax, any interstate motor fuel user can obtain a single-use permit for either 24 hours or 72 hours in the state of Kansas. And then motor carriers operating in Kansas who are not registered with an IFTA member state must still remit interstate motor fuel tax directly to Kansas. A lot of details there about an important part of how we move freight across the state, which is IFTA. If we look at our current rates, gasoline, gasohol is set at 24 cents a gallon. That was set in 2003. And the same for diesel and other rates, they were all set in 2003. That was the last time that motor fuels tax rate was adjusted for the state of Kansas. The rate for E85 was set in 2006 by the legislature. To date, revenue has been minimal, from what I've been told, on E85. The trip permit fee that I just discussed is $13 for a 24-hour trip and $25 for a 72-hour trip. And the federal rates that you see at the bottom, we don't set those. Those are set by the federal government. They were set in 1993 for both gas and diesel. And when you look at Kansas relative to other states, we have the 16th lowest tax rate for gasoline in the country, 17th for diesel. And so for comparison, if you want to look at both ends of the spectrum, California is the highest at just under 60 cents per gallon. Alaska is the lowest at 9 cents per gallon. Those are state rates only. They do not include the federal tax rate. So that's a bit of a background on kind of the policies that govern motor fuels tax collection. Now I want to talk about some trends. So motor fuels tax is relatively straightforward to understand because at a high level, there are really two primary variables to track. One is the tax rate, which I just discussed. In Kansas, the tax rate has not changed since 2003. The other variable is really about how much fuel is being purchased, all right? And so that can really be broken down into two separate factors. One, how many miles are people driving? We call that vehicle miles traveled in KDOT language. As the amount of travel goes up, we would expect the demand for fuel to go up. And the other factor is fuel efficiency of the fleet of vehicles that are traveling on our highways. As fuel efficiency goes up, you would see an inverse relationship that the amount of tax collected would go down. These variables obviously are not entirely independent of each other, and they are also impacted by factors outside in the real world. But we can look at our past trends and kind of start extrapolating what the future might look like. So looking at motor fuels tax revenue, at a very high level, the revenues that we've seen from motor fuels tax going into both the combination of the special city county highway fund and the state highway fund. This is total motor fuels tax collections. We've seen about 12% growth in net revenue over the last 20 plus years, and that represents year over year about 0.5% of annual growth. Our collection last year was about $462 million. Collection in 2003 was about $412 million. Now, taking a step back and look at motor fuel usage. When looking at gallons sold for the two primary components of our motor fuels tax, so gasoline and diesel, there has been a pretty clear trend in gasoline usage that it has been flat. There's been little bumps up and down, but for the most part, zero growth in gasoline usage over the last 20 plus years. Gasoline usage last year was estimated at about 1.37 billion gallons compared to about 1.4 billion gallons in 2003. Diesel usage was about 520 million gallons last year compared to 360 million gallons in 2003. So there's essentially no growth in gasoline sales. Diesel sales have gone up nearly 20% over that same time period with an average annual growth of about 0.8% per year. So, as I said, two main factors. We'll look at vehicle miles traveled. As mentioned earlier, vehicle miles traveled on our roads is a main driver for fuel usage. This is KDOT data reported publicly. Over the last 20 years, we have seen an approximately 9% growth in vehicle miles traveled on our state highways and roads, which represents an approximately 0.4% year-over-year growth. In 2024, astounding to me, 32 billion miles of travel on our public roadways. However, as vehicle miles traveled have slowly and steadily increased, significant gains have been made in fuel efficiency. So data from the U.S. Department of Energy shows that from 2003 to 2023, the average fuel efficiency of a new light-duty vehicle increased over 37%. This is a 1.6% year-over-year increase. Just to be clear, this is the average fuel mileage for vehicles produced in that year. It does not represent the fuel mileage of the actual fleet that is driving on our roads. As we know, that is composed of many different years, model years of vehicles. The trend is clear, though, that fuel mileage is getting better. It is increasing. So as our fleet modernizes, we would expect the state fleet of vehicles to continue to get more efficient also. So just a summary of the components that feed into motor fuels tax collections. Motor fuel tax rate has been unchanged since 2003. Fuel usage has been steady with modest gains in diesel usage. There's been a modest gain in vehicle miles traveled, which has created a positive demand for fuel, while more significant gains in fuel efficiency have driven demand down. In summary, grand summary, over the last 20 plus years, we've collected about $9.2 billion in motor fuels tax for the state. In that same time period, we have traveled 642 billion miles on our public use roadways in the state. So just like, that's a hard number for us to wrap our heads around, right? Distance from Earth to the sun is 93 million miles. That's 3,500 trips back and forth to the sun in the last 20 years. It's a lot of miles. What that really means is our roadways are important, whether they're state highways, county roads. People need them, people use them for every day, for freight. Every person every day relies on this system. Now, I'm going to pivot because I've talked about the revenue side. I can't go further without talking about the cost side of the equation. The cost of doing business has outpaced the modest gains that we've seen in the motor fuels tax collections. So according to Federal Highway Administration data, this is national data, not specific to Kansas, average highway construction costs across the country are about 3.25 times more than they were in 2003. So I've overlaid our 3 transportation programs that have occurred or are occurring since 2003 onto this graph just to give you some perspective. In the comprehensive transportation program, which was in the 2000s, rapid inflation in the middle of CTP with some volatility around the Great Recession really dictated that those costs. During T-Works, what we saw was slow but steady increases, very predictable changes in costs over that time period. Ike has been anything but predictable. The first 5 years of Ike, you can see very clearly rapid inflation that we have been dealing with really from day one. We have started to see a slowing of that inflation, a steadying of costs. We have not seen a drop in costs, a steadying of costs. So if you put those 2 graphs together, and really this is just pictorial, right? I just want you to see that over time a gap has grown between what was once funded by the motor fuels tax and what is currently funded by the motor fuels tax. I had our staff go back and look at the budget from 2003 and the revenues that came in 2003. In 2003, motor fuels tax represented 37% of the revenue stream that funded highway improvement. In 2025, motor fuel tax represented about 22% of that state highway fund revenue. So we have filled the gap because the needs have not dropped. There's continued needs all across the state. You don't have to drive too far to see it, right? Drive around Topeka and you'll see the needs, you'll see what's going on. We have had to fill the gap somehow, and the way we have chosen to fill the gap in terms of the state highway fund is through things like sales tax. So as a reminder, going back to that initial slide, sales tax, a portion of the sales tax that comes into the state does get distributed to the state highway fund. Right now it's set at 18% of every sales tax dollar goes into the state highway fund to fund roadway improvements. So that is one way we have filled the gap. Another way is through federal fund reimbursements. Those have continued to go up. So those are how we are continuing to do business. But obviously, you can see the trend as time goes on. Motor fuels tax has continued to be, and really will continue to be, a smaller and smaller portion of how we fund transportation without major changes. So now I'm going to talk about Special City and County Highway Fund because this is really more about impacts at the local system. The distribution of motor fuel tax to the Special Highway Fund and Special City County Highway Fund are set in statute. We do not determine that. That has been determined by legislation, with about 1/3 of it going to the Special City County Highway Fund. From there, 43% is distributed to the cities and 57% to the counties. The distribution to individual cities and counties is based on those variables that are shown there. It's a pretty complex statute. Lots of variables in the statute. One thing that I would just like to point out is that it is part of our budget. The cities and counties, it gets passed through to the cities and counties. The Treasurer's Office is the one who is responsible for the distribution of those funds. So when we look at Special City County Highway Fund distributions over that time period, just as motor fuels tax revenue has been relatively stagnant, so has Special City County Highway Funds. So the distribution of funding to the state's 105 counties, 631 municipalities for fiscal year 25 was 148 million. I'm sorry, 155 million compared to 148 million in 2003. But I think it's important to look at this from the perspective of a specific jurisdiction. I took a little liberty here. I picked Lynn County. And looked at distributions to Lynn County. I don't know why, it just popped in my head as a good county to choose. So in the last 22 years, the amount Lynn County has received from motor fuels tax has gone up by about 5%. But in terms of real value, the motor fuel tax revenue in 2003 for Lynn County may have replaced 1 or 2 small bridges in that county. Based on today's prices, it will cover about half of the cost of a bridge replacement. So there are real impacts to the loss of this revenue. Now, just like the state has chosen ways to fill the gap, I think cities and counties have had to find ways to fill that gap. They have real needs for their operations and maintenance of their large systems. The needs have not lessened over the years, but the portion paid by motor fuel tax continues to decrease. Cities and counties are relying more and more on taxes like ad valorem and other fees to fill gap between motor fuels tax and their needs. Preliminary analysis of county roads. So I have been curious about this question for the past couple of years. How much of a county's budget for road and bridge is paid for out of motor fuels tax versus other fees? And what we have found, just really rough preliminary analysis and going through budgets, is that about 15 to 20% of road and bridge budget needs are filled with motor fuels tax. And on average, going to be different for each county, for each city, but on average, about 68% of revenues for county road and bridge are ad valorem. I think that's a significant part of the conversation. So I'm going to close with this slide just because I do want to recognize the changes that were made out of House Bill 2122, which has to do with EV registration fees. This was really about making sure we had parity for all road users. Right now, for an electric vehicle, there's no way to collect that user fee like we do for internal combustion engines where they go up and fuel up at a pump. So House Bill 2122 was passed, which modified registration fees for electric vehicles, hybrid electric vehicles, plug-in hybrid electric vehicles, all those things up on the list there. The intent of the legislation was to bring parity to the amount the owners of these vehicles pay for the use of the roads. But one thing that the legislature did this year, which I truly appreciate, is recognizing that those vehicles are also using our local systems and that those fees should also be broken down and passed on to our locals, so they were distributed in the same manner as our motor fuels tax to the Special City County Highway Fund and the State Highway Fund. And with that, I know it was a quick overview. I hope I got you back on schedule, but I would absolutely entertain any questions.
Well, thank you, Mr. Secretary. And again, I can't speak highly enough for how responsive you guys are and the hard work that you do for the state.
Yeah.
So thank you. Committee questions, Senator Klemp, then Representative Turner.
Thank you, Madam Chair. And thank you, Secretary Reed.
Yeah.
Appreciate it. I had a quick question. You had talked about the complexity of the formula for SCCHF in regards to the different percentages that get weighted for vehicle miles traveled, miles of road, and registration fees, and it's a complex formula. I was curious, is there any weight in there for bridges, counties that have a higher number of bridges, and does that weigh into that calculation at all? It was more for my own edification.
So with my familiarity of the Special City County Highway Fund, I have not seen anything that has anything to do with bridges. I don't think they're mentioned anywhere in the statute. I am going to look at my experts over here. No, we don't think there is, but we can get back with you if we see something in there.
All right, thank you.
So Representative Francis?
Thank you, Madam Chair. And some of this is almost more comments for the committee. You know, the Secretary did an excellent job. I spend a little time as Chair of the House Transportation Committee on this stuff. But one of the things I wanted the committee to be aware of, these registration fees that the Secretary alluded to, Those include basically our base internal combustion engine registration fee. A lot of times when you see state data on a national level, those registration fees for EVs and hybrids do not include their base registration fee. So you can basically take $40 to $50 off of this, and that's a comparable number to what you see statewide. And I wish the Secretary could also expound upon the fact that even though on our city-county revenue sharing, we don't have anything in there, I don't believe, for bridges, but we do have separate bridge funds to help our local governments with bridge replacements and cost share programs. And then my third thing would be, we often hear about what do we do about the charging. Our current statutes say that commercial utility bills pay sales tax. So when a car fills up at a commercial charger, the state is collecting a sales tax on that that is somewhat equivalent to our fuel tax. I'm sorry to step on.
No, you said it well. I don't know that I have anything to add to that.
That's good to know. Thank you for the information. Representative Sawyer.
Thank you, Madam Chair. I am very surprised to find out that the Kansas motor fuel tax is in the bottom third of states. You know, roads have always been pretty important in Kansas. I remember in '89 we voted for motor vehicle tax increase to fund the highway plan. It seemed like we were more towards the top. And then again in 2002 when we increased it. But I'll tell you what surprises me more is that Missouri's motor vehicle tax is actually higher than Kansas, which is hard to fathom since their roads are so bad. But at any rate, it does look like, yeah, I'm just frankly surprised we're that low.
I was looking at the same thing in Oklahoma and Colorado are less than us. So is it interesting to see the mix there? Yeah. So Senator Peck.
Thank you, Madam Chairman. On the interstate motor fuel user tax, my question is because you said that motor carriers are required to the taxes are distributed based on where the fuel is used, not where it's purchased. And as was just alluded to, the tax rate is different. So if someone purchases fuel, I'll just use an example of Oklahoma, but then they drive a lot in Kansas, how is the tax figured out? How do we receive the tax? Are we receiving less because the fuel was actually purchased in Oklahoma than if they had purchased in Kansas and driven in Kansas? Can you elaborate on that a little bit?
So I'm going to look back. I don't know if somebody from the Department of Revenue would be willing to talk about the mechanics of how it's actually collected. My understanding of it is that they are paying the tax rate based and the miles in the states that they are driving in. So if they are driving in Kansas, even if they're registered in Oklahoma, if they're driving in Kansas, if they drive so many miles in Kansas, they're going to pay the fuel tax rate for those miles that they drove in Kansas. But once again, I would like to.
What I'm trying to get at is, depending on where the fuel is purchased, are they not paying any fuel tax at the time of purchase?
Yeah, this is where the devil's in the details, right? And I think Department of Revenue can answer the details to that question.
Hello, my name is Terry Agnew. I'm in the IFTA department that runs this program. Whatever carrier does, wherever they buy their fuel, when it comes to filing their quarterly tax return, they're going to take all the miles that they traveled and all the fuel purchased, no matter where it is, and they're going to come up with an average miles per gallon. Then, based on the miles that they traveled, they're going to divide the average miles per gallon into that to figure out how much money they might owe us using, and we haven't got to our tax rate yet, so we're just figuring out how many gallons or how much mileage they owe us. Then we take the gallons that they purchase. If you bought enough fuel in Kansas, you might get a credit. And if you haven't bought any fuel in Kansas, then we're going to take what we think you owe times our tax rate, and then they're going to pay us that amount. So like he said, it's based on the miles that they traveled in the state. But coming up with the average miles per gallon is how we're figuring out how much they're paying us.
So that's a very complex system. I actually am So they file in one state?
Yes, with their base state where they got their IFTA account set up.
So, and it's an on your honor system, basically?
Well, they are audited, and to some degree, I think paying all your taxes on some of your, on your
No,
own.
I understand. I'm just curious as the process. I think this is new to many of us, and that's why we asked for this overview to see where we're at on our taxes and how this process and the system is working. So did you have some more questions, Senator Peck?
Thank you, Madam Chairman. Just one final question. So a carrier who's got their vehicles registered in another state, is it beneficial? I'm focused on Kansas. I want to make sure we don't get it taken the shorts. But they purchase most of their fuel out of state, but they spend most of they drive most of their miles in Kansas.
They're going to pay us.
Okay.
They're going to owe because they didn't buy any fuel to cover our roads, we kind of call it. And so they're going to owe us money no matter what.
But the other state received the tax revenue. Is that state then required potentially to refund to the carrier because they did not travel very many miles in their state?
All of those equations are done on the same return. So yes, essentially, it would show a credit on like if they're from Oklahoma, on the Oklahoma line. But essentially, when we get the return, they're showing us every single state that they traveled in and every state that they bought fuel in. So it's a matter of the money just going back and forth. Then, at the end of the quarter, we send this money to a clearinghouse where all the returns come from all the different jurisdictions, and then they pay us, and we pay everyone back and forth. It is a lot.
So it is a complex system, apparently, or antiquated. But would you mind sending to Eddie, so it can be distributed to the committee, an idea of what kind of dollar amounts we're looking and what's coming in from other states? I would be curious. Okay, great. Senator Clamp, did you have a question?
Thank you, Madam Chair. Just more of a comment to Senator Peck's comment. Having the pleasure of owning a trucking company here in the state of Kansas, we do go through that process. It's a cumbersome process. I feel it's hard to beat the system. If someone was looking to do that, the audits are significant, and so we pay attention to that. And we participate in IFTA, and some states choose to participate in a conglomerate group where it goes for all of the states, and there's a handful of states that don't participate, but you capture all of the miles in every state. And as you report that, to your point, it goes back to a central source, and then they do provide credits and debits accordingly. But we like to buy all of our gas in the state of Kansas, so just FYI.
So it seems like a cumbersome process. I'm not saying you shouldn't be filing quarterly, because most sales tax do, but I don't know. Maybe if there's any way the process could be improved, or maybe it doesn't need to be improved. Okay.
Madam Chair, I would just like to point out, I think the alternative for this is that every carrier would have to register in every state and would have to navigate the tax issues of every state. This is really, I mean, it's really meant to help standardize the process. So, I would hope it's cumbersome, but it's probably less burdensome than dealing with every state's Department of Revenue or equivalent, right?
No, I understand that.
Yeah.
What I'm thinking too, and I guess I'll share it with the committee. So I get the system and I get the distribution method, but it would be very difficult for us to be able to see. I'll give you an example. There was a city manager in one of my municipalities, and he caught the fact that the way the sales tax was being filed, they were filing it with the wrong location, and so his city was not getting a sales tax that he should have been getting. And so that's all I'm looking at here is, it is a little bit complex. How do we know that Kansas is getting the accurate output that they should? That's all I'm looking for. And there was a question earlier too on the distribution of the sales or the motor fuel tax. I thought that it was available for roads and bridges. Is that not accurate? It's only available for roads to local governments?
So I interpreted the question as, are bridges a part of the formula that determines how much is distributed to each city and county? Our answer to that would be, we don't see that as part of the formula, but the funding is for all road and bridge purposes.
Okay, great. Okay, that's helpful. Any other questions, committee? Mr. Secretary, thank you, and thank you. I'm sorry, I missed her name again. Terry, thank you very much for answering those questions. It was important for us to understand. Thank you. Committee, we are back on schedule. I guess, in fact, we're a little ahead of schedule now. We have a lunch is going to be provided. I know that's a little different, you guys. It is a working lunch, but we're trying to cover so much new information that I don't want to restrict questions. And so we're trying to allow some flexibility. Committee, I guess Eddie is next up, so we can be flexible with the schedule from here on out. Would you? Stephen, I want to recognize you. Stephen Durst is providing lunch today from Federico Durst, and thank you very much. They always go over and above, so thank you. Well, committee, we will break for lunch. We'll get our lunches, and how about we start 12:05 or 12:05? Is that good with everyone? Okay, we'll reconvene at 12:05. Thank you, committee. I think we're ready to go ahead and get started. And Eddie, somebody's got their audio on. It's okay. No, it's not yours. Well, thank you, committee. I'd like to thank Stephen Durst again from Federico Durst. It allowed us to continue working. I know we cover a lot of territory in this committee, but it'll allow us to stay on schedule and entertain many questions. So Eddie, would you mind going over, and this one, you're going to get a lot of questions, I guarantee it. Property tax exemption overview. The more I delve into this, the more it's an interesting topic. So thank you, Eddie.
Yeah, thank you, Madam Chair and members of the committee. As I mentioned when I came up here earlier, kind of a goal of today was to get all of the issues of the committee in front of you so that as needed, they could be followed up upon at later meetings. And this presentation might be the best example of that because I'm going to try to kind of cover more or less the entire universe of Kansas property tax exemptions. But obviously, there's a lot of detail within that universe, and while some of the questions you might have as it relates to that detail are things that I will be able to field from the podium today, in certain instances, it might be the case that those are the sorts of questions that we need more detail, more follow-up on, and would be better suited as a note to add to as either a follow-up item of information or as a possible agenda item for a future meeting. But you should have two documents in front of you that are going to be part of this presentation. One is a document that is a list of property tax exemptions, and the other one is a document that is county level data as it relates to it. To property tax exemptions. And so I'll go through the list primarily first and then circle back to that county level data afterwards. But before I get all the way into the weeds of even the list, I do want to talk through a handful of kind of what I would describe as principles of property taxation and property exemption that will be helpful to just have in your mind as we go through this list. And the first of those is that in Kansas, we have what might be described as kind of a baseline assumption that all property is taxable. And so unless there is a specific exemption that applies to property, we default to it being part of the tax base. That's something that when we think about our taxes in Kansas, obviously on the sales tax, that actually varies whether it's a good or a service in terms of that question. And on the income tax, we default to a federal starting point. So the determination of that on the income tax depends upon the federal treatment of any category of income. But for property tax purposes, our default assumption is that every single bit of property in the state of Kansas is subject to the property tax unless it is specifically exempt. What this means, though, also is that for purposes of determining whether an exemption applies, they are typically strictly construed by appraisers, by the Board of Tax Appeals, by courts against taxation. And so if there's any doubt in terms of whether or not property is exempt, all of those entities typically resolve it in favor of taxation and against exemption. That's kind of a legal principle that goes hand in hand with a baseline assumption that all property is taxable, but it is something that oftentimes is probably very frustrating for your constituents, and that might be something that you hear questions about or complaints about even, but it's something you should be aware of. The next principle is that the Board of Tax Appeals is the primary entity that determines if a piece of property is exempt in most cases. That's the way that we have our laws structured in Kansas, and most exemptions therefore require an application for that exemption. However, there are a handful of those exemptions that are specified in these materials where the county appraiser themselves has the authority to exempt the property if the exemption does clearly apply. But once again, the appraiser is specifically told to err on the side of listing the property for taxation and saying if there's any uncertainty at all, in terms of if this property is exempt, the Board of Tax Appeals is the right entity to make that determination, not the county appraiser. It's only clear-cut cases where the county appraiser is exempting it themselves. Another kind of principle of property tax exemptions in Kansas is that most of our exemptions are what might be described as use-oriented and not ownership-oriented. And so what that means is that it's the actual use of the property that determines whether or not they are, the property is exempt, not who is the owner of the property. A good example of this, and I say good just because it is something that has been in the news over the last couple of years, is that the city of Topeka owns a hotel here in town, but there's no municipal use of that. It is still being used as a hotel. And so that property, even though it is owned by an entity for which much of their property that they own is exempt, is still subject to the property tax. And that's true for any time that an entity owns property that they use for a non-exempt purpose. It is not uncommon for nonprofit organizations to own property and then use them for the production of income that they then use to finance their nonprofit operations. In those sorts of cases, that is still subject to the property tax because it's not being used for that exempt purpose. And then another thing that this relates back to a little bit the default assumption that the property is exempt is that one of the kind of, just as a result of the way things are, exceptions to that general rule is that most exempt personal property is not listed anywhere. And frequently it does not necessarily require an application for exemption. I'm going to jump ahead very briefly, but the very first item listed on the list of exemptions is the property tax exemption for all household goods and personal effects not used for the production of income. Obviously, all of us here have household effects and personal goods that we do not use for the production of income. And I'm pretty sure that none of us here have filed an application to have those exempted from the property tax. And I'm also pretty sure that none of us here have ever paid a dime of property tax associated with those goods. So when it comes to personal property, there's kind of a reality that most exempt personal property is never listed for taxation in the first place. And so there is no application for that exemption. And then the other thing that I do want to mention is kind of a principle of property taxation and exemption, and this is somewhat of a more of a principle for the way the property tax works in Kansas, is that by and large, most of our property tax exemptions do not reduce tax, but they rather shift tax to other property that is subject to the tax. Most of our property tax in the state is levied by local governments, not the state, and prospectively, I guess, all of it will be levied by local governments and not the state. And the way local government budgeting works is the local governments determine the kind of spending needs of the local taxing entity. They deduct all of the non-property tax revenue sources from that, and then the property tax is the float on local government fiscal policy. And so whatever is remaining after the non-property tax revenue sources have been deducted, that's the amount of property tax to be levied. They divide that out by the total taxable property within the entity to get their tax rate. And so if that total taxable property within the entity is reduced by virtue of an exemption, it just results in a higher rate. And so all of that property that is still subject to the tax pays. And so on income tax and sales tax sides, when we have exemptions and deductions and credits and things like that, they result in reduced revenue. But by and large, on the property tax side, when there's an exemption, it results in a shift of that revenue. Now, there are a couple of exceptions to that rule. Obviously, we do still have a very few number of fixed mill levy rates in the state. The two that are probably the most noteworthy are on school finance. The 20 mills is a fixed mill levy, and then the capital outlay mill levy levied by school districts. While it is not truly a fixed mill levy, it is a capped mill levy, and most school districts that do levy that levy are essentially at their cap of 8 mills. And so in those cases where it is a capped mill levy or a fixed rate mill levy, and the exemption does serve to reduce the revenue in that sort of instance. It doesn't just shift the tax burden to other items of property. And so I think that is all of the kind of principles of property taxation that I wanted to touch on before we got into the document. Those are just all things that are probably going to be helpful for you to have in your minds as we talk through what these exemptions are. So with that said, I'll jump right into the document, and I'll start with the list first, and I'm going to clarify that this is my annotation of a document that the Property Valuation Division prepared. And so this is extracted from their memo on property tax exemptions that they have on their website. I added a kind of a third column off to the right that specifies kind of where this exemption is going to fall in the table of data that is the second attachment that I have for you. But generally speaking, this document is kind of 3 columns. The first, the farthest left column, is the source of authority for the exemption. The second is the kind of description of the exemption itself, which in some cases is the direct statutory language from it. And then the third one is that column that denotes where in the second document that I have, the data associated with that exemption is most likely to fall. You can see on this first page, a lot of those say NLPP. That is my personal abbreviation for not listed personal property. And so if it says NLPP, what that means is there probably is no data associated with that exemption in the county level exemption specific data. So want to clarify that for everybody. But the first, and then from there, the only other thing I really wanted to clarify is that while this memo and this list attempts to kind of group these according to categories, the reality is we have a lot of property tax exemptions, and many of those do not fit neatly into a category. And so there are some of these that you're going to be like, why in the world does he have that as a personal exemption? Probably the second and third ones listed here will fall neatly into that pondering if you look ahead at all. But the reality is if I had listed every single category that we might have needed, I probably would have had at the end of the memo like 7 or 8 categories that just had 1 or 2 exemptions, and that's just not really helpful for reviewing this. But with that said, the first kind of category and set of exemptions here they're labeled personal exemptions. What that basically means is these are just things that people have in their lives. They aren't necessarily for a specific function of the economy or a specific subset of taxpayers. They're pretty universally applicable. So obviously the household goods thing that I specifically mentioned is one of those. The next 2, as I noted, they don't really fit neatly into this category. If I had done this with a bit more thought, I probably would have slid this to the bottom of this list on this category and just gotten to them and mentioned that we do have these. Because obviously most of us don't have land contiguous to a dam or reservoir. Most of us don't have real property upon which surface mining operations occurred. But those are 2 that just don't really have a good elsewhere to fit. And so accordingly, you can see in that farthest right column, they're in the exempt all other, which is just a not elsewhere classified subset in the data. The second one here is somewhat of a unique exemption for the state, and that is our exemption of the first $75,000 of appraised value for residential property from the statewide school finance levy. Most exemptions that we have, almost all of them, are either all on or all off property tax exemptions. We don't have very many partial property tax exemptions. There are certain circumstances in which we can't have partial property tax exemptions based upon our constitutional language. We have a classified property tax system, which means that different classes and subclasses of property are assessed at different rates. And we've had some legislative efforts in the I believe it was the early 1980s to apply kind of a uniform partial exemption to a whole subclass of property, and by virtue of a statute, and the Kansas courts said that really is just a circumvention of the classified system that you have provided for in your Constitution, and so you can't do that. Now, there are certain instances in which we can and do partial property tax exemptions, and this happens to be one of them, and this is kind of partial in 2 different senses. It is partial in the sense that for any residence valued at greater than $75,000 of appraised value, it only exempts a part of the property, but it's also partial in the sense that it only applies to one of the mill levies that apply to the property. The statewide average mill levy is around 125 to 130 mils. Obviously, depending upon where you live, the statement I just made to you might have made you think, wow, what a low mill levy. How could that possibly be the statewide average? Or it might have made you think, wow, what a high mill levy. How could that possibly be the statewide average? It is a pretty big range in terms of that average mill levy, but this one only applies to the 20 mills, which are truly uniform throughout the state. And so that is kind of the second of these, if you exclude and drop down those other two. The other thing that I would note as it relates to that levy is that is worth exactly $172.50 for every residence that is valued at least $75,000 of appraised value. And so no matter what the home value is, it's not more than that. If it is less than $75,000, it's less than that, but it's kind of a fixed amount. The next exemption here, and I'm not going to actually ultimately list every single one of these, but I probably on the front end go through a bit more detail so that you get a sense of the sorts of detail that goes into these. We have an exemption for antique and amateur built aircraft. Another one that, this is one that there will be another later exemption for a different category of aircraft. And between the three different exemptions for aircraft, it's a relatively small slice of the total universe of aircraft within the state that are still subject to property tax. The next one after that is personal property that would be listed except its purchase price is $750 or less. And so that's, it might be described as a de minimis type exemption for personal property in the sense that there's a lot of personal property that might be subject to tax. However, no matter what it is, if its purchase price is less than $750, it never goes on the tax rolls. That way, that probably saves taxpayers a lot of headache in terms of trying to sort out, do I need to be sending in a form to my county appraiser to get this listed and taxed? It also saves appraisers a lot of headache in terms of do I need to be going out to seek this personal property? The following exemption here is one that was enacted a few years ago regarding any antique utility trailers. I do probably want to note on this one that this was likely subsumed by the one at the bottom of this page, since this one had empty weights of 2 to 8,000 pounds. And the most recently enacted legislation on this list that I don't believe we have a KSA number yet for, unless Amelia might be able to. Oh, it was apparently as of this morning we do have a KSA number, but I prepared this earlier this week, and so it just says 2025 House Bill 2231. We now exempt any trailers with a gross weight of 15,000 pounds or less. The one immediately below that also was probably subsumed by that because it was any watercraft designed to be propelled through water through human power alone. And I believe that the exemption for this one included watercraft. I believe that should, or marine equipment. I believe that should be a number 4 there that I think got cut off in my formatting for this. So I will get that corrected. The bottom section there is, of course, the personal property tax exemption that you passed this year that I guess as of this morning does have a KSA number. I can't tell you what it is. And that does include marine equipment, which I believe would absorb everything in 795501C. So that's it for personal exemptions. And since I talked through those principles and now through a first array of exemptions, this might be a good time for me to pause for questions and to take a drink and let you all ask me things.
Sure. I think there's going to be plenty of questions, and we'll see. But Representative Sawyer-Clayton.
Thank you, Madam Chair. So, no, Eddie, I appreciate you taking the time to break all of this out. Would it be possible for the committee to get this listed with a fiscal note to see which exemptions cost the state the most money? I think that's what I'm looking at when I'm looking at things like this.
So that is actually by and large what some of the pages of the second attachment will do. Now, it lumps them in by category, which is in many ways all we're able to do for some of that, because some of the properties that, based upon the county reporting, they might apply, multiple exemptions might apply to them. And so it's easier to say this is exempt energy property or exempt graveyard property or whatever. But the second attachment that you have, the first 3 pages of it are the parcel count by county. The second 3 pages of it are the amount of exempt appraised value by counting, assuming that all of it would otherwise be commercial property. And then the last 3 pages are the amount of exempted tax, but assuming a statewide uniform mill levy of whatever the most recent statewide average was. I think it's 127 and change mills. Now, I was going to get to this when I got to this document, but since we're talking about it right now, this might be as good a time as any to mention it. I actually noticed as I was putting this together over the last couple of days that there are a handful of counties, and they are the larger counties in the state, that are not included in this. I've already checked in with PVD on that, and we are working to get that data, and we'll provide it as an update whenever it is available.
That was going to be my second question, so thank you, Eddie.
Yes.
Thank you, and thank you for providing these, Eddie. I will bring it up for Representative Turner. I'm sure he'll appreciate this. We've had some questions as to trailer and the definition, and I don't know, I think maybe we could, we defer to Amelia on that at a later time. I'll give you time to look it up. But we had a definition of camper trailer and trailer in the statutes, and I think there's some confusion as to how that's being interpreted. And so we might see further legislation next year as a result of it.
Yeah, I think that is something that the last I heard, the Department of Revenue was still working on the legal guidance they were going to be providing to county appraisers in terms of how to handle that. I don't know. They may have already provided that guidance. If they have, it's been within the last week or two. But that certainly is a good question for the committee and might be ripe for future legislation if it's of interest to the legislature.
Yeah, it is, and I definitely know it's an issue. I just wanted to make sure that he knew that it was on our radar and that we haven't forgot about it. But would you like to comment to it, Representative Turner?
Well, I'm not sure what, thank you, but I'm not sure what comment you're looking for. You mean just to kind of explain it? I guess my question is, having heard that they may send clarification out to the county assessors on it, I haven't even heard back on my question. So, but I think it's curious that they're putting out direction, and
No,
I haven't heard an answer.
He just said they might be. He didn't know. Okay, yeah, no, and the Department of Revenue will be here for other items, so we can ask them at that time.
Right.
But no, I'm sure
So-
they're going to get back to you on your question.
Yeah, just for the benefit of the group, so they know. So we passed legislation that exempts trailers below 15,000 pounds, I believe is the guide. The question became, I've got an Airstream trailer, so is my Airstream trailer now not taxable? So that's the question on the table. Thank you.
Thank you, and I would say, based off of current language, we'll see what their ruling is. But, and either way, it's not that difficult. If you don't like the way they decide, then you put in a bill for next year, right? That's the way the process works, so. Any other questions, committee? I have one for you, Eddie, and the $750 or less, has that been on statute for quite some time, or has that number been looked at?
Yeah, that has been on statute for a long time, and we have not adjusted that $750 in a long time. Well, I probably shouldn't use the phrase a long time. It has been longer than since I was here that we last adjusted the $750. Off the top of my head, I do not know what year that was, but it has been more than 12 years since we adjusted it, and we can track down the year that number was set.
So I'm thinking we might want to put an adjustment in. That might be something that either this committee continues to look at or that we look at in legislation next year. It's kind of like the 20,000 exemption on the 20 mil. We took a look at that a couple of years ago when we were able to increase it substantially to 75,000. So
During this conversation, Eric let me know that it was 2008 that we set the $750 level. I do not know what it was prior to then. Oh, that was when it was enacted. Okay.
Okay. No, wonderful. So it's much like the 20,000 for the 20 mil. It hasn't been changed since implemented. So that'd be great. Committee, any other questions? Representative Smith.
Yeah, just to follow up on that, I'm not familiar with that actual language, what if I bought something for $1,000 and that's now worth $500? Is it based on the original purchase price and then that continues even if the value of the property is less than $750 currently?
My understanding is the eligibility for the exemption is based upon the original purchase price, but obviously its taxable value each year is based upon its present value.
Sure. Okay, thank you.
Senator Peck.
Briefly, to continue on that, original manufacturer suggested the price when it was new, or if I purchased something used?
I would prefer to have the language in front of me, but I believe it is the purchase price when new, but I don't have the statute open in front of me. The statute itself just says purchase price, so it might be the purchase by that taxpayer. I would want to do further research before I tried to tell you definitively this is how it is handled.
Well, I was reading purchase price as is the price that I bought, whether it was new or used. And, okay, thank you. Thank you, Madam Chairman.
Could you give us an example of something that might fall into that?
So the
a piece of artwork, would that be?
Well, it's the subclass is the not elsewhere classified subclass in essence. And so a lot of the things that you just exempted by virtue of this year's bill are the things that would have been most applicable to this. This one has probably been mostly subsumed by this year's bill. However, there are still a handful of things within that subclass of property that are subject to the property tax. And so that's what it would still apply to. The things that I'm immediately thinking of are the remaining taxable aircraft. Obviously, there are not a lot of aircraft sold for less than $750. I personally would not want to fly in one. And then I believe one thing that we also mentioned at the times of the hearings of this were that hot air balloons are part of that not elsewhere classified that oftentimes do exceed that $750 threshold.
Any other questions, committee? Thank you, Eddie.
Okay, the next page of this gets to some nonprofit type exemptions, and this covers those based upon kind of no matter their nonprofit basis, whether it's kind of religious in nature, education in nature, charitable or benevolent, humanitarian, or there are also some here that do have fees charged for their service. So they're not purely, charitable in nature, but they are nonprofit oriented. And so these are things that you probably do think of as exempt, and I imagine most of your taxpayers, most of your constituents understand them to be exempt. And that's property used for public worship or for school district purposes, property used for charitable purposes, but also within that same subsection, we have literary, educational, scientific, religious, or benevolent. Obviously, there is potentially a lot of overlap between the previous one and that one, but it probably does capture some additional property there. The funds that are held by university, colleges, and schools, when you think endowment funds, things like that. The property of colleges or university parsonages, which obviously pretty closely related to the religious exemptions listed earlier. 501c19 veterans organizations, 501c3 that is used for humanitarian services, convents, monasteries, charitable auction motor vehicles. And then down below that, we get to a lot of the nonprofit healthcare property that is exempt from property tax as well. This is one where to Representative Sawyer-Clayton's question about can you get us, kind of an estimated fiscal note associated with each of these, you can see that some of these ones, the fiscal note for public worship and school district purposes, those pretty conflated within the statute, but obviously at the tax level, it's pretty easy to tell the difference. Is this property used for public worship or is this property used for a school district? That's not as the same sort of conflation. And so on the second sheet, you can see that we have it split into, there's an exempt education, there's an exempt religious. And so the exempt religious category here captures the public worship piece of this, but also within 201 second, if it's property used for religious purposes, and also 201 seventh, parsonages, and also 201 10th, convents, monasteries, et cetera. So all of that goes into the exempt religious on the second page, or the second attachment, rather. And then obviously virtually everything in what is labeled here, nonprofit fees charged for services, is oriented towards hospitals, healthcare, or housing type services, specifically housing for elderly purposes, persons operated by a nonprofit organization, group housing for individuals with certain disabilities, and then also elderly persons with low incomes, that sort of property. From there, I'm going to pivot over to the third page. The first three of those are military exemptions. It probably would be better phrased military member exemptions, because these are all properties that are exempted by virtue of the property owner being a military service member in some form or fashion. The property of the military itself is exempted further on by virtue of governmental exemptions. And then also a handful of agriculture-oriented exemptions here. These are by and large machinery and equipment type exemptions, but also things that I think from an agricultural production side are probably thought of as more inventory sorts of things. The livestock itself, the grain itself that is produced, hay, silage, and things like that. And so that is all I was going to comment on those. I told you I would get to moving a bit quicker as we got a little farther into it, but I will pause here if there are any questions.
I have a couple of questions. Do the committee members? Okay. When you talked about the schools, this has come up a little bit, and with the hospital property tax exemption. I had a representative call me from his area. They are buying properties that are somewhat competing with businesses in town, especially the nonprofit hospitals. So how does that work? If they buy, say, the city example that you used for the hotel, if a school purchases a hotel and is operating a hotel, do they still pay property taxes on that?
Yeah, these exemptions are all use-oriented on this page. As we go through here, you'll see that some are not necessarily use-oriented, but these ones are all use-oriented. So it is used for school district purposes, and I don't think the Board of Tax Appeals would be inclined to be convinced that a school district operating a hotel would be a school district purpose. Now, that being said, there are obviously, that kind of takes it to the two different ends of the spectrum, things that are patently commercial activities versus maybe, a school building itself patently an educational activity. There's probably tremendous amount of gray area in between there, and that's probably going to be resolved on a fact-specific basis by the Board of Tax Appeals in terms of, is this educational purpose or not?
Okay. And then on the hospitals, I know that's been brought up by a couple, that we have nonprofits that don't pay property tax, but the for-profits do pay property tax. I guess that would be getting into the qualification of why are you nonprofit versus profit, or?
Yeah, that's just the policy the legislature has chosen to adopt, that the hospital and kind of related exemptions here are all limited to nonprofit hospitals. Obviously, if the legislature wanted to visit that for-profit entities as well, it would certainly be entitled to do so. Okay. But it is similar to the education item that we talked about here. All of these hospital and healthcare oriented ones do include that use component as well.
Okay, and the motor vehicle, I'm sorry, I know I'm asking quite a bit of questions, but I've been called by a few legislators on this stuff. One of them said that his family member drives 2 Porsches and doesn't pay any property tax on their vehicles in Kansas because of, but we do that for active military. I don't know if most people are aware of that.
Okay.
Yeah.
I didn't know in that context that you were referring to the military exemption one. Yeah, that, I mean, the statutes are of course agnostic as it relates to what kind of car our military service members own.
Right, but it is only active, not retired. Is that correct?
I believe that is, that's right there out on the face of the statute, yes.
Okay, great.
But it does go into a pretty robust definition of exactly what military service means. And it, it's a Kansas statutory definition. It isn't based upon a specific set of federal orders that the service member might be under. It is based upon the Kansas statute and how they would be interpreted.
Okay. Wonderful. Any questions? Senator Bowers.
Thank you, Madam Chair.
I'm sorry, I looked at you and said Bowers.
Yeah.
Yeah, sorry.
It'll take a few years for everybody to get
I'm thinking
Bowser
of
and Bowers sorted out.
Elaine's on my mind, so.
Thank you. So I represent, my Senate district is Senate District number 1 in Northeast Kansas. All 4 Native American tribes in our state have reservations in that Senate district up in Northeast Kansas. And I understand there's some tax exemptions granted to Native Americans, especially on the tribal reservation. But do you have any, I'm seeing a trend where the tribes are buying property outside of the reservation boundaries, then putting that land or businesses or whatever into a federal trust, and then that becomes apparently tax exempt. Kansas is losing quite a bit of tax money on that. Do you have any estimates on tax exemptions for tribes outside of the reservations? I'm told in Jackson County, for example, it's $5 to $6 million per year.
Off the top of my head, I do not immediately have an estimate for that. But yeah, that is, in that sort of instance, we have a blanket exemption in 201A first, which is not necessarily use-based, that is property owned by the United States government. And that's one of those that, even if we didn't want to exempt that, we probably can't compel the federal government to pay taxes to us. Almost certainly can't. And in the case that you're describing, I believe that is property that is technically and legally owned by the United States federal government, and it is held in trust for the benefit of the tribes in question.
Correct.
And so from a property taxing standpoint, the reality is there's probably nothing we can do about it. Now I don't know if there is anything in terms of it as it relates to the state's relationship with those tribes that it can do in terms of whether or not that land ever goes into trust. I know that is something that has sometimes been litigated by the state, I think in a different context, but that's probably how the approach the state would have to take there, because I think once it's owned by the federal government in trust, there's really nothing we can do about it. In terms of an estimate on that, we can work on getting what that number would be, but I don't know it off the top of my head.
Thank you. I'd like to see an estimate on that. And then, Madam Chair, I think, and again, we're working this through the Joint Tribal Affairs Committee. Senator Alley chairs that committee. But it may be appropriate at some point for the state to ask the federal government for compensation. I mean, we're losing millions of dollars a year because the federal government says they're tax exempt.
No, thank you, Senator. I'm not sure the committee is aware of this, but it's not just an issue for your county because there is no restriction on where they purchase the land. So they could be coming into any of our districts at some point.
That is correct. And they are, I'll just use not trying to pick on the Potawatomi tribe here, but they are purchasing or have purchased property in Shawnee County now, again, outside their tribal reservation boundaries, and put it in the USA Trust. It's now off the Kansas tax rolls.
Yeah, and how many, percentage-wise, it's a fairly high percentage for Jackson County that they've expanded.
It is a significant impact to Jackson County. I would suspect Brown County and Donovan County and some of the other counties as well. So.
The only thing, as it relates to your kind of final comment, that does the state want to petition the federal government for some sort of compensation for this sort of thing? The only thing I would mention there is that the federal government does have specific federal programs related to this sort of issue as it relates to military installations, since those oftentimes pull substantial property off of property tax rolls. They also oftentimes result in population being located to an area that may have children enrolled in the public schools in the area that would otherwise be financed via property taxes. And so the federal government does have federal aid programs to state and local units of education to kind of offset that reality. And it might be something where the state would pursue a program similar to that for just the underlying property tax issue. But obviously that would take federal action. Okay. I had jumped ahead to the government exemption page on mine, so I'm going to now jump back, and we're now to the business exemption section, and I am realizing here that I don't think my highlighting printed off very well, at least not in my copy. I'm not sure if any of the statutory sections are highlighted in anyone else's. Thank you. I finally saw one head shaking no. What I was going to talk specifically about here is that first, in the Department of Revenue version of this, the energy exemptions are lumped in with these business exemptions, and they certainly conceptually can be. However, since there are so much language associated with all of those energy exemptions, I thought just for ease of reading through this and getting some delineation within your materials, I would add a separate subsection of energy exemptions there. That's just a comment for your benefit, but what I did want to note here, specifically on these business exemptions, is that while I believe all of the exemptions we've talked about up to this point, and most of the exemptions throughout all of this, are determined wholly by the legislature or by the citizens of Kansas through statutory enactment or through constitutional enactment, some of the ones in this section are more discretionary. Now, they are provided for via either statute or constitution, but they are ones that the actual enactment of the exemption itself requires action at the local level. And those are, of course, the two that I'm referring to there are the EDX exemption is what it is oftentimes referred to, EDX standing for economic development, and the IRB exemption, IRB standing for industrial revenue bonds. The first three entries under business exemption, if you use a highlighter or happen to have a highlighter, those could all be highlighted. And then there is one also about nearly at the bottom of this that is 79-221 that also could probably be highlighted, and that is associated with it as well. So these are ones that, in the case of the Constitution specifically provides for, and in the case of statutes specifically provide for, that under a certain set of circumstances, county governments or municipal, I believe on the IRB, municipal governments as well, can take action that results in this property being exempt, and it's property that otherwise would be subject to the property tax. So these are ones that they're provided for at the state level, but the exemption itself is actually granted at the local level. And oftentimes when you all, as a legislature, collectively talk about property tax exemptions, many times the discussion focuses specifically on these exemptions, because these are the ones that they play out differently in different counties and different municipalities based upon the local elected officials' decisions as it relates to their locality. And so these are ones that are kind of optional in nature, and obviously there are parameters that have to go along with them, but you could have a piece of property that would perfectly meet the definition of the very first one listed there, the EDX exemption, but because of the decisions of local elected officials, as it relates to their local territory, that they are not exempt from property, or vice versa, they might be if they make that decision. I do want to clarify that in each of those cases of the optional ones, they are limited to 10-year exemptions, so that's probably an important thing to note, that the locally determined exemptions are not the indefinite type that we have, as is most frequently the case for the state level ones. Another note that I want to have as it relates to the EDX property specifically is that this is another one of those where we are able to, in certain circumstances, have kind of partial exemptions. The Constitution specifically authorizes the legislature to take action to limit that exemption, is I believe the constitutional language, and one of the limitations that the legislature has chosen to do as it relates to that is to give the option and opportunity for this to not be a full exemption, but to only be a partial exemption. Another limit as it relates to that, and when I say partial in that sense, I'm referring to a partial share of the property, like it might be 50% of it is exempt. Another limit that the legislature has placed upon that exemption relates to exactly which mill levies it applies to. There are certain school finance mill levies that, depending upon when the exemption was initially granted, it does not apply to, the EDX exemption does not apply to them. And that's because the legislature has specific constitutional authority to enact limitations to that exemption that maybe don't extend to some of the other exemptions provided for that the legislature has the constitutional authority to grant. And I believe it was in 2017, but it might have been 2018, one of the reenactments of the school finance law, the legislature chose to carve out some of the school finance mill levy from the application of the EDX exemption. The next one listed here is one that probably belonged in the energy exemption category. I don't really know why I didn't migrate it over to that grouping. But this is one that is going to be on the agenda tomorrow specifically, and that is the renewable energy generating property exemption. Of course, prior to 2016, anything installed prior to that date, it was a lifetime exemption. I believe it was 2016 legislation, might have been 2015. Oh, I guess it says here. 2015 legislation limited that to a 10-year exemption for new properties after a date in 2016. The next one also actually probably belongs in the energy exemption category. The next one here, personal property moving through interstate commerce. This is one of those, you might recall in some of our past discussions of sales tax exemptions, if you've been a part of those, that we say there are certain sales tax exemptions that we refer to as legal exemptions that we probably have to have by virtue of federal law. And this is a property tax exemption that might fall into that same category. Anytime we have any sort of state law that has a nexus to interstate commerce specifically, we kind of run the risk of running afoul of the federal Constitution's interstate commerce clause. And so this is a property tax exemption that relates to property moving in interstate commerce or kind of just stored in the state, kind of on its way through interstate commerce. It's an exemption that kind of keeps us safe as it relates to that federal interstate commerce clause. And then the one after that is another, the third instance of aircraft being exempted. Business aircraft are exempted, and there is a kind of a predominant use test as it relates to that is specified in the statute. Below that, we get into some more personal property that are relatively I think they're relatively straightforward in nature, and they're things that, at least at different times, some of this equipment would exceed that $750 threshold, if that it was even necessarily where it went. But the legislature doesn't really want to get in the habit of, your construction and mechanic hand tools. Make sure that every single wrench you have is sent into the county appraiser for taxation of that wrench on its value, and so chosen to exempt those almost as a tax expediency measure. Motor vehicle inventory, as you might imagine, is exempt from the property tax. And then below that, we kind of get down into more or less straightforward ones, I think. I'm not going to touch on those very explicitly. Oil and gas leases are specifically subject to the property tax. They're one of the subclasses provided for in the Constitution. One of tomorrow's presentations is going to be on the valuation and taxation of those specifically, and so I imagine that this will come up in it, but there is a property tax exemption for low-producing leases in that context. And then the bottom one on this page relates to commercial and industrial machinery and equipment purchased or leased after June 30th, 2006. That is something that relates very closely to what Representative Francis discussed during the Board of Tax Appeals type of issue, and it's one of those exemptions that it becomes a classification question in certain instances, because the real estate is still, of course, subject to the tax. The personal property is not. And so then the question that gets litigated, I believe, by and large, before the Board of Tax Appeals is this personalty or is this realty? And that is the difficulty that comes up in some of those cases. Beyond that, once you get into the energy exemptions, well, actually, I'll pause there before I jump ahead into energy for questions.
Thank you, Eddie. Representative Sawyer.
Okay, so I'm trying to think in my head, what would be left to be reported on a business personal property rendition to the county appraiser's office? Like if I bought like a $2,000 desk, would that still have to be reported?
So if it is a business rendition, then it would be only things placed in service or not used for production of income prior to 2006.
So even like a desk.
Yeah, it would be any equipment if it's more than, I mean, at this point, that's almost 20 years old, but if they're still using something that was taxable pre-06, then it continues to be on their annual rendition.
Okay, thanks.
My hairdresser is still paying property tax on the chairs in her facility because she's prior to 2006. I mean, it doesn't even make sense that cutoff, you know, and I don't know. Maybe it's something that we want to look at during session. That would be great. Did you have a question? Yeah, Representative Smith.
Thank you, Madam Chair. Eddie, when you were talking, I think about the EDX stuff, you were talking about how some mill levies are actually excluded. Do we have any, I'm thinking about, like, the best example, probably the easiest to understand is like our food sales tax. You know, that's, the local rates still apply. The state rate was set to 0. Technically, it's not an exemption, but when it comes to property and property tax exemptions, especially when you look at some of the EDX initiatives out there, what if a city and county approves something but the school district didn't? Does everybody have to be on the same page in agreement on these? Or are there any examples?
So generally, everybody, it's kind of an all or nothing. The one carve out is those EDX exemptions post 17 or 18, and it's only a subset of the school finance levies and it may only be the capital outlay. It might be also the bond and interest mill levies. And I might have those backwards. It's one or both of those, but generally everybody, it's all or nothing. The one key distinction there is that the city and the county and the school district all have the ability to stop it, so to speak. That there is a notice and a kind of a veto opportunity, for lack of a better description. I believe most frequently that's tried to be handled in a more alternative dispute resolution fashion, where whatever entity is wanting to propose the exemption visits with the other entities and says, can we come up with a version of this exemption that works for everybody, so to speak? But they don't carve out, at the local level, they're not allowed to carve out that the city and county mill levies will be exempt, but the school and state mill levies or whatever other mill levies would still be subject to it. Mm-hmm.
Thanks, Eddie.
All right. On the energy side of things, the one thing that I really wanted to highlight and mention for you is that there are obviously a lot of sections, a lot of them right in a row with each other as it relates to these. Most of these, I think, were by and large enacted in I want to say the 05 to 08 kind of time frame. And the legislature in recent years has tried to do some work to kind of universalize these, so to speak, by which I mean making it such that the statutes are agnostic as it relates to what the energy source is, who the energy producer is, what the kind of purpose of the energy facility is, but there are still a few discrepancies in the sense that some of them are 10 years, some of them are 12 years, those sorts of things as it relates to that. So I wasn't going to go through those with a lot of specificity because frankly the technical details are things that I know I would get bogged down in and not really be able to articulate very well for you all, and I imagine that they would be easy for us all to get lost in if we did go into those. But it is something the legislature has worked on in recent years, but there is still a bit more work to be done if a goal of the legislature were to make those all truly uniform from energy source to producer type, just as a note.
And we do have that presentation tomorrow, right,
Yeah.
Eddie? So that's going to help us take a look at it.
Yeah. Another one of tomorrow's topics is public utility taxation. And I think that it's going to focus more on the valuation side of things. So it might be the valuation and apportionment side of things, not as much the exemption side of things. So if you're wanting further clarity on the exemption side of things, that might be a presentation for a follow-up meeting as well. Mm-hmm. And then the last kind of subset of exemptions that I have here are all of the government exemptions. These are probably ones that by and large, even if you don't necessarily think of them on a day-to-day basis, they're ones that are pretty easy for you to understand. We are standing right now, or standing in my case, sitting in your case, in an exempt building. This building's appraised value is $66.1 million. across the street. The Judicial Center's appraised value is $18.2 million, but all of that is still is not subject to tax, as you might imagine. The government generally does not pay taxes to itself, so to speak. But once again, as we talked about earlier, as it relates to the hotel property here in Topeka, the use provisions do generally still apply, with the exception of the federal government, because it's difficult for us to impose that sort of use requirement on the federal government. But if the state were to use property for a non-state purpose, for a commercial purpose, in many cases, it would still be subject to the property tax. I believe the most recent case in which I saw this is there's certain wildlife and parks property that is subject to the property tax by virtue of it being used in essentially a commercial fashion by the Department of Wildlife and Parks. And so that's really all that I was going to touch on specifically, because I think by and large, other than the use issue, which can sometimes get blurry, there's not really a lot of other detail to go into as it relates to government exemptions. The other thing in this document that I was going to talk about is that I did provide the list just because it was in PVD's memo. It's not, I certainly don't want to claim that this is me deciding this would be a great idea to do it. Provide the list of, I mentioned earlier that the Board of Tax Appeals is generally the entity that determines is a property exempt or not, but in certain cases, county appraiser is able to make that determination as well and exempt property without requiring the taxpayer to go to the Board of Tax Appeals. It is a specific list of things that the county appraiser is authorized. This lists exactly what those items are and the statute where they're found. It is one thing that oftentimes comes up is I wish this was easier for the county appraiser to handle. I think one of you even mentioned it this morning during the Board of Tax Appeals presentation about, is there a way that we could streamline this? I mean, Mr. DeFries referred to agreed upon orders. Is there something that could almost be done like that as it relates to more categories of exemptions where the county appraiser might be able to handle them more frequently on their own, as opposed to having to refer the taxpayer to the Board of Tax Appeals? So if you were looking for an area that obviously would require a certain amount of work in terms of getting into the details, but might result in some benefit as it relates to that sort of efficiency and expediency for taxpayers, but also for county appraisers and the Board of Tax Appeals. A close examination of this list in the context of the full list of property tax exemptions might be a place where you might be able to find some of those opportunities. So I did just want to flag it for you for that purpose. And that's all I was going to say on the memo that is the list of them. And with that, I would pause for questions there before just going into a little bit of the information as it relates to the data that you have in front of you.
So Eddie, I have a question. You made a comment about wildlife and parks, property tax exemption. And I was under the impression they had sent us a list of that they are paying property tax on some properties. So they're exempt on some and paying property taxes on other?
Well, no, that's what I said is that the use requirement still applies. And so if the state is using the property for non-state purposes,
Like hunting and fishing.
which by and large means if it's using it for a commercial type purpose. Okay. Those are the instances in which, by virtue of the use requirement of the exemption, the property is not exempt from property tax and does have to pay the tax.
So my question then also, are they using taxpayer dollars to pay the property taxes? Obviously, they are, but is there any restriction on their payment? Does it have to be revenue that's generated from the activity?
I will need to follow up with you on that question. Okay. That's a very good question. You know, they're certainly using public funds to pay those taxes, whether or not it's limited to revenues from the fees they receive from the commercial type activity. I'm not aware of any sort of statutory restriction like that, but it might exist, and I'll follow up on that.
Okay, because it would make sense for the hotel too, that they would have to use income from the hotel. Any other questions? Representative Long.
Thank you, Madam Chair. Eddie, in regards to the government exemption properties, puts me in mind of the state-owned casino in Dodge City. So that property's probably paying property tax through the people that lease it, maybe, in that lease agreement, but not the state of Kansas? How does that work?
So I believe in this case, and I'll want to try to confirm this, we have 4 state-owned casinos.
Right.
I believe that it
Right.
is the casino operation that is actually owned by the state. I think the facilities themselves, the real estate itself, might be owned by the operator, and it's more the gambling enterprise that is in fact owned by the state. But I will follow up and confirm that with you.
Thank you.
Senator Peck.
Thank you, Madam Chairman. I notice on the very last page at the top, it's got municipal airports and airport authorities. Then it's got a little bit further down, Strother Field Airport. Further down, Salina and Pratt airports. Why do we have some listed specifically?
That is to the extent of my knowledge, it's kind of a historical anachronism, but it's related to, I believe, are those. I don't believe the ones that are listed separately are technically municipal airports as defined by the statute there. So for instance, Strother Field is not owned by a specific municipality, and so it wouldn't qualify as a municipal airport. And I believe that to be the case for the other ones that are listed specifically as well. It's kind of a carve out for specific airports that are by and large like municipal airports, but don't meet the statutory definition of municipal airport.
Okay, thank you.
Maybe we could get some clarification. I think there's still some confusion as to why we can exempt some and not others. Why we're able to list some airports, I mean, it's government picking and choosing winners and losers again. I'm not sure how we're doing this. I don't know if the committee's interested in more information or not. It doesn't seem like it, so maybe not.
Well, I think the legislature certainly could list others if it so chose to. I think these are specific instances in which the legislature has chosen to list ones that don't meet whatever the statutory definition to the generic one is. For whatever reason, most of those are at least, I think, 30, 35 or more years old, and for whatever reason they don't meet the municipal airport definition. Beyond that, I would need to follow up.
Okay, committee, any other questions? Well, Eddie, I think this is great information. Did you want to go over the sheet with the blue?
Yeah,
Okay.
I'll go over this just really briefly because it's by and large pretty self-explanatory, and I'm certainly not going to read you 98 counties worth of data. But as I mentioned earlier in response to Representative Sawyer Clayton's question, the first 3 pages of this are the number of parcels that are exempt pursuant to kind of each of these categories of exemption in each of it would be 105 counties, but for the fact that I believe 6 or 7 of those are missing. And as I mentioned, I discovered that those ones were missing when I was putting this together and trying to do a kind of percent calculation. And so I've checked in with PVD and neither of us immediately know why they're missing, but we're going to get the information for you. It's kind of the important piece of that, I think. And so on the first table, the ones that are missing are not highlighted. The second one goes into the amount of exempt appraised value by county. Once again, assuming that every bit of exempt real estate would otherwise be commercial. Obviously, we know that that's probably not necessarily true. Parsonages, for instance, would be residential if they were, and obviously the not-for-profit property would probably be in the not-for-profit class. And so this does make a certain assumption, but it would be difficult to parse it out otherwise without doing a very manual, intensive process. But what I did add to the second set, and this is how I identified that there are 6 counties missing from it that I've highlighted, there is the total county assessed value and then the exempt as a percent of the total. And that's probably an important thing for you to look at because sometimes there's a belief that if similar to the sales tax exemption belief that if we just got rid of these exemptions, we could cut the rate into, half of whatever it is for people. And as it turns out, in some counties, it is quite a bit of exempt property and it would make a big difference to the rate if the exemptions didn't exist. But in some counties, I happen to look near the top there, Anderson County, only 3.4% of their total county-wide assessed is exempt. The other thing I did want to highlight as it relates to the data is that there are two columns here that are not truly tax exemptions, but are kind of tax exemption-like policies. That's the neighborhood revitalization program, where that tax is actually abated and then refunded back to the taxpayer, and then the tax increment financing, where the tax is paid but is not routed to where it normally would be. The tax on the increment goes back to paying for the development of the district of which is subject to the TIF. And so that last column on there might be the most helpful one for you to look at as it relates to any of this data, because you can see how big of a deal are we actually talking about for these exemptions. And it does lend itself to, or I'm sure you'll be very interested in seeing that as it relates to the largest counties in the state whenever we do get that data. And then the final one is just the amount of actual tax being exempted here. And so if you look to the very last page of this, on the far right bottom line, it shows $491.4 million of property tax being exempted. Once again, that assumes a fixed mill rate of between 127 and 128 mills, and it assumes 25% assessment ratio. So there's some big assumptions in there that are not going to be the case for all properties in all locations. But that gives you a sense of kind of what we're looking at. But once again, that does not include 6 of the larger counties in the state, including Sedgwick, Johnson, Shawnee, Riley, Reno, and Finney. Those are the 6 that, for whatever reason, were not in the underlying data set, but we do anticipate being able to follow up with including those. So with that, I'm kind of finished there and be happy to stand for whatever questions you might have.
Thank you, Eddie. I just want to make sure, these are valuations, not the dollar amount, the actual, or the value amount.
So the first 3 pages are the parcel count, and so that's
Right.
the number of parcels. The second set of 3 pages is the assessed value. So it's not the appraised value, but it is the appraised value multiplied by an assumed 25%
So that
ratio.
means-
I could provide the pure
No, this is good
appraised value.
because the agriculture, we would know
Yeah.
the different
Mhm.
assessment
Well,
rates.
Yeah, and the one thing I probably should clarify there is the header there is a mislabel. The table is correct, the header is incorrect. It is assessed value, not appraised value. That's an important thing.
Okay.
But then the last 3 pages are the actual property tax, once again, assuming the statewide average rate. So,
Okay, the dollar amount.
yeah, the actual dollar amount.
Okay. And that would be the grand total and the total assessed value?
Yes.
So my question then also would be that you've included in the grand total properties, and this is fine, I just want to make sure that there is no way that we can pull them onto the tax rolls, like federal government, state government, because it is somewhat, like you said, people have this image that we're exempting all this property and that we can get more money so that not everybody's paying as much. But the reality is, there's some of these that we can't touch.
Yeah, that's certainly true, that some of these subsets, and so it might be the case that the most useful single thing to do would be to look at the entire bottom line of exempt totals working your way across. And you can see that the first 2 are those sort of county discretionary exemptions, the EDX and the IRBX. And on the first table here, I succeeded in putting what I thought would be helpful line segments. The latter 2 tables, I did not succeed in including those lines. But the first 2 are those kind of the municipal optional ones. The next ones are the kind of government ones. The next set are things that are kind of government-ish. Education, some of the exempt property for educational property is going to be governments, state government at the university level or local governments at the school district level. Some of that would be private education as well. Some graveyards are municipal or municipal owned, some are not. So, and same is true for water and fire. So those are all kind of government-ish. The next 3 there are ones that are fall into that benevolent, charitable, humanitarian, that sort of category. The far out ones are ones that just don't fit neatly into any other category. And then those last two are the ones that are not really exemptions, but they're exemption-like.
Eddie, the first two and the last two are definitely discretionary
Yes.
for local governments.
Yep.
Okay. Representative Smith.
Yeah, Eddie, I apologize. I know you've mentioned it a couple times. Do you have data available for the counties that are excluded here? Will we be able to see a comprehensive?
I visited with PVD about that, and we anticipate being able to get that data.
Okay, perfect.
I do not have it right now on my computer unless I've gotten an email during this presentation, but it should be available.
Okay, thank you.
Yeah.
Any other questions for Eddie? Thank you very much, Eddie. Thanks for your time putting this together. And Bob, I know you guys worked very hard on it. It's much appreciated. I think it gives us a lot to digest. So thank you. Committee, we're running a little bit ahead of schedule, so we'll take approximately a 9-minute break and reconvene at 1:30. Our next on our agenda is a limited scope audit of the High Performance Incentive Program and Kansas Affordable Housing Tax Credit. Josh, thank you so much for being here today. I know you did a lot of work on this audit, so thank you.
Yes, thank you, Madam Chair, members of the committee. Can you all hear me okay? Great. I am Josh Luthai with Legislative Post Audit. I know a lot of you either have currently do serve on the Post Audit Committee or have requested an audit from us, but for those of you who are less familiar, we are legislative staff like KLRD and the revisers, but you typically see a lot less of us because you really only see us when we come to present the audits that you request. But we do take audit requests from legislators, and then our committee selects some of those every year for us to work on, and then we come and present them both to our committee and to any committees that are interested in hearing them. And that's what I'm here to do today. So I believe you all have available to you a limited scope audit report titled Reviewing Tax Credits Awarded and Used Through the High Performance Incentive Program and Kansas Affordable Housing Tax Credit. It's a mouthful. The objective of this audit was to look at the amounts of those two credits that were awarded and used over the past 5 years. In terms of answers to the audit objective, we didn't report on the amounts of HPIP credits businesses earned and used because of data limitations, and I'll explain that a little more in a few minutes. But for the affordable housing tax credit, we found the state has awarded about $73 million in credits so far, and none of those credits have yet been used. I'm going to start out with some background information about HPIP, which starts on page 3 of the report. HPIP, or the High Performance Incentive Program, encourages businesses to make capital investments and train its employees. In exchange for doing these things, qualifying businesses can earn state income tax credits. A qualifying business can earn a state income tax credit based on its expenditures on employee training and education. A business's expenditures must exceed 2% of its payroll at a specific work site to qualify for this credit. The business earns a credit equal to the portion of its expenditures that exceed 2% of its payroll at the work site. Additionally, a business can only earn up to $50,000 of this credit each year. The credit can't be carried forward, it can't be transferred, and it's not refundable. Qualifying businesses can also earn state income tax credits based on their qualifying capital investments. Businesses that spend more than $1 million on capital investments in Douglas, Johnson, Sedgwick, Shawnee, or Wyandotte counties can earn a tax credit equal to 10% of the portion of their capital investments that exceed that $1 million threshold. For businesses in other counties, they earn the tax credit equal to 10% of the portion of their investment that exceeds $50,000. To earn either credit, a business has to be certified by the Department of Commerce. By certifying a business, Commerce is basically declaring that they do meet program participation criteria. Businesses are then generally going to work with the Department of Revenue or KDOR to claim their tax benefits. Insurance companies, however, will work with the insurance department to do that. Starting on page 5, we discussed the data limitations that prevented us from reporting on how much credit businesses earned and used. For this audit, we reviewed 3 HPIP data sets. KDOR gave us 2 of those data sets as part of the audit, and we had a third one from a prior audit we did. The data sets overlapped for a couple tax years, so we compared them to make sure that we were using accurate data. What we found, though, was those data sets weren't consistent with each other. So, for example, for tax year 2019 specifically, one data set, the one we had from a prior audit, showed businesses earned about $900 million in HPIP credits and used about $90 million. A second data set that we got as part of this audit showed businesses earned about $230 million and used about $110 million. And the third data set showed businesses earned about $160 million in HPIP credits and used about $100 million in HPIP credits. Again, that's for tax year 2019 specifically. But because those data were inconsistent, and because this was a limited scope audit, which means we're limited to 100 hours of work total on it, we could not determine what the actual amount of HPIP credits earned and used were, so we didn't report on that. It would take a full audit for us to adequately verify that KDOR's data is correct. We did talk with KDOR officials to understand what caused these inconsistencies, and they told us that the inconsistencies were due to a combination of data entry errors, tax system limitations, and the complexities of the HPIP program and the businesses that participate in HPIP. For example, Cador officials told us that some businesses that earn HPIP credits pass their credits through to their owners and shareholders, and that some of those shareholders even have shareholders of their own. Those people all claim the credits on their individual tax returns. Cador officials told us they have to manually track significant amounts of information to keep track of all of this stuff and then adjust their tax data to make sure they don't do things like double count credits. They told us that didn't always happen, and that's what caused the data issues that we saw. Cador officials told us they were reviewing their data for accuracy, so as part of this audit, we did recommend they continue to do that and then report to you all once they have corrected data. So those are my comments on HPIP. I would now then move on to the affordable housing tax credit.
Would you mind if we took questions on HPIP first before we moved on? Okay, thank you. Committee, any questions on HPIP? So I'm going to ask a couple, and I really appreciate your work on this, and I understand the department is, and is Kathleen here? She is here, great. So they are working on this still, and they are going to try to get us the data that is accurate by December, January timeframe. But in the meantime, these numbers are still interesting to me because we're looking at a possible, in 1 year, $900 million tax credit, $230 million tax credit, and or $160 million tax credit for 1 year. Any one of those numbers, even the smallest number, 160 million, is still, we're talking over $100 million possibly a year for HPIP tax credits that have been eligible and could be, I compare it to a checkbook, you guys, that the state wrote the check for the tax credit and it can be cashed within a 16-year period, correct?
That's correct, yes.
Yes. So what my objective in requesting this audit was, how much do we have on the books? How many tax credits have been issued? And how many could be, quote unquote, cashed in during a 16-year time frame? So we have to understand this as legislators when we're creating our budgets and with these finances. So that's what I'm trying to get my head around here with these numbers. I just wanted to give a little background there. So, committee, any other questions? Yes, these tax credits are transferable as of 2021 legislation. Any other questions? Seeing none? Okay. Representative Wolf.
Thank you, Madam Chair. Why 16 years? Do we have any idea why so long?
That is a great question. I don't know. This legislation did not come through Tax or Commerce again. Or maybe it did go through Commerce. It did go through Commerce. That's right. It did go through Commerce. So I'm not sure why the 16 years was picked. Do you know, Josh?
Well, I was trying to see if I had in the report information about when that changed. It looks like it was, this is on page 4, third bullet from the bottom. In 2011, the carry forward period for the capital investment tax credit increased from 10 years to 16 years. I do not know why that was.
Yeah, so.
Was it just giving them extra time to get their stuff together so they could use it? It just seems like so long to hang out there like you were talking about.
I don't know. Kathleen, would you be comfortable on that? Were you around during the debate on the expansion? Okay. I'm not sure why. I don't know if Representative Sawyer knows. Wonderful.
Thank you.
There were a number of companies that weren't going to be able to use their credits up in that 10, 11-year period, so it was expanded to 16.
And the transferability at the same time?
Well, the transferability was later. It was like 2021. Okay. But that's why that was increased from 11 to 16.
Okay. And then, Kathleen, if you wouldn't mind, I would like the committee to get a grasp of how difficult this is to track because of the transferability and the extended, it's created quite a scenario. Every time we pass and work on tax legislation, we tend to ask, what's the fiscal note? What's the cost going to be, or decreased revenue and decreased taxes? But it seems like when we're handing out these tax credits, we don't necessarily ask those numbers. And we need a real picture of what these credits are, how they're working, how they're not working. So could you kind of give us the pass-through entities and all the complications that you're looking at? Any other questions for Josh? Yeah, Senator Peck.
Thank you, Madam Chairman. So on page 6, this is something I was unaware of. It says that a business must be HPIP eligible in any year in which it wants to use carry forward, and then it continues to say, if I'm reading this correctly, and that's sort of where my question is, that a business can not be HPIP eligible, I'll just pick a number, 4 years, and then decide, well, we're going to have big tax liability. We want to be HPIP eligible this next year. And then they can become, as long as it falls within that 16-year period, is
No,
all
you're
this?
correct. I think that's one of the things that complicates this. A business could be eligible in 1 year, earn some credits, then stop being eligible, or at least not apply for the program, not use the credits for 10 or 11 years, then come back, get certified, say, hey, we want to use the credits this year.
As long as it's within that 16-year period from initial qualification of the credits, because they haven't expired. I'm going to use the word expired. Correct?
Yes, the carry forward period starts the tax year after the year in which the credits were earned. So you have that first year to claim them, and then an additional 16 years for a total of 17 years.
Thank you. Thank you, Madam Chairman.
Any other questions? Thank you, Josh. Kathleen, did you want to address that, and then we'll move on to the low-income housing? I keep calling it the low-income housing, but affordable housing. Thank you.
Madam Chair and members of the committee, my name is Kathleen Smith, and I'm with the Kansas Department of Revenue. You can see on, I think, on page 16 of the report, our response with regards to the audit, and it kind of details the complexities that we run into with this specific credit. First of all, our tax system is 25 years old. It was never set up to track these credits by location and for this long a period of time. So there's going to need to be some enhancements made to our tax system in order to probably get us to a point where all of the detail that we do is not by hand. A lot of the work that we do is by hand for this specific credit. Some other things that we run into, the pass-through entity on page 16 of your report, it shows kind of how complex the pass-through entities are. Over half the entities that earn the HPIP credit are pass-through entities. So in that means that the pass-through entity files their tax return and fills out the Schedule K-59, which is the credit schedule, and then each shareholder, member, or partner has to fill out a K-59 as well and submit it with their tax return. Now, some of those partners, members, and shareholders are pass-through entities themselves. So then we have to track the next level, and then those could be pass-through entities as well. And just the simple illustration on page 16 kind of shows you how it can get very convoluted very, very quickly in how we have to track those shareholders. And then, again, with the pass-through entities, those members don't stay the same from year to year to year, or their percentage of ownership changes. And so we're having to track for each specific credit earned that those shareholders for that specific year throughout the 16-year period. So that adds something else. Again, the 16 years is a long time, and for us to be able to track that, again, tracking that by hand at this point is very onerous on us. Let me think what else there is. A transferability that has added another level of complexity as well, because now they can only transfer 50% of the credit. So again, we are tracking the first original owner, and then now we have to track who they have transferred it to ensure that they don't use the credit in more years than is available. So those are just a few things that we have to, that we've run into, our challenges, I guess, with tracking the credit. When we review this, again, this just kind of gives you an idea. When the return comes in, we have to ensure that the taxpayer is actually certified, that the Department of Commerce has actually certified that worksite. They issue all of those certification letters to the company, and we get a copy. So we have developed a spreadsheet, an Excel spreadsheet, that shows all of the entities that have been certified, and they have multiple locations in many respects, and then they're certified for a number of years. So we've got 6,000 entries in this specific Excel spreadsheet. Bundling that down or going down into one level as to the number of entities that can actually be HPIP certified or that are HPIP certified, there's around 1,200 entries. 1,200 entities are HPIP certified. Now, that could be prior years, and that can be current as well. So we have to verify that they have actually been certified. So we go in and we look at that database. Then we look at the K-59. We have to ensure that all the data that the entity has provided is correct. Pass-through entities, we're matching the shareholders and members and partners with the pass-through entities return to ensure that everything is the same. Again, those pass-through entities do provide just a little bit of a challenge for us. Then we also have to review our tax processing system to ensure that all of the information that has been entered electronically or by our people have keyed the entries in, everything is correct and is matching what the return is showing as well. So now there's another review. Then we've got to track the credit. Because of the number of years that we're looking at and because of the pass-through entities that we have involved in the program, we have an Excel spreadsheet for each one of our certified entities. And we have to manually go in there and the spreadsheet will provide the amount of training and education tax credit that has been earned, the amount of credit that has been used. It also displays the amount of investment that the company has made, the amount of credit earned, and then the amount of credit used. So we are, and then, I'm sorry, there's so much.
I think you've given us the picture that we need. It's very much appreciated. And the two items are the transferability and the 16 years created unforeseen circumstances. And so I think we need to look at this program as a legislature. And one of the questions that I'd asked, and I'll ask here, is would you mind taking a look at other programs and see if we also need to maybe address some of these issues? Because as a state legislator, we need to know, to me, these are expenditures of the state. And so we need to know where we're at with our expenses in order to be able to get a good picture of where the budget is.
Yes,
so
yes, we can do that.
That's what I'm looking at from these tax system.
And one thing, just to repeat what has already been said, but we have dedicated one staff member to go through each one of these companies to ensure that all the data that we have is accurate, complete, and up to date. And we do hope to have that review done by the beginning of this next calendar year.
Which is much appreciated. I know it's a heavy lift, so thank you. Committee, any questions? Senator Klemp.
Thank you, Madam Chair. And thanks for that information. You mentioned that there was some expense required to track it systemically versus in writing or versus manually. Do you know what that looks like?
I'm not sure that I understand your question, sorry.
Update software so you can track it systemically.
we are looking at system enhancements. I know that we're reviewing our reporting mechanism as well. If any system enhancements are made, we have to do it within a limited time because of our reporting, our tax reporting season, and then the extended tax reporting as well. So we've got a very limited time. We've talked about it for many, many years. At this point, we just have not had the resources or the time to be able to really fully look at this.
I appreciate it. Thank you.
Representative Sawyer.
Thank you. I appreciate the work you guys are doing to get these numbers. I think it is important that we have the numbers for this program. And I said the numbers could be huge once we get it all. So thank you for what you're doing.
Representative Turner.
Thank you, Madam Chair. Say, I'm just trying to go through here to find pieces. So this, the credit was created in 2022, is that right? The KAHTC.
Okay,
according to this.
That's the affordable housing tax credit
Right.
that we're talking about, the HPIP right
I
now.
know, there's two pieces here, so
Yep.
I was just
Yep.
trying to, so that was created, and that's not problematic in terms of tracking, because we are talking about HPIP, right?
We are talking about HPIP. With the affordable housing tax credit, we have not had any taxpayers actually claim the credit at this point, so we don't know what that's going to do for us.
And HPIP was created when?
In 1993, I believe.
93, okay. And so it's just become more problematic since it has taken the transferability? Because
No, what
I'm
created
trying to
the,
understand, if it's been out there since 93.
if I may,
Thank
Representative,
you.
nobody's taken a look to see what the expense was of this program since 1993. They've just been letting it operate. And a few years ago, Legislative Post Audit did an audit, and that brought it to my attention. And ever since then, I've been trying to get my head wrapped around this. And so I requested a follow-up audit. And then we found out what we did, what was presented today. And so hopefully we'll have some numbers that we can all get our head wrapped around. So no, the program's been inception. We don't know. We don't know because it's not been tracked to this degree in the past.
All right, well, thank you. I was trying, yeah, because it
Yeah.
talks about, the original question was in the last 5 years. I was trying to understand the entirety of it. And typically in a fiscal note, KDOR puts in costs to adapt systems for programs, and I just wondered if that was there. Thank you.
No, that's fine. And if you have a question, I didn't want to interrupt. I just wanted to give you the background so that you knew what was going on. If any other questions? No? Okay. Thank you very much, Kathleen, and thanks for your work on this. Yeah. Thank you, Josh. Since we've disposed of HPIP, we'll turn to the next audit.
We will go on to the equally, perhaps more complicated Kansas Affordable Housing Tax Credit, or KAHTC. Background information for this one is going to begin on page 7. So this credit was created in 2022. It is a state tax credit that matches the federal low-income housing tax credit, if that sounds familiar to you. Both of those credits are administered by the Kansas Housing Resources Corporation, or KHRC, and are meant to subsidize the development of affordable housing. KHRC awards both credits through an application process. Housing developers apply to KHRC for credit awards. The developments that receive those awards are going to sell, for lack of a better word, sell those credits to investors in exchange for investment in their housing developments. That helps those developers reduce their development costs, which in turn lets them charge lower rents to tenants, which is how this tax credit is supposed to provide more affordable housing. The investors then take their credits and use them to reduce their state income, premium, or privilege taxes dollar for dollar. So when investors use their credits, the state is foregoing tax revenue. The affordable housing tax credit is neither transferable nor refundable, but it can be carried forward for up to 11 years. Additionally, the affordable housing tax credit works differently from other credits you might be familiar with. Affordable housing tax credit awards can be used annually for 10 years. So if a housing project receives a $1 million award, the investors that receive those credits get to claim them every year for 10 years. So that $1 million award represents up to $10 $10 million in foregone tax revenues over 10 years. Additionally, because KHRC makes annual awards, the potential foregone revenues can kind of stack up over time, and I will talk about that and share a figure with you all that kind of explains how that works here in a few minutes. But first, figure 1 on page 9 shows the amount of credits KHRC has awarded since 2023. Like I said, the credit was created in 2022, and 2023 was the first year in which KHRC made awards. As that figure shows, KHRC has awarded almost $73 million as of August 2025, so over 10 years, that's about $730 million in potential foregone tax revenues. However, as Kathleen just said a few minutes ago, no investors have yet used their credits to reduce their tax liabilities. And that's because investors can't use their credits until the development projects those credits were awarded to are completed and available for tenants to occupy. KHRC told us that 2 projects were recently completed, and as those projects all come online, we expect investors will begin to claim, or that is, use their credits. Over the next couple decades, investors' use of this credit could result in as much as $1 billion in foregone state tax revenues. So let me try and explain where that number comes from. Like I said, KHRC has already awarded $73 million in credits. Recent legislation from the last session limited the amount of credits KHRC can award this year and in future years. So the limit for 2025 was $25 million. KHRC has already awarded about $17 million, so they've got $8 million left for this year. Then in 2026 through 2028, they can award $8.8 million each year. So if you add all that up between when the program started in 2023 and when it is set to sunset in 2028, KHRC may award about $100 million total in credits. And because those credits can be claimed annually, every year for 10 years, that's about potentially $1 billion in foregone tax revenues. I would note, though, that estimate only considers the potential foregone tax revenues due to investors' use of the credit. It doesn't include any possible returns, such as tax revenues due to incented economic activity that KHRC officials told us might offset the credit's costs. Now, figure 2 on page 11 helps illustrate how the state may experience the foregone tax revenues I've been talking about, and it also helps illustrate that stacking effect I mentioned. So I'm going to try and take a few minutes here and walk you through this figure. So you'll see in 2026, there's a dark blue bar labeled 25.3 million. That bar signifies the awards that KHRC made in 2023. In this figure, we're assuming it takes about 3 years for those projects to be constructed and for investors to start using their credits. So we're estimating in 2026, investors are going to claim about $25 million in credits. They're going to do that every year through the end of 2035. Then, starting in 2027, we're assuming that investors use credits that KHRC awarded in 2024. That would bring the total foregone revenues in 2027 up to about $56 million. So 25 in 26, 55, almost 60 in 27, and then so on and so forth as those credit awards stack up until 2031 through 2035, be annual foregone revenues of about $110 million a year. If you add all those numbers up, should get a total of about $1 billion in potential foregone tax revenues. So that's trying to illustrate how that stacking effect I mentioned works. I should mention, though, this figure does make a variety of assumptions. Like I said, it assumes investors are going to take about 3 years to start using the credits. It assumes investors don't carry forward any credit, and it also assumes that there are no issues that prevent investors from claiming their credits. If those assumptions don't hold, then the actual foregone revenues may be different, or they may occur in different years from what we've estimated. And as I said, the credit awards will stop after 2028 under current legislation, but investors will continue to use the credits they were previously awarded. I believe that's all I had to say about the KAHTC. KHRC did respond to this audit. Their response begins on page 19, if that's something y'all are interested in reviewing.
Thank you, Josh. Committee, there is quite a bit of information on the back pages to pages 20, 21, and then a list of, builders and projects for your information. Are there any questions for Josh? Okay, Senator Peck.
Thank you, Madam Chairman. I suppose it may be for our post-audit, but I was unaware, I don't know if I'm the only person on the committee, that the Kansas Affordable Housing Tax Credit is for creation of rental housing only, apparently. Is that correct? And the program is for rental only? It's not for building homes that are then purchased and occupied?
The housing has to begin as rental housing. There is a homeownership conversion option that I believe is available after 15 years, but my understanding is the developments that use this credit, they will be rental housing for 15 years at least.
So I, Madam Chair, was not aware that we're dealing with rental, and I can see some games being played with that, but maybe not. But anyway, that's informative to me, so I won't ask any additional questions at this time, but I'm not certain that a lot of Kansans are aware that it's for rental housing only as
No,
well.
Senator, you bring up an excellent point, and I think when the legislation was debated and passed, it was not mentioned that it was rental either. I don't know, though. You guys have heard me say this. I say it quite often. This legislation came through Fed and State, not through the Tax Committee and not through Commerce. I think we would have seen a different product coming through one of those two committees. But one of the other things too, Josh, I really appreciate the graph that you put together on page 11, and it tops out at 107 million, but one of the key points to that is if, as you stated, that's assuming that they don't carry the tax credits forward and use them up. So there could be a higher cost in a certain year if those credits are carried forward and used at the same time frame.
Yes, there are a lot of potential ways you could arrange the numbers. It could mean that the costs in one year are much higher than in another. We don't know what's actually going to happen because no one started using these credits yet. KHRC officials told us they were fairly confident they were going to be used, though, because investors are essentially buying them.
So what is the carry forward time frame and the transferability?
So this credit is not transferable, which maybe seems a little confusing because I talk about people selling these credits. It's not incorrect per se, but what's happening is the developer gets the credit award and then they're partnering with investors and then distributing the credits amongst themselves in exchange for putting investment into the pot, if you will. So the credit's not transferable once it's resting with an investor, if that makes sense.
Not really, but okay.
With regard to the 11-year carry forward, though, the 11-year carry forward applies, it starts the tax year after the year in which the first credit in that 10-year credit period is claimed, and then it applies to all of the credits claimed in that 10-year period. So what that means is, if I'm an investor and I'm claiming my first credit in 2026, my 11-year carry forward is going to start in 2027. It's going to tick down and then apply to all of those credit claims. So I have a total of 12 years to claim my first year of credit, but I think only about 2 or 3 to claim my 10th year of credit because that 11-year carry forward that applies to my 10th year of credit started counting down a lot earlier. Does that, a lot of numbers, but does that make sense?
Yes, it does. And actually, I know this is going to be a little bit to ask, but could you put together what, if all of the carry forwards were carried to their maximum amount and what we could end up with in one of those years, in the ending years, because they have to use them or lose them right towards the end.
Yes.
And so we're looking at a considerable, I mean, 107 million, I think, is a good, probably an accurate picture, but I want to know more of a worst-case scenario is what I'm looking for. What could we be looking at if the carry forwards were carried through 8 to 11 years? I don't know if that would be an extra, you would have a better idea of what.
I think that's something I can take a swing at. We'll see how it goes.
Okay, just, yeah, you kind of see what I'm looking for. What are we on the hook for here? Yeah, I don't want the maximum, but I guess that would be the best. suggesting the maximum liability. So yes, overall, we're looking at over $107 billion is what we're looking at right now, combined, right? Is that what your statement was?
Sorry, what's your question?
No, I'm sorry. That was 1.7 billion, not after.
Yes.
Yes, okay. So for a total?
Yes.
Okay. Representative Wolf.
Thank you, Madam Chairman. So I'm coming late to the table with this, so I'm not sure, but this is low-income housing. So is there an amount of rent they can charge? So they're getting this credit, plus they're also going to get rent. Are we capping that rent so that it can only be so much? Is it based on income of the people living in there? I mean, how does that work?
All right, so I looked this up this morning, so grain of salt here, but
Yeah, thank you.
for it to be low-income housing, it needs to pass one of 3 tests, and the development has to commit to passing this test for the duration of its compliance period. The first test is called the 2050 test. 20% of the units have to be rent restricted, and the occupants have to have incomes of less than or equal to 50% of the area median gross income. The second test is the 40-60 test, in which 40% of the units have to be rent restricted, and the tenants have to have incomes of less than or equal to 60% of the area median gross income. And the third test is the average income test, in which, if I understand this one correctly, 40% of the units have to be occupied by tenants with incomes of between 20 and 80% of the area median gross income, and the overall average income of those tenants needs to be less than or equal to 60% of the area median gross income. So lots of percentages there. And then I said the term rent restricted. A unit is rent restricted under federal rules if gross rent is less than or equal to 30% of the income limitation applicable to the unit. So the short answer there is it really depends on the area in which the unit is located, its area median income, and some other additional rules that KHRC may impose on these developments. Since I just told you about the baseline federal rules, I think KHRC goes above and beyond that.
Senator Klemp.
Thank you, Madam. More of a question for the chair. Sorry. Because I have a question it's more maybe a question for the committee. So we have this, this 10-year chart that we're seeing here. Is there anything that we can do to change this at this point, or is this just where we're at?
That is a good question, and yes, there is. The House attempted to change, they did change this drastically by the legislation that was passed into law, but they attempted to even draw it down to a smaller number. So yes, we can look at it, and you may want to address that.
So the potential foregone revenues associated with the awards that have already been made, that is 2023 through 2025 to date, those are locked in. Can't say exactly when those will occur, but they will likely occur at one point or another. The awards that KHRC has not yet made could be adjusted if you all passed additional legislation.
And that's through 2028?
Yes.
Yeah, and that's the last 2 years are $8 million. Is that right on credits?
It's 8.8 million in each year of 26 to 28.
Thank you, Madam Chair.
Yes, we're locked in. I don't think we could make it retro for 26, but yes, but it is something that could be considered. Any other questions for Josh? So committee, Ryan Vincent is here from KHRC, and I got to tell you, you couldn't have anybody better in that position. He is so enthusiastic about housing for Kansas, and I just appreciate it so much. And we decide the tool sets or provide the tool set, and Ryan runs with it. So Ryan, did you want to say anything or just thank you for being here? Yeah, so you guys don't hesitate to reach out to Ryan if he can help you. I know he will. So thank you. Representative Smith.
Thank you, Madam Chair. And I didn't really have a question. I just kind of had a comment, and maybe perhaps Eddie can correct me if I'm mistaken here. But, you know, as these credits, whether it's HPIP or any of these are earned, they're not deducted from our actual receipts, even though they are kind of on the books. last year we passed the income tax trigger. There is a scenario where, you know, a lot of, you know, hundreds of millions of dollars could be claimed or earned, but with the provisions that we put in that income tax trigger, we could exceed revenues, the income tax rate could get bought down, and then a lot of these things could be claimed, kind of putting the state in a difficult situation. So not to throw another wrench into the complication of this policy here, but you know, that's another problem we have with deferring the benefits to this, especially out to 16 years. We never know in any given year what might be claimed and what the state would be on the hook for.
Eddie, did you want to address that?
The only thing I would say as it relates to that is when we do the revenue estimates, we of course do have a conversation about what are our sort of outstanding obligations as it relates to this. But of course, we also don't forecast out anywhere near that far into the future as a part of those estimates. We as a matter of law, estimate the current and one following year. Obviously, in our office, we prepare 5-year budget profiles, and the way we typically handle things like this is that we use a growth rate for the associated taxes that is lower than what we might otherwise expect, basically, such that if we imagine that this is going to primarily hit corporate income tax and our actual, you know, long-term growth rate on corporate income tax is 3.5% per year on average, we might deduct a 1/4 point off of our assumed growth rate for something like this in light of having a policy like this built into our long-term horizon.
Right, but I guess what I was thinking of was the language in the income tax trigger bill that functions off of the actual receipts, not necessarily consensus revenue, but
the tax receipts, the provision in SB 269, which I guess now has a KSA number, although I don't know what it is, but that doesn't have anything to do with any discrete policies. It is just what actual receipts attributable to those specific 3 tax sources are.
And I do know that we've seen numbers from research as to how much has been collected or turned in or cashed in on the HPIP tax credit before. And if I remember correctly, it was about $300 million a year is what were in the sheets that were handed out during tax. You may want to look that up. And so I do know that you look at this information. But as far as the number, what's out there, hanging out there and could come in, that's what got my attention, is to where are we at as a state. So any other questions? Seeing none? Okay, well, thank you, Josh, very much. And again, thank you, Ryan, for being here. Committee, we're going to turn our attention to the next item, and then after that, we'll take another short break. But we have local sales taxing authority apportionment. Eric? Yeah. Eddie, do you mind?
Yeah, the only thing before Eric gets started that I was going to mention is you do have in your materials a packet of data provided by the Department of Revenue on countywide sales tax apportionment. They're here to field questions on that if you'd like, and it might be something that you might have questions for a future meeting on, but we didn't have them to present specifically on the agenda. But I just want to make sure you know that's in your packet.
Thank you, Eddie.
Madam Chair, members of the committee. Eric Adell with Kansas Legislative Research Department. Property tax has been around since Kansas was under territorial administration, but the sales tax is a little bit newer. The state sales tax dates to 1937, but it wasn't until 1970 that local units of government were allowed to levy sales taxes. And after their initial enactment, that was briefly repealed for a year and then reinstated in 1973. And just as a note, when talking about sales taxes, I'm also including the imposition of use tax, which is automatically imposed by entities that are levying the sales tax. And so for this, it's just treated as a component of sales tax, even though when I refer to sales tax, I'm referring to both sales and use tax. The statutes relevant to local tax authority with respect to sales tax are in Chapter 12, Articles 187, 189, and 12-192. Those are there just for your reference. But all local taxes sales taxes require approval at an election prior to being imposed. Statute provides for ballot requirements, but any change of rate in a local sales tax requires a vote, although repeal can be accomplished by either an election or adoption of a resolution. And the ballot language has to specify the purpose for which the revenue from the sales tax is to be used. And for countywide sales taxes, the method of apportionment, which I'll discuss briefly here in a minute. But for purposes of administration, the state administers the local sales taxes based on the same tax base that's in the state sales tax. And for reference, the state sales tax is levied at a rate of 6.5%. And then local sales taxes vary depending on the unit of government that is levying the tax. So cities are allowed to levy up to 2% for general purposes and an additional 1% for special purposes. And they must be, they're required to be in increments of 0.05%. And the purpose for special purpose taxes has to be specified in the ballot language prior to the imposition of the tax. There's a time limit on special purpose taxes in statute. They have to expire within 10 years, but they can be reauthorized with an additional election. For counties, counties can levy up to 1% for general purposes and an additional 1% for healthcare purposes. And county taxes are levied in increments of 0.25%. Exceptions for any additional authority must receive special legislative approval. So, might be familiar with proposals where counties come to the legislature to request additional authority for sales tax. HB 2275 last year was one example of that, where Finney County and Pawnee, came and requested additional taxing authority for a particular purpose. Those authorizations are all explicitly listed in statute for that additional county authority. And then there are also special taxing districts. There's kind of two kinds. Community improvement districts are levied by cities up to 2% for purposes of funding economic development projects within the district. And then transportation development districts can levy up to 1% to fund transportation infrastructure projects. And both of those are established through petition process of the owners of the land that are in the district. So they tend to be more localized, and there can be many districts within a particular city or county. Sometimes the community improvement districts and transportation development districts can overlap. So there are a handful of instances of those. And there is only one case where an overlapping community improvement district and transportation district both levy the maximum tax rate. So the combined rate for those improvement districts is 3%. And then there are also a few named kind of special entities that are given specific authority in statute. One example that's recent is the Gage Park Improvement District. So that's like those community improvement districts, except that it has its own specific authorization in statute. And there are 4 of those. But so when sales taxes are levied, the kind of end result depends on where you're at, but the sales tax, the total sales tax that you pay is a combination of those different rates. The city, the county, and any special districts combine to give you the rate of sales tax that you pay in those locations. There are, from our count of Department of Revenue, their publication on the current sales tax rates, there are 691 local taxing jurisdictions where a local sales tax is currently levied. And the local rates range from 0.5% to a high of 5% as a combination. And so the highest sales tax rate in the state is that 5% combined local rate in addition to the 6.5% at the state rate. And the average combined rate among local jurisdictions is 2.78%. There's a table there just to give you an idea of the number of entities where these taxes are and what the highest and lowest rates are and the average rate for those jurisdictions. So in terms of apportionment, when talking about sales taxes, apportionment is just referring to how the revenues get distributed. So primarily this refers to countywide sales tax. So when a tax is levied for county purposes, there are 3 different ways that apportionment can occur. And the primary way is by a formula where the revenues are distributed between the county and the cities within the county. And that formula, half of the revenue is distributed according to population. So the population of the counties as their proportion relative to the county, and the balance of the county, if that makes sense. So the revenue is apportioned based on the proportion of the population of the respective portion of the county. And then the other half of revenues are distributed according to relative proportion of property taxes levied. Some sales taxes that have a dedicated purpose can be, the revenues can be retained by the county, and that is specified in the ballot language when the question is asked of the voters. And then current law also provides for a third apportionment option where local entities can have agreements among themselves for how the revenues are apportioned. Just in terms of recent consideration by the legislature, this topic came up last year in a couple of different bills, but also in 2023, the Special Committee on Taxation considered this issue and discussed sales tax authority and made the recommendation that the legislature should introduce and consider legislation to simplify the process for local sales tax adoption with an emphasis on control of the voters within the taxing district rather than by the legislature. Included within this recommendation is making the countywide sales tax limitations identical to the city sales tax limitations. In 2019, there was a bill that would have authorized counties to impose a 1.25% sales tax for special purposes in addition to the 1% general purpose authorization. Would have made special purpose taxes not subject to apportionment. So all the revenue would have been retained by the county, and any of those taxes would have been made to expire no later than 10 years from the date it was first collected. So that proposal is kind of more akin to the way that cities collect sales taxes currently. Last year, in the 2025 session, there was legislation that would have modified the apportionment formula. There was some testimony to the effect that there's there's an incentive or a disincentive for county governments to reduce property tax revenues because the half of the apportionment formula that is based on the total amount that's levied means that if you are to reduce property taxes, then you would also be reducing the relative proportion of the sales tax that your jurisdiction would be receiving. That legislation was not passed, but we ultimately passed HB 2275, which included a provision that froze the apportionment formula to the basically the ratios that were in effect during the previous tax year. And so any changes that occurred in terms of the property tax didn't affect the actual apportionment for taxes during tax year 2025. And then just going to review a few different sort of policy considerations that you all may want to think about as you consider legislation with respect to this issue. There's the relationship between county and city sales tax authorization. So you might want to ask whether county sales tax authorization should mirror city authorization in certain ways, whether with regard to the limits in terms of the rates, the 10-year limitation for special purpose taxes, or the increments that are required to be used. So counties and cities have a different requirement for the increments. The apportionment basis, should revenue from county sales taxes always be apportioned among the counties and cities by formula, or should it be allowed to be dedicated to the county? Should there be a third option that is currently in statute? Could tax be dedicated based on ballot language? So could the language itself dictate whether or not the tax was dedicated? The current law doesn't provide for dedication without specific statutory authorization. And then in terms of ballot issues, should notice of ballot questions or results, or both, be required to be reported to Department of Revenue? So currently, the Department of Revenue is aware of additional taxing authority because the request is being brought to the legislature. So absent that, there may be any need for Department of Revenue to have that information reported to them when a taxing jurisdiction is intending to impose additional sales tax authority. Could the ballot language allow for rate reductions without an election if the funds generated are more than necessary for special purposes? Should any ballot language requirements be added that reflect any changes to the law? So any changes that are made should be considered in terms of whether there need to be changes to the ballot language. And then should countywide sales taxes be required to have an endpoint? So you could require them to have a specific date for expiration, or they can be terminated when the debt is repaid. So those are limitations that are currently included in the statutory language when counties request authority. A lot of them specify how long the tax is going to be in effect for. And then again, with the increments, do you want counties and cities to have the same required increments? Could the tax be repealed entirely in the future without requiring an election? And then currently, the process of legislative authorization provides a restraint. It's a kind of check and balance that allows the legislature to review the authority that is being exercised. But if there's repeal, there may be some interest in providing some alternative check and balance on that authority. something like the revenue neutral rate appeal procedure to the Board of Tax Appeals is one possible model. But with that, I'm happy to stand for any questions that you may have.
Thank you, Eric. Committee, any questions? Committee, just a little bit of background on this. The House brought this issue to us last year. What we found out is that the sales tax distribution equation is using the mill levy. So this goes along with that, and we appreciate them bringing that to us. And so what we did was we froze the equation for 1 year so that locals could lower their mill levy without being penalized. And our objective is to get the sales tax equation off of the mill levy. So I had requested Eddie put in the handout that you'll see from Amy, and it is 3 different scenarios. Eddie, would you want to speak to that a little bit?
The only thing I would offer is that the first, let me actually have it in my hands. The first scenario listed there is HB 2377, which was the bill that the House Committee initially considered last year on this topic. Here's the document, and the way this table is laid out is you can see, and it's detailed, and it goes through every single county in the state and every city within that county. So if you want to, the county, they're in alphabetical order by county. If you want to go to your home county and glance, the first column is the current law. And you can see, I'm just looking at the first page, Allen County. You can see that Allen County, the county of Allen County gets 52.3%. Iola is the largest city in Allen County. It gets 28.7. Humboldt gets 11.7. The other smaller counties get their fractions, as you can see there. The next 3 columns are what the amount that they would get under 3 different alternatives to the current law. The first of those being HB 2377 as introduced. I thought that was probably the most obvious and appropriate one to have in front of you all, and it's one that I believe the House Committee had asked for before taking action upon the bill, and so that's there. The next one is an alternate version, and these latter 2 are just so you have other options. They're ones that I came up with, and it is population only, since we have population as a 50% factor currently, and the property tax side of it is where the discussion of whether or not it is the right incentive. What would it look like if the population factor were the only factor you used? And so that's just for information, for your consideration. The last column there is actually, and I need to apologize, this is my fault for miscommunicating what I intended the last option to be to the Department of Revenue. But this is a version where the cities receive 50% based upon the population, and the county receives 50% based upon population, and the other fraction of it based upon the valuation, but only considering the counties, to where the counties look like the big winners here. I miscommunicated with the Department of Revenue in terms of how I actually envisioned that one, but it is another alternative, and so what I was envisioning really is not that material, so it works just as well for your purposes, just to see other options. The latter 3 columns just reflect how those ones differ from the current law, the 3 kind of alternatives. So that's what that is, and you can see it in detail for the entire state if you're interested.
So committee, what I would like to see is that we remove it from the mill levy in the future, and that we look for a more stable value number to base those distributions off of. And since the House did bring this to us, I know that the chairman's willing to continue in that effort. Would you like to? Yes, Representative Smith.
Sure. Yeah, and this is something that I've been trying to ponder and work through since we had the bill introduced last year. Eddie, if I could just, because what I was envisioning was to use population and valuation, and I want to make sure what I'm looking at on this chart. If we have, for example, County A that has city number 1 and 2 in it, when you look at the population data, the population that's counted for the county excludes the cities. Is that correct?
Yes, that is specified in the statute, that the population piece of this for counties is the population of the unincorporated area of the county, I believe.
Okay, now I was intending, instead of using the mill levy, basically their ad valorem budgets, to do the same thing with valuation, to where the county valuation less whatever the cities were. Is that what you've got in column
That was
3
what
here?
that was what I intended to communicate to the Department of Revenue with that last column there. But I want to be clear, this was not their fault; it was mine. I did not make that clear in trying to get that. So I think that for a future meeting, we can get that version of it to you.
I would love to see those numbers, because that's where I was going with this and drafting the bill for next session. So I think we're kind of on the same page there, so it'd just be interesting to see what the numbers look like.
However, it is possible that is what the HB 2377 as introduced data listed here is. But either way, I think that for a future meeting, we'll clarify exactly what that is and circle back.
So Eddie, would you clarify what that third column again is? The header is population with county valuation only, but what is it actually that we were looking at?
So taking a step back might actually help. We describe it as a formula that uses 50% population and 50% valuation. The way it's written in the statute, I believe it is actually 50% of the revenue divided according to population and 50% of the revenue divided according to the mill levy, or the amount of tax to be levied is probably how I ought to phrase that. And so this divides 50% by population, and then it divides the other 50% according to the valuation, but only for the county valuation. And so the county is in essence, I believe, getting the entirety of that 50% under that column.
Okay. Senator Klemp.
It's more of a question for Representative Smith. So your thought is it streamlines, it takes out mills and streamlines the process. Is that the goal of what you're suggesting?
Yeah, because really the goal, before we froze this, under current statute right now, you're rewarded with more sales tax revenue if you increase your budget. So we're kind of rewarding the opposite behavior. We want to incentivize, good conservative budgets, and hopefully by focusing this more on, if you do just on population, it really skews things. If you would include a factor of some valuation in there, and maybe it's not 50-50, maybe it's 60-40, I mean, whatever that mix looks like, to look like it's fair. But it's my intention to keep another factor other than just population in there, and valuation seemed like a logical factor, but certainly open to other ideas or
That's great. Yeah, I appreciate it.
weightings.
Yeah, I don't know, we were going to take a look at other states or other, I know, maybe that's an idea, just to look at other distribution methods. I appreciate the valuation, I'm just skeptical of, I thought somebody was, they knew where I was going and was telling me to shut up. Sorry. I appreciate you guys looking at that, and any ideas would be wonderful. Yeah, so. Any other questions, comments? Okay. Sedgwick County is here. Would they like to make a comment?
Thank you, Madam Chair, for allowing Sedgwick County to be here. Again, that's Wichita. I brought with me our CFO of Sedgwick County, Lindsay Poe-Rousseau, and our Assistant County Manager, Tanya Cole. So if we wanted to, there was a lot to unpack in that previous summary. And then you all have a pretty good grasp. Representative Smith, thank you for supporting the freeze. So we submitted a letter, I think you all have a copy of it, just to cut to the chase, because you've covered a lot here. It really is in what would impact currently without the freeze is really summarized nicely in the second paragraph, to where Sedgwick County, as a commissioners, this is the third year in a row that we have not captured all of the assessed value growth, and we could have captured 8%, 8.5% growth is what we could have done this year for next year's budget. We took about 4%, so we took about half of that. So as you all have said, what would have happened in Sedgwick County's case, every 1% that we didn't capture would have cost us $180,000 less in sales tax revenue. Again, that sales tax is one pie, and it's just divided to make sure that pie is all distributed. So us lowering ours would allow $180,000 per 1% to go to the other 20. There's 20 cities in Sedgwick County. I think a couple of them have caught on board and lowered their not agreed as well to their to take all the assessed values. So if everybody would not take it, then the current formula would work fairly, but some of them are not. And so 4% that we didn't take, as the letter says in the second last line there, it would have cost us $720,000 in less just in 1 year. And then, of course, we didn't do it the year before and the year before. So we are in lockstep with the states, with all of our citizens and our businesses about property taxes, and we're trying to do whatever we can, and we're encouraging all of our cities in Sedgwick County and the school districts and the taxing authorities to follow along. But it's a little bit of an uphill pull, but we're making some progress. At least we're doing what we can on our side. So listening to the options on the last part of the presentation, in the third paragraph, we've done some calculations, and we believe the population is fine for half of it. It's the other half that's skewed, skewed. That's without the R. And so the assessed, but we would propose supporting, including the assessed value of all of the cities in the county as the option. We kind of did some calculations, and it would kind of fare everybody. A couple of the cities in Sedgwick County would lose a little bit. A couple would gain some. But at least it would be what we think is fair and a good option. So we get a little bit of dialogue. We have a great relationship with all the cities. But as most counties, the county has the jail, the county has 911, county has ambulance service, county has the judicial court systems. So the county does a lot for everybody, and we can't lose respect. Can't lose that perception, and that's we're all in this together. And thank you, the state. You all lowered your 1.5 mills last year, and I think we're all pointing north in the right way. And but this is a flaw in that sales tax formula that we would appreciate moving forward. We've got a lot of value that we think we could bring if we wanted to discuss further options, especially you, Senator, and Representative Smith, if we'd be glad to do so. So thanks for letting us at least share our. Did I forget anything too much? Okay, all right. I'm the elected person, though, the smart person.
Well, thank you. Thank you for being here today, too. I do know the handout is kind of interesting, and I don't want to put Eddie on the spot here, but the Sedgwick County numbers are considerably less with the bill that was proposed. And so we want to be very cautious going forward. I don't know if you're aware of that or not.
Well, when it was talking about that, we're doing some emergency looking to see what are all these columns saying, because we had not seen all that yet. But we're glad to digest that and follow up and officially comment, unless you. I can speak now. Yep, we've got. Can the CFO come up?
Welcome, and please introduce yourself. Yeah.
Thank you, sir. Thank you so much, Madam Chair and committee. My name is Lindsay Peruso. I am the Chief Financial Officer for Sedgwick County. So a pleasure to be with with you today, and thanks for letting me speak. So yes, as written right now, we have noticed that that would be significantly detrimental to Sedgwick County. And so I think what we were hoping we could look at, and this would be a bit unorthodox, and I recognize that, but because right now the formula takes all of the individual property tax levies and adds those up and then divides based on your proportion, we would basically like to have credit for the full assessed value for the county, much like we get credit for our full property tax levy today. So essentially, if you looked at the formula, it would almost be like assessed value is twice. The total assessed value is twice. So if it was Sedgwick County, we've got about 7.5 billion of assessed value. If we only look at that portion that's in the unincorporated county, that's where you get those smaller figures that you're seeing today. So I don't necessarily have a better alternative other than essentially doubling the figures, but that could be one way to look at it in order to maybe not have such a detrimental effect. But I do realize it's unorthodox and probably hard to explain.
And then I would add, I'm reminded that if you did the assessed value process, that would take very little administrative work because it's already done and on file, and that's the.
Yeah, my concern with assessed values, well, pay attention to the presentation tomorrow.
Okay, I will tune in.
Representative Smith.
No, I was just going to say that is something that we have to be aware of, because a lot of times, especially in your larger urban counties, that will skew the results, skew without the R.
Don't quote
So,
on that.
yeah, I'd actually considered that proposal, because there's another formula I do, looking at some local data that I do that exact same thing. I add all of the levies together, and that's your percentage of that total portion of the levies. But
Yeah, and maybe also, and I forget to, at the end, we recognize that anything fairly drastic could have some negative impact on some communities. And so maybe a thought is if we want to change the formula, maybe it's implemented over time, or percentages over time, 3 or 4 years, everybody can kind of migrate into that and plan for it, something like that. But freezing it was, thank you, and helpful last year. So, or you can could you keep it permanently froze, I guess? I don't know.
Well, we'll definitely do a deeper dive. So,
Okay. Well,
yeah,
thank you, Madam Chair,
Yeah.
for letting us present. So I think.
absolutely.
that
Representative
covers-
Smith.
yeah, I just had one quick question. What do you have right now in Sedgwick County as the county for sales tax? Do you have, what's your percentage? Is that just the 1% general?
Just 1%.
No dedicated or special?
No. And the city of Wichita actually does not have a sales tax, which is, I was on the city council for a while, and I was like, wow, looking in, most cities have a sales tax. We had a 1%. It was voted in 87, I think. And on that bill, it said half of that revenue would go directly to reduce the property tax mill levies, and the other half was for roads and bridges. So that's what it's used for. So it's somewhat specific to what was in your first part of the presentation. So I wasn't around in 87, but apparently that's what we do now. So,
Okay.
But some of the cities in Sedgwick County do have their own additional sales tax, so.
So committee, that information is going to be distributed by Eddie via email, because it is a fairly long sheet of who has what sales tax. But I think it'd be good for all of us to know our areas. And thank you, Amy, for all your work on sales tax. If you guys ever have any sales tax questions, she is definitely an expert in the state, so we're lucky to have her. But thank you, guys. Any other questions for the conferees? Thank you very much.
Thank you, Madam Chair.
So, Eric, I did have one question for you, if you can get it off the top of your head real quick. You can answer from there. Who's maxed out at 5%? Maybe we don't want to answer that publicly.
So they are specific community improvement districts. There's one in Chanute there's one in Coffeyville. There are 2 in Junction City, and 2 in Leavenworth, and then 1 in Ottawa and 1 in Goddard. And the one in Goddard is the one that has the overlapping community improvement district and the transportation development district.
So they're at the 5%. So Chanute, I'll just give them a little bit of a shout out, though. They completely eliminated their mill levy. They are at 0 on their mill levy. So they are a little bit higher on sales tax, but they have 0 property tax for somebody that lives in the town of, city of Chanute. So very innovative thinking going on there.
Just
Eric.
as a follow-up, that 5% includes the county rate as well. And so in the county, the rate is 1.75%. So it's a little bit higher for counties as well.
Any other questions? Seeing none, thank you, Eric. Committee, we're going to take, how about we come back at 3:10? We'll put a little off schedule, but not much. Would that be okay? 15-minute break? Okay. We'll recess. Thank you.
What are you doing, man?
We start tomorrow at 9 a.m. I know we started today at 10, but we will start tomorrow at 9, hopefully can finish up, because I know a few of you have drives to make for tomorrow. So, wonderful. Next on the agenda is an overview of HCR 5014. We'll start with Adam.
Thank you, Madam Chair. HCR 5014 was introduced during the prior legislative session, the 2025 legislative session. It was introduced on March 14th, so it's towards the kind of the end of the session. The resolution currently resides in the House Committee on Taxation. There was an informational hearing on March 17th of 2025. I've included the bill brief explainer that was presented before the House Committee on Taxation. And since the resolution has not changed, I just attach it for this committee to review. Going through the HCR, the House Concurrent Resolution would amend the Kansas Constitution if it would pass. It would establish the Freedom from Taxes Fund. It would establish the Kansas Citizens Freedom Review Board, which authorizes the review of tax exemptions and approves or eliminates exemptions. It would also provide for the future elimination of state-imposed property taxes, income taxes, and privilege taxes. Under the constitutional amendment change, the Freedom from Taxes Fund would be established. That would also include two sub-funds. These would be the State Property Tax Elimination Fund and the State Income and Privilege Tax Elimination Fund. The funds would be administered by the State Treasurer. Any expenditures from the Freedom from Taxes Fund would be used solely for the elimination of state-imposed property and income and privilege taxes. The Kansas Citizens Freedom Review Board, created pursuant to the resolution, and the composition of the qualifications and manner of the board members would be prescribed by law, so essentially just by law. The board is tasked under the HCR with reviewing, approving, or eliminating in whole or in part any existing state sales or compensating use tax exemption that would go into effect for the next ensuing year. The board would be required to submit a report upon completion of its review of the exemptions. Then once the report is submitted, the board would be dissolved. After the Kansas Citizens Freedom Review Board eliminates a sales or compensating use tax exemption, the state treasurer would be required to calculate and transfer an equal amount of money generated from the elimination of the tax exemption. And that money's transferred would be deposited into this Freedom from Taxes Fund. And they would first be transferred to the State Property Tax Elimination Fund, the sub-fund, yearly in an amount provided as a result of the elimination of the tax exemption. Once the state treasurer determines that the amount of monies identified as projected interest earnings in the state property tax elimination fund is greater than the amount of monies needed to eliminate the state mandated property tax levies and state imposed property tax levies, so essentially at this point would be the 20 mills, such property taxes would be eliminated in the next ensuing year. The state treasurer would then transfer from the property tax elimination fund to the state general fund the interest earnings in an amount equal to the discontinuation of the property tax. And then the legislator would be prohibited from levying a state mandated or state imposed property tax after this date. So essentially what it would do, it would backfill the loss of the property tax with the interest earnings generated by the fund. After there's sufficient monies generated from the interest on the state property tax elimination fund, essentially any new monies would be deposited into the state income and privilege tax elimination fund. And again, once the treasurer determines that the amount of monies identified as projected interest earnings in the state income and privilege tax elimination fund is greater than the amount of money needed to eliminate state income and privilege taxes, such taxes would be eliminated in the next ensuing year. With essentially the state would then transfer money generated on the interest to cover the loss of funds, and that the legislator will be prohibited from levying a state income and privilege tax after this date. Any new or for any sales or compensating tax exemption that is eliminated, the legislator would be authorized to enact either new, identical, or similar exemptions. However, such exemptions would be required. It would expire after 5 years, but however, could be subject to further legislative renewal. So essentially, a rolling 5-year exemption would have to be renewed or they would expire. And that for any exemption that is approved by the board to remain in effect, the exemption would also expire at the end of 5 years, subject to further legislative renewal. The legislator would be prohibited from extending any exemption until the legislative session immediately prior to the year the exemption expires. So you couldn't proactively extend the exemption until the prior year. If the legislator eliminates any exemption or any exemptions expire, such money shall also be considered for transfer to the Freedom from Taxes Fund. In the event the legislator transfers money into the Freedom from Taxes Fund, such funds shall not be subject to suspension or transfer by the legislator. And then lastly, if once the state treasurer determines that the two subfunds are fully funded to reimburse the state general fund, the legislator may determine by a 2/3 vote whether to deposit the identified monies into the state general fund or propose a constitutional amendment to eliminate other forms of taxes. And then lastly, the amendment, if passed at the 2026 general election, would become effective on January 1 of 2027. And with that, I'd be happy to stand for any questions.
Thank you, Adam. Senator Corson.
Thank you, Madam Chair. So the board, if I'm understanding, I'm sort of looking at your memo, but I'm also looking at this. So would the board be responsible for finding $2 billion in tax exemptions? And then is it once they reach that $2 billion, is that when the board is dissolved at that point?
Not exactly. The board just identifies exemptions to repeal. And once they submit their report, the board would dissolve. Then essentially the savings, the yearly savings from whatever exemptions get repealed or eliminated, that would be the amount of money that gets yearly transferred from SGF. So essentially there'd be new money coming in, and then that money would get transferred into these new funds. It's basically the yearly savings is kind of my thought of how it would work. But I don't think there's any, looking at the language of the bill, they don't have to necessarily look at $2 billion. I understand that's probably the amount of money that it probably states, but the intent in the language in the constitutional amendment is that they look at the whole scope of the exemptions and they repeal certain ones, and then they use that amount of money to then transfer from SGF into these new funds.
And sorry, Madam Chair. And the board has the authority in and of itself to eliminate these exemptions. So the board isn't making recommendations to the legislature. The board has the authority to actually eliminate an exemption if that's what the board decides. The legislature doesn't get to weigh in on whether the legislature thinks an exemption should or should not be eliminated. Is that correct?
Correct in the aspect that the board would have independent authority to eliminate them. It states that the legislator could come back and reenact them for whatever that's worth.
Thank you, Madam Chair. I appreciate that. Thank you.
You're welcome. Senator Klemp.
Thank you, Madam Chair. I had a similar question, but I didn't catch how the board was established?
That would be established. It's not, the details aren't laid out in the HCR. That would be essentially the requirements would be laid out pursuant to a law you guys would have to pass further legislation.
So we craft a board and then that board would have the ability solely to eliminate without legislator. That was a follow-up question I had as well. All right, thank you.
And generally, there's a delegation of authority issue in Kansas constitutional, and that essentially by putting it in the Constitution delegates that provides for this authority to this board. So that's why general law we would say there could be an issue, and by doing it through the Kansas Constitution this way, that gets rid of a possible constitutional concern.
And it could be potentially unelected folks that are on that board, potential on how we would write the rule. Okay, thank you.
Senator Peck.
Thank you, Madam Chairman. So I'm going to talk a little bit over my head here. The reviser, and when I say the reviser, I mean the reviser, and I had a conversation years ago relating to undelegated authority. But by this, if I heard you right there at the end, because I had this question, then you sort of hit on it. Right there at the end, you said that by putting it into the Constitution, we don't have that issue of undelegated authority for unelected board.
That would be, since it's specifically written into the Constitution, that would be the way that there would not be a delegation of authority concern. This is, the Constitution provides for this board, essentially.
Okay. All right. Thank you, Madam Chairman.
Seeing no other questions, thanks, Adam. Representative Carpenter, welcome to the interim committee.
Thank you, Madam Chair, Mr. Vice Chairman, Joint Committee members. So I sincerely appreciate the opportunity to stand before you today and present this brainchild. Now, to the House members, you've kind of heard this spiel before, so thank you for indulging me, and thank you, Senators, for your time this afternoon. One thing that I do want to hit on before I dive into this, hopefully the staff sent you folks an updated version of this. I'm not going to hit on that too much because we are here to discuss HCR 5014, but I wanted it to be released to you today just so that you guys could have some of my thoughts on how it could be updated. And the reason why is because the initial version of this was written within about a week time at the end of session. And so it was produced very quickly, and it does need to be updated in my personal opinion.
So if I may, you are welcome to start to the updated version. We did get a copy of that last night. It was sent to us by Eddie. And since you've already improved on the process or the system, you might as well use that as your baseline.
Okay, thank you, Madam Chair. I sincerely appreciate it. So I think a lot of us have heard the old saying, the best time to plant a tree was 20 years ago. The next best time is today, right? This strategy, this system that we would be enacting here today is a long-term strategy. It is something where we invest money for the future generations of Kansas. And how it works is the investment is put into this fund by the elimination of the sales tax exemptions, which there's about $9 billion worth on the books today. And if we get $1 billion, if we get $2 billion, there's no set number on the board and how much they would be looking at in their review process. However, I would hope that when the board does their function in this process, that they take into consideration not absolutely destroying the Kansas economy, but that's also where we still play a role as a safety net and can come in and reenact any exemptions that we cry foul on, essentially. So as we look at this, it is a long-term strategy. It does not prevent us from doing short-term strategy items when it comes to our tax code. For instance, this year we passed a tax bill that is a ratchet that goes down to 4% on the income tax. We can still continue to do things like that, even with this in effect. This works in the background. And actually, as we do other things like making income tax adjustments and modifications, that actually speeds this entire process up, because if we're collecting less in income taxes, that means that the overall number is going to be lower for us to hit in these future years. Now, we've talked about the board. We'd have to pass a follow-up law on this, and we would have to prescribe how that board is selected and appointed, and then they would do their jobs, and then we would move forward. And then after this were to pass, one of the biggest problems that we have today is that when a tax exemption goes on and it's not given a sunset, well, I mean, that's as good as being immortal almost, because it's going to last on the books for a very, very long time. There's been a lot of efforts in this building over the years to eliminate exemptions, whether right, wrong, or indifferent. Pick your exemption. I'm sure that there's folks on the left, there's folks on the right that can point to an exemption that they don't care for, right? But that doesn't mean that it should be precluded from review. That doesn't mean that it should last there forever. Just because somebody was in a very powerful leadership position and got an exemption on the books for one specific entity, that shouldn't continue to exist just because that person was in the right spot at the right time. So that's the reason why we're adding this 5-year sunset, that we have to review these exemptions to make sure that they are still doing what they were supposed to be doing to begin with. Now, one of the biggest things I think all of us have seen in our time is the If there's a lot of money sitting around, people want to tap into that money. I think we've seen it recently with the rainy day fund. Well, hey, we can just take a few $10 million here or there off the interest generated from that fund, and we can spend it on this. Both sides do it. We all have good ideas. We all want to do the things that make a difference for our constituents. However, with this, it's explicitly written in the Constitution on the page 2, it says that the monies identified as principal in the Freedom from Taxes Fund shall remain intact and inviolate and shall not be appropriated, transferred, encumbered, borrowed against, or otherwise diminished for any purpose whatsoever. And the reason why is because if we do not protect the principal, this fund can get raided and it will not be as successful as it would otherwise be without that protection. You can look at sovereign wealth funds or wealth funds that are all over the world. Norway has a very prime example of it. They took, in the 1990s, they took excess oil and gas money and they invested it for their future. The population of Norway is about 5.5 million people. So that's about 2 times the size of the state of Kansas. Their sovereign wealth fund today is one of the most successful. It is about 2023 numbers, if I recall correctly, are $1.7 trillion. And it produced about $222 billion for a country the size of 5.5 million people. What I'm saying is that if we start going down this path, even though our state's at 3 million people, we could create a fund that ends up actually creating more as far as helping government fund itself than we do today based on the backs of our taxpayers. We all save for retirement. We all build our principal fund up. We have that nest egg for when we retire. This is essentially what the state of Kansas would be doing. We would be making it to where our future generations don't have to pay for it off their backs. But as we move forward, this fund is protected and it's helping those future generations not have to pay as much in taxes. Now, I gave you guys a graphic. And in that graphic, it talks about 3 different phases. The first phase would be the elimination of, it would be the first subfund, which would be the elimination of vehicle property taxes. That would happen in about a 6-year period where nobody would have to pay property taxes on their vehicles again. Everybody, every single one of your constituents, most of them have cars, and they're paying taxes every single year. I can't tell you how many plates I see that have Texas tags on them. I'm sure you guys have seen those too. And so what it would do is it would eliminate those taxes completely, and it would eliminate the administration fee for that completely. And as we move forward, the fund would be self-sustaining, and it would produce enough money to then send out money every year in interest, where you can go at 3%. There's a 3% cap built into this to where it grows at the rate of inflation. And that would be distributed out to the counties. So at the first year, let's say that Sedgwick County, let's say that they're paying $20 million right now for, and that's a made-up number, I'd have to go check, but let's say they're $20 million is what they're paying for their property vehicle taxes right now. Once this goes into effect, it'd take a snapshot in time, and it would then, every year after that, add 3% to it. Now the question comes up, well, what happens if our investments in that fund do not produce, or we go through an economic downturn? Well, that's the reason why we have a asset manager in here that would be managing our billions and billions of dollars worth of assets, and they would mitigate that risk for us. Once a fund is mature, they go from aggressive growth to a conservative growth strategy and attempt to bring in a 6% amount per year. Now, it allows us to go up to 3% to distribute. Now, if we have an economic downturn year, and let's say we only get 3% or 4% return on our investment, we can then go, okay, hey, we can't afford because of how bad things are right now to do the full 3%, but we'll give you a 1% increase over what you had last year, or a 0%, or a 2%, or a 3%, or some variation thereof. And then that will continue that fund. It'll allow it to be healthy and maintained without being depleted. Now, inflation is about 3% every year. This also makes it to where government entities who are receiving that money, oh, well, last year we had this much. If we get 3% this next year, this is exactly how much tax dollars we will have for our budget next year. It will actually make it to where they are tracking exactly how much money they're going to be getting from this fund every year. I'm going to speed up because I know you guys are running out of time. So then after that, you got your second fund, which would be go towards the complete elimination of all state property taxes, which is that 20 mills. And after that, it would be a march to completely eliminate all income taxes in the state of Kansas. Now, when I created this spreadsheet, which I'd be more than happy to send to you folks if you would like, or I can walk through it with you if you'd like as well after this committee meeting. But there's assumptions that were made within my spreadsheet, and I will communicate that now. So assuming that you can get 7.5% return on your investment, which we should be getting more than that if we have an asset manager that does this for a living and is good at their jobs. And we look at that contract every 2 years, and we as the legislature in conjunction with the state treasurer would renew that contract. And so hopefully we're not getting just 7%. Hopefully we're getting like 10 or more % on our investment every year, especially with aggressive growth. But then also, there was an inflationary number calculated into that, but it also doesn't include what we do in the short term as far as lowering how much income taxes we're actually taking in. And so these numbers that I'm about to share with you on how long this is going to take assumes all those things, which are all fluid. They can change. And so based on the calculations, it would take about 6 years in order to eliminate the vehicle property taxes. It would take about 12 years to eliminate the 20 mills, and it would take about 40 years, worst case scenario, to eliminate income taxes. And so in total, it would take about 59 years to do this. And the reason why the compounding model works the best is because it eliminates it within 59 years. There was some calculations that were made in order to, hey, we'll pay out the interest as it comes in. Well, if you do that just for, let's say, income taxes, the problem that you have is that it would take, adjusting for inflation and other things, it's going to take the better part of 80 to 100 years to eliminate that one item if you try to pay it out as you go. And so that's the reason why I chose the compounding model, was because it made more fiscal sense and people are actually going to end up seeing it sooner. So I've thrown a lot at you, but I sincerely appreciate this committee's time, and I will stand for questions, Madam Chair.
Thank you. Committee, Senator Representative Sawyer.
Thank you, Madam Chair. I do want to clarify, too, on your calculations. You mentioned the 7.5% rate. I assume, I want to just verify this, that it's taking $2 billion to start in that fund to make all that rest of that work.
Yeah, so the timelines that I just gave you was if we ended up with a $2 billion seed money every year, and then that is adjusted for inflation at that point moving forward. If you only, let's say, secure $1 billion, then that timeline, you can basically take that and double it.
Okay, thank you.
Representative Clayton.
Oh, thank you. I thought a senator might be ahead of me, but I'm happy to ask my question. So I've got a couple, but I will try to keep it fairly quick. In this updated draft, do we have a provision that makes it so that we are not changing anything regarding the sales tax exemption regarding B2B things? Because, I mean, honestly, as any good Johnson County legislator, this has been drummed in my head from the first time I ran for office. Do not eliminate that exemption. It will lead to economic collapse in Johnson County, which is, you guys know I'm going to say it, the economic engine of the state. What are you planning on doing about that?
So
is this in here? Is there a provision that keeps that out forever?
Thank you, Representative, for the question. For those listening in that might not know, B2B is the business inputs, correct? Just making sure I'm tracking, because I'm not on the tax committee, so I wanted to make sure I'm tracking what you're actually referring to. So at this point, no, it does not reference it, and that would be in the 5-year renewal cycle with everything else, or potentially eliminated. But I believe that the legislature would come in and reauthorize it. That being said, I'm going to leave it up to this committee. If you guys believe that that exemption should exist, okay. It's $3 billion worth. I'm not advocating for the elimination of that, and I hope nobody else would either. But I think that when we're looking at the exemptions, we have to look at the things that are going to be extremely detrimental to the economy of the state of Kansas, and that would be one that would be extremely detrimental.
All right. The second question that I have is, so I really like the first two taxes that we want to eliminate. Those are pretty regressive taxes. Now, I think there is not a one of us that hasn't heard from our constituents, especially about property tax. So that's something that we really agree on. But why a march to zero? I'm sorry, I have some trauma from that phrase. As long as I don't hear "Look out, Texas, here comes Kansas," I think I'll probably be okay. But why not a march to zero on the very regressive sales tax? Kansas has some of the highest state sales tax in the nation. And why not set that as a march to zero. I mean, I think that's especially detrimental, especially given the fact that a lot of our population centers are on the borders. So, I've got, my colleague over here where, it might be cheaper for you guys to go buy things over in Colorado. That certainly happens with us in Missouri. So why income tax, which I have literally heard from 0 constituents who want me to put that to 0, but I certainly hear from them when it comes to property and sales tax. So what's the logic behind that?
Thank you, Representative. Thank you, Madam Chair. So I think that we will have our differences on this issue. My constituents have asked for the income taxes versus the sales taxes. I think that's just a difference in our districts, difference in where we're located regionally. Now, that being said, at the end of the day, I believe that if we were to eliminate the income tax and all these property taxes, at that point, Kansas becomes a very attractive state for people to move to, want to retire in, and makes it to where they can grow a family. We stop losing people because now we have one of the best tax structures in the United States. And so I think that it makes it to where if we're only paying sales taxes here, we stop the brain drain. We actually start bringing people here.
All right, and then one other real quick point here. I do think that there is a lack of transparency in the fact that we're kind of vague about the board. I think that if we are putting this in ballot language, the board sounds, albeit temporary, still is incredibly powerful. We need to have in the ballot language who is on the board, who appoints it, under what circumstances, whether it's regional or not. And I will add, just to dispel the narrative that we have a brain drain based on our tax policy, I have a child that is going to live and continue to live in Chicago, not because of their tax policy, but because of their social policy, which is more welcoming to her than Kansas is. So if we want to look at that, we need to look away from tax policy and on other things. But tell me, why is the board not more clearly defined? And why is the description of the board not listed in the ballot language? Can we look at that just to be more honest with the people? If we're putting stuff on the ballot, we tell them who is going to hold the power and why and who appoints?
Thank you, Representative. Thank you, Madam Chair. I will just make a point, since you brought it up. I think that our social policies have actually been great here in the state of Kansas. And so I will look forward to Kansas continuing to have great social policies. Now, that being said, when it comes to the board and not putting the specifics into a constitutional amendment, there's a reason why. Because when you start getting into constitutional amendment language, you don't put every nitty-gritty little detail in there as much as possible so that the legislature and the people's representatives have the ability to work within the structure and the framework of what's spelled out. I think that there's other provisions within the Constitution that provide by law. It says that provided by law, the legislature shall do what they need to in order to enact this provision of the constitutional amendment. So that's essentially where that is coming from. The details would be allowed to be hammered out by us, debated by us, and ultimately approved by the governor at the end of the day, or not, depending on when this passes, but most likely we'll have a new governor, because this would be on the ballot in November of 2026 if passed. So whoever the new governor is, I don't know, maybe they're sitting in the room right now, maybe not. But, I think at the end of the day, it allows the flexibility of us to debate those items and work within the structure that was laid out by the Constitution.
Do you have a potential trailer bill for how you want that to look, since that would be something that we would be following if we are going to put that on our Constitution? Then we as legislators should at least know what we want it to look like, in particular because the House members, we might not still be here, but the senators will. And so do you have a draft for trailer legislation for how that would be looking?
God bless you, Representative. I don't look that far ahead, unfortunately. I've been focused on trying to get this passed. No, I have not even begun to attempt the draft language on that, because if we don't even pass this, then, I'd be having the revisers draft a bill that would cost the taxpayers money, and at that point, it would be a waste of resources. So I think at this point in time, no, my focus has been on this. My effort has been on this and trying to educate folks on what this is. And then if we pass it, if the taxpayers pass it, then at that point, that's when I think it would make logical sense in order to try to get after that trailer bill.
Thank you. Senator Klemp.
Thank you, Madam Chair. Thank you for the creative thought also. As I look at this, wouldn't mind getting your perspective on what drove the thought about having an independent board do this. I assume it's because we have a spending problem. We don't like to tackle that sometimes internally, but I'd like to get your perspective on that because I do think it's, and I also agree with your social comment. So I appreciate that as well. But if you would touch on that, and then it looked like you could also interlace short-term legislation, and how do you see that working? It seems like there's a lot of analysis that would have to be happening in real time, but I agree with that as well. So thank you.
Okay, so your first question was why the board? So I believe it was Senator Peck who brought it up. And in the past, whenever we've looked at trying to eliminate some of these tax exemptions, that type of thing, looking at an independent board, the reviser has always said, you can't do that. That's an unlawful delegation of legislative authority. So as I've tried to think about how to get after this issue, the only thing that I could really come up with was an independent board that's in the Constitution, because now it's not an unlawful delegation of legislative authority if it's in the Constitution and the people have approved it. And at that point in time, we can then have them do a review of the processes and get down to, okay, is this exemption doing what it's supposed to do? Is this exemption working? Was this exemption for, that's only, maybe $20,000 a year for this one organization, even though there's hundreds of this organization all across the state, is that doing what it's supposed to be doing for the people of Kansas? And then that's what they're going to get after. And then as far as the follow-up, in regard to how would this work with policies that we're working on today, how I view it, how I see it, is that because the money is not coming to the state general fund, which, by the way, if we were to repeal this money and just have it going to the state general fund, all you would see is us spend that money on whatever. And I feel like if you set the bar here, we as a legislature, it might take a little bit, but we as a legislature build up to that spending level, and we will spend that money. That's what I've seen in years past, and that's what I didn't want to occur. So if we end up with a windfall of money, let's use it, and let's use it for the betterment of Kansas and a better future for Kansas, right? And so while that money is coming into the SGF, it's then being immediately transferred to where we have no ability to stop it. So that fund is growing, and it's working in the background. And we don't really even see that money until those triggers go into effect. But there's nothing that stops us from making any other tax policy changes that we want to today. So let's say that we hit the 4% income tax. Okay, well, let's say that it worked great. Well, who knows? We're still working on it. But let's say it works fantastic. Here in 5 years, we hit that 4% for everybody. Okay, now, hey, shoot, that works so well. Let's go to 2%. We have the ability to make those changes, and this fund is still doing its thing in the background. Or if we want to make any other tax changes, if we want to do, if we want to look at HPIP, if we want to look at any of these other things, none of that actually impacts how this is working because it's working in the background. So I think that these actually work well together because our short-term tax policies, we can still modify and change. This would just be a long-term strategy of here's where we want to get to, and it's paid for. And we're not eliminating those taxes and then moving those tax burdens onto something else. Like income, if we remove income tax, we're not moving that burden to property taxes. We're not moving it to sales taxes. It is eliminated. It's paid for.
Thank you, and thank you, Madam Chair.
Representative Vaughn.
Thank you, Madam Chair. I have two quick questions. And you're right, we did hear this in House tax last year. I know you talked about Norway coming up with this concept. Is there any form of this concept currently being used in any state in the country at any degree?
Great question. Thank you, Representative. Thank you, Madam Chair. The closest thing that might get close to it is Alaska and what they're doing up there with the refunds that they do for their citizens based on the oil and gas money that they receive from those corporations and companies. So similar in nature, but yeah, I would say this is tweaked compared to what they have. But we would be the first state that is going after it in a model in this form, is based on my understanding of all the other state tax policies that exist today.
Okay, my second question real quick is, my concern is sometimes when we put these questions on a ballot for the general public to vote on, the questions are long and confusing. We've seen that in the past. Have you thought far enough ahead to see what this question on the ballot might look like?
Oh, yes, I have,
for
Representative.
understanding purposes?
Okay. I would like the committee to flip to their new version of the language on page 11. So this is a long constitutional amendment. And so I attempted to break this down in layman's terms, because that's also another problem that we've heard. This is written in legalese. I have no clue what this is actually doing or saying. And so I attempted, and you guys can massage the language if you like. This is just one person's opinion, but I'll go ahead and read it. The explanatory statement is, this amendment creates the Freedom from Taxes Fund to eliminate taxes on vehicles, reduce home property taxes by approximately 15%, and phase out the state income and privilege taxes over time. The fund is funded by ending wasteful or outdated tax exemptions. A temporary Kansas Citizens Freedom Review Board will review all exemptions and decide which to keep or remove. If a popular tax break is cut, your elected representatives can restore it. All special interest tax breaks would be reviewed at least every 5 years. The fund would be a permanent savings account for the state. It will grow over time and earn interest, and that interest will be used to help pay for schools, roads, and other priorities. So the state can stop collecting certain taxes from you. The Freedom from Taxes Fund itself is protected by this constitutional amendment, which means politicians are legally blocked from spending or rating it for other purposes, guaranteeing it remains focused solely on reducing your taxes now and for future generations of Kansans. And then a vote yes for this proposition and a vote no for this proposition. A vote yes for this, or a vote for this proposition, means ending the state taxes on motor vehicles, lowering home property taxes, and phasing out state income and privilege taxes over time without cutting essential services. It creates a Freedom from Taxes Fund and a temporary Kansas Citizens Freedom Review Board to decide which tax breaks to keep or eliminate. Future tax exemptions would be limited to a duration not to exceed 5 years without further enactment by the legislature. A vote against this proposition means the state of Kansas will continue taxing motor vehicles, property and income and privileges to fund government operations. The state constitution would remain unchanged. So that, I felt like, was very straightforward to the point of what this does, and it's not really in legalese or layman's terms, but if a normal citizen reads that, they know what they would be voting for.
Okay, thank you.
Thank you, Senator Corson.
Thank you, Madam Chair, and thanks for being here, and I appreciate the vote of confidence. My question is sort of touched on by Senator Clem, but maybe to put a little bit finer point on it, I have a real concern about this board, because I just think that it is a core function of us as elected officials sent by our constituents to make decisions on things like whether or not a given tax exemption is appropriate and needed. And certainly we would disagree with among us, but I think it should go through the legislative process of debate, of having legislators vote on it. I just have a real concern about delegating all of that authority to an unelected board. And I know you tackled that a little bit with Senator Clump's question, but if you could just address, because I'm very concerned about that notion of giving up that authority from the legislative branch.
Thank you, Senator Corson. Thank you, Madam Chair. So in a perfect world, I don't disagree with you. You're right. There is a certain function that the legislature, it's our jobs to carry out. But we've spent decades attempting to solve that problem ourselves, and we've gone nowhere. And so this is an attempt to at least give ourselves a chance to actually get into the issue and allow it to happen with this independent Citizens Freedom Review Board. Now, some people might not like it, other people might. It just depends on what you're comfortable with at the end of the day. One thing that I want to reiterate, though, is that if something is done away with, we as a legislature have full authority to go back in and say, that wasn't right, we're going to reestablish that, and we're going to repass it. And it puts it right back onto the books. So there's a safety net there, even if they eliminate something that the majority of us want. Let's get it.
Thank you, Madam Chair, and I appreciate that response. The other question sort of dovetailed on what Representative Long asked, which, the fact that no other state is doing anything really similar to this gives me a little bit of pause as well. Although, again, I do appreciate your creativity in coming up with an idea and presenting it to us. I absolutely appreciate and admire that. But, you know, it feels to me like a little bit kind of, dare I say, kind of an experiment that Kansas would be going through. And I'm a little worried about future tax experiments because I think we've kind of seen that movie and I didn't really love how it ended.
Well, I'm not going to acknowledge that last comment other than the states are laboratories of democracy, right? And I believe that this is a concept that if adopted, it will bear fruit and other states will copy us. You know, it's one of those deals of the state of Kansas, we didn't become a free state because we didn't want to lead. We were more than happy to lead. And we led on that issue. We've led on other issues throughout the United States. And I think this is another issue that we can lead on again.
Senator Bowser.
Thank you, Madam Chair. And thank you, Representative, for your testimony today. And I want to applaud you because this is a big, bold idea. And I got to be honest with you, sometimes when I hear things for the first time, and in this case, this is true, I really just have comments, not questions. But when I first heard this idea, I thought, this is the craziest daggum idea I've ever heard. But then when I think about it a little bit, there really are, and I learned more about it, there really are some good nuggets in here, I think. I do have some concerns about unelected officials making decisions. I think I've got some concerns about, you know, getting the seed money to get started. But again, there's some good nuggets here. I 100% agree we need to take a hard look and review at our tax exemptions. 100% agree there. And I really like the idea of the strategic fund or the strategic wealth fund. I have proposed a similar piece of legislation in this upcoming year. I agree 100% with you there. So, again, the idea kind of sounds crazy when I first heard it. I thought there's no way, but the more I kind of think about it, I think there might be something here. Make no mistake about it, this is a stretch. This is not going to be an easy thing to do. There's going to be a lot of hurdles and roadblocks, and I don't know if we can do it, but I, again, applaud you for the idea. Thanks for bringing it forward, and I think it's worth a little more consideration. So thank you very much. Thanks, Madam Chair.
Thank you, Senator.
Representative Smith.
Thank you, Madam Chair. Representative Carpenter, thank you for your efforts and your work on this. You and I have had some conversations about this.
Some very late conversations.
Yeah, late at night. I've mentioned to you at times the math works, but the politics might be a little bit, that'll be difficult to navigate. Have you come up with an answer? Because the money for this fund comes from the taxpayers in the form of repealing tax exemptions. Do you have a talking point or a suggestion for us as fellow legislators if we're going to vote for this? How do we address the people that might say this is a tax increase because we're repealing a tax exemption, so we're going to be paying sales tax where we haven't been? I like the fact that we're trying to pay off I think the 6-year the vehicle property tax. That gives a little bit more impact. It happens a little bit quicker. If you went after something that took 30 or 40 or 50 years from the get-go, it's going to be hard for people to really see the benefit of that at any time soon. But just curious on your thoughts and how you work through some of the politics on how we convince the Kansas citizens that this is in their best interest.
Thank you, Mr. Chairman. Thank you, Madam Chair. So at the end of the day, you know, when we look at these tax exemptions, it depends on the tax exemption, right? Not everybody's paying for these different items that are for sale by different entities, right? So when you're giving tax exemptions to certain people, the people themselves are actually paying more in taxes elsewhere. So by broadening the base, you get a chance to lower the rate. And that's essentially what we're doing. It's just we're doing it in a manner that is coming at it from a compound interest manner and its long-term sustainability. So in recent years, I mean, we cut taxes here in we've been on a merry-go-round, right? We cut taxes, we got budget shortfalls. Okay, now how can we make up those budget shortfalls? Okay, raise taxes or cut spending, right? Well, we've been having a problem with cutting spending, but you see how this is a cycle that just continues. This allows us to break that cycle. And when you go to your constituents, you get to say, well, first of all, I put this on the ballot so you get a chance to decide on if this is something that you want. But at the end of the day, I voted for you to no longer have to pay property taxes on vehicles. That's one of the things that my constituents do talk about. They're very upset about paying their property taxes on vehicles every single year. And this eliminates it in a fairly quick manner. And so that is the visible relief that they get to see. Now, if somebody, let's say, buys a newer vehicle, they could be paying $500, $1,000 on that vehicle. If they have a large family, they could have 5, 6 different vehicles that they have to tag every single year. And so when you start getting into that and comparing that to the sales that they might be spending on the particular entity that is exempt from that sales tax, I would say that in short order, when people stop having to pay that property tax on their vehicles, it immediately already starts countering these items that went up for a short duration or a short period of time. So at the end of the day, you know, one of the things that I said back during session was, it's not about the next election, it's about the next generation. That's also what we hear our constituents say. I want to leave a better country, a better state for my kids, my grandkids. And that's what this affords us. And as I've talked to people about this idea, from all political spectrums, people that are political and people that aren't, they go, you know what, I do want a better future for my child. I do want a better future for my grandchild, and this is going to secure that. And they are absolutely on board. And so that's been my experience as I've shopped it around to different constituents and even people that I work with. And I think that because we allow for that first phase to hit and hit that quickly, it will, I think, make a difference.
Thank you. Committee, thank you. Okay, Senator Klemp, then Senator Peck.
Thank you, Madam Chair. Mine's quick. So do you, when you were talking right there, I had a quick thought. One was, we have a spending problem today that needs immediate attention. Bringing in 10, spending 10.5, or in round numbers. Do you think that these potential cuts, or where we find these, will compete with the need for an immediate fix on the shortfall that we have today?
Great question. There's actually a press release that's probably going to go out later today that you'll see on budget stuff for 2026. So should be hopefully helping to resolve that issue, and more details to come.
Thank you, and thank you, Madam Chair.
Senator Peck.
Thank you, Madam Chairman. The most important and biggest economic driver in our state is agriculture, not some particular county. But I'm with most of what has been said as far as I like the idea and I don't like the idea. I like parts of it, I don't like parts of it. The fact that the voters have ultimate say, we want to make sure we get it right if we do get it to the voters, and they're the ones who will determine if we do or do not amend the Constitution. My question, you said you've been shopping this around. What has been the biggest objection, hurdle that we, if we do go down this road, would need to overcome to help constituents understand the value of the proposed constitutional amendment? What's the obstacle or hurdle, objection, and what's the remedy or answer to their objection? And I know that's, Mr. Pro Tem, probably a difficult, tough question, a big question, but I thought at least might help us, because I will be joining and shopping this around. Because of the fact it's innovative, it's outside the box, big thinking. Doable? I don't know, but I like to throw these kind of things out to my constituents. But if I could get you to help me be a little bit better prepared than I am at this very moment, I'd appreciate it. Thank you, Madam Chairman.
Thank you, Senator, and thank you, Madam Chair. So I would say that I'm more than happy to sit down with any of you and anybody in the legislature really to go in depth, walk through all the spreadsheets, walk through all the stuff in order to get the information to you that you can then pass on to your constituents. The problem is that what I have today is anecdotal stories of people that I've talked to, right? And so that's people in the workplace, that's people in the district, most likely similar beliefs. That's why I hope that they keep sending me here, right? So what I would hope is that you guys would go out and talk about this with your constituents and see what they think. So far, no. The people that I've been talking to, they they are not in the weeds, in the politics every single day like we are. They're not in the Topeka bubble. They're just normal, everyday citizens. And when I talk to them about, hey, it works very similar to an endowment fund. It works very similar to how you save for retirement. And here's how we get after it. And once the fund is mature, it works in perpetuity. You know, we can take that, we can eliminate that tax from you. We can eliminate that burden from you. We can eliminate it from your children, your grandchildren. That's what they latch onto. That's what they really enjoy, and that's what they really like. Same with Norway. That when they talk about their sovereign wealth fund, they talk about how, even at the beginning, this is going to help future generations of Norwegians. This is going to be providing for our future, and it has. And so I think that when I've talked to people, they see hope. And right now, there's a lot of people out there that I think look at politics and they're not hopeful about the future. And when they see this, they don't see us kicking the can down the road. They see a possibility for a better future, a brighter future for their children, their grandchildren. And when it starts getting into the weeds, they're like, you know what, this makes sense. This works. I understand where you're going in general, and I like the idea. So that's my anecdotal stories, and that's my anecdotal evidence. But I would absolutely encourage every single one of you to have the conversations with your constituents back home, because I do believe that this does have merit. I do believe, yes, it's different, but I think it's a good different.
Very much appreciate you bringing innovative ideas. We definitely need them in front of the legislature. I'm sure we'll hear more about this in the future. So thank you, Representative.
Thank you, Madam Chair. Thank you, members of the committee.
Yep. Committee, next up is Catherine Lawhead. Sorry about that. Welcome to the Tax Committee. Catherine, it's nice to see you in person. Thank you.
Thank you, Madam Chair. It's great to be here. Thank you, members of the committee. I appreciate the chance to speak with you today on HCR 5014. My name's Catherine Lawhead. I'm a senior policy analyst and research manager at the Tax Foundation based in Washington, D.C. And while the Tax Foundation does not take a position on any legislation, I appreciate the chance to provide some information on the subject matter that I hope will be helpful to you as you consider this proposal. In the interest of time, I think you have my prepared remarks in front of you that you can consult later. I'll try to be briefer than that. But to start, this resolution, I think, has merit, but I do have several strong concerns with the version of this resolution as currently drafted that I'd like to walk through and to propose some potential solutions to. I won't recap all of the summary of this resolution because we've already heard some good summaries today, but there are a few main goals here. I think first, creating the Freedom from Taxes Fund, using revenue from sales tax base broadening, and then using that interest from the compounding interest to eliminate various taxes over time. And I think of these goals, the goal of reducing reliance on the income tax is especially worthwhile. While all taxes create some economic drag, some are much more economically harmful than others. And it's important to prioritize for reduction or elimination those taxes that are the most economically harmful. And there is a large body of economic literature showing that income taxes tend to be more of an impediment to economic growth and location decisions than well-structured sales and property taxes. Income taxes fall on savings and investment, and they reduce the capacity for future consumption, while sales taxes are more neutral. And when it comes to the corporate income tax, it's important to keep in mind that that tax, or the burdens of the corporate income tax, are borne by workers in the form of lower wages, consumers in the form of higher prices, and investors in the form of lower returns on investment. And when it comes to individual income taxes, there's a lot of evidence from other states that either have no individual income tax or that have a low flat rate outperform their peers year after year in terms of attracting new residents. So I do think the Kansas legislature has a really unique opportunity to help foster greater economic growth by moving more toward less harmful taxes on consumption and away from some of the most harmful taxes on productivity. So another goal of this resolution is, of course, to broaden the sales tax base by eliminating various exemptions to deposit that extra revenue in the Freedom from Taxes Fund so the interest can be used to eliminate various taxes. And I do think modernizing the sales tax base is an excellent goal. It's something we've long recommended for Kansas, but it is absolutely essential to get that sales tax base broadening right. And most economists would tell you that the sales tax is designed to be a tax on all final personal consumption, so goods and services, but not business-to-business transactions or business inputs. Taxing business inputs creates a lot of tax pyramiding, where taxes get embedded in the price of the good multiple times over, and when the consumer pays the tax, they are paying a tax upon a tax. And this would be especially harmful in Kansas because the sales tax here, like in many states, is destination sourced. So it is paid based on the location of the consumer. And so as a result of that, taxing business inputs would create a lot of problems because, for example, if you applied the sales tax to marketing services, that's a business input. Kansas businesses would be the ones paying that. Out-of-state businesses would not. So if you're a Kansas business, you hire a marketing firm from out of state to generate a marketing campaign. The Kansas-based business is going to be paying that sales tax, not the out-of-state business, if the roles were reversed. So this could be really harmful, especially if a lot of different business inputs are taxed, or for any businesses that rely especially heavily on any one taxable input. So I do think that is pretty problematic and something that shouldn't even be in the base to begin with. And honestly, I think taxing business input should be taken off the table altogether. Another concern I have with this proposal as currently drafted is that it expands, by expanding the state sales tax base, it also expands the local sales tax base simultaneously, because Kansas has essentially a uniform state and local sales tax base with some minor exceptions. And so what would be done with that extra local revenue? Would local governments just pocket that extra revenue? I think one solution could be for the legislature to come in and say, by expanding the base, we are going to require you to perhaps reduce local property taxes with that extra revenue, but that is potentially another complicating factor here. And then again, I share the concern that a number of you have mentioned today, which is that it would task an unelected board, the Kansas Citizens Freedom Review Board, with identifying sales tax exemptions for elimination, and any exemptions that are identified for elimination would be eliminated without an act of the legislature. And so while the legislature would have the authority to come back in and reverse decisions made by the Citizens Board, repealing exemptions and then potentially restoring them soon after the fact would create uncertainty for taxpayers, instability in the tax code, and unnecessary turbulence in the policymaking process. And this could even put legislators in the tough position of having to reverse decisions that were made by the review board that are either legally impossible, structurally unrealistic, or that the legislature disagrees with as matters of policy. More importantly, though, I think that the legislature should ultimately be the one to make any sales tax base broadening decisions, because the power to tax is a fundamental power granted to the legislature as an elected responsive board that is checked by a governor. Authorizing a separate board to change the law would be an abdication of the legislator's right and responsibility to make the tax policy decisions voters have entrusted to them. Any expansion of the sales tax base should be done carefully and methodically, with the legislature leading this process, and with sufficient opportunity for all legislators and stakeholders to provide their input. If an unelected board is appointed to make these decisions, then tax burdens could shift dramatically with no input from policymakers directly accountable to the people, and also subject to a legislative code of ethics. But if legislators don't want to abandon the idea of a review board entirely, one alternative could still be to have this board serve as an advisory board that reviews the existing sales tax exemptions, offers recommendations and a report to the legislature on ones that they would recommend the legislature repeal, and that could help inform the legislature's decisions, but ultimately the decision would rest with the legislature. Additionally, I think policymakers should consider adding some basic parameters for the composition of such a board within the underlying resolution itself, rather than waiting to do so in a future implementation bill after voters will have already approved the constitutional amendment. I think this would provide some peace of mind ahead of time. And I think, you wouldn't have to spell out all the details, but you could say, for instance, a certain number of legislators need to be on the board, perhaps some economists and other experts, just specifying some broad strokes what this board would look like. And again, I think an advisory board like this or a blue ribbon commission has a lot more precedent than a board that makes these decisions outside of the legislative process. And now to move on to the main substance of what the resolution seeks to accomplish, which is to create what is essentially a state-run endowment fund to finance the elimination of various taxes. I do think an endowment fund type of idea could be worth considering, but I would strongly encourage policymakers to consider phasing down the specified taxes over time instead of waiting until there is enough interest in the fund to eliminate a particular tax altogether. For example, if a law is enacted to eliminate $1 billion worth of sales tax exemptions, that would generate approximately $1 billion in additional revenue that could be transferred to the fund each year as principal. So as long as that principal remains intact and inaccessible and a similar amount is transferred to the fund each year, the amount of interest would continue to grow with the principal year after year, even if most or close to all of the interest is taken out on an annual basis to phase down various tax rates over time. So I have an example here of if we use $1 billion and that amount of sales tax-based bonding revenue is deposited into the fund, assuming a 7.5% rate of return, this would generate approximately $75 million in interest after the first year of investment. So policymakers could reduce taxes by $75 million the following year. After the second year, the state would now have $2 billion of principal, and that would hopefully generate about $150 million in interest after the second year of investment. So policymakers wouldn't have to generate, or they could generate $150 million less than they would have had to otherwise from various taxes. So the tax rates could be stepped down incrementally over time. I do think it is important to consider what the legislature would want to do or how to respond if the market has a tough year and the fund generates less interest than expected. And I would encourage policymakers to consider adding some buffer in the proposal so that, for example, only 90% of the interest that is generated in any one year is used to reduce tax rates the following year, with the rest retained specifically for the purpose of preventing tax hikes in leaner years. And I do think phasing down tax rates over time would be better both for the taxpayers and for the economy, because individuals and businesses could start benefiting from this proposal almost right away, much sooner than if they were forced to wait until there's enough interest to eliminate a tax altogether. I think that would make this proposal, especially the sales tax-based broadening part, more palatable, because understandably, I think taxpayers might be hesitant to accept potentially billions of dollars worth of sales tax-based broadening and paying that amount year after year if they're going to have to wait decades to experience any of the promised relief. If taxpayers know some of the tax increases will be offset almost immediately, that may improve the feasibility of this plan. And I think specifically phasing down income tax rates over time would really kickstart increased in-state investment and economic growth almost immediately, whereas the proposal as currently drafted would delay by decades most of that economic growth, especially if the income tax is the last of the taxes to be eliminated. Now I want to turn back to one of the ultimate goals of the resolution, which is to eliminate the state portion of the property tax, as well as the state's income and privilege taxes, and potentially first eliminating property taxes on motor vehicles, as has been proposed in this amended version of the bill. Of these three separate goals, I do think working toward the eventual elimination of the income tax, again, should be the highest priority, because income taxes are much more economically damaging than taxes on real property. There's evidence that of all the various sources of revenue state and local governments rely on to generate funding for government services, corporate income taxes have been shown to be the most economically harmful, followed by individual income taxes, whereas sales taxes and then property taxes are less economically harmful. So the state wouldn't get a whole lot of bang for the buck if you're relying a lot more on sales taxes to rely a little bit less on property taxes. And so I can understand why policymakers want to get rid of the state portion of the property tax altogether, but I would posit that eliminating the state portion wouldn't do a whole lot to relieve administrative burdens compared to eliminating the income tax or substantially reducing it. if the state can eventually eliminate the income tax, there's a whole lot of taxpayer burdens, both for taxpayers, businesses, individuals, as well as the state in complying with and administering the income tax specifically. And it also, again, is one of those most harmful to growth. So I do think it's also important to acknowledge that a draft amendment to this resolution proposes to eliminate the tangible personal property tax on motor vehicles before eliminating other taxes. And I do think that could be worth considering because that is a smaller source of revenue. It could generate some momentum early in this process of taxpayers actually seeing a tax get eliminated from the books. But the car tax really is more of a nuisance tax than anything. And so ultimately, I would say that tangible personal property taxes broadly as a category of tax are worth considering phasing out over time. So the car tax could be the first category to tackle. But again, I do think the income tax is the most important. And then returning briefly to the topic of expanding the sales tax base, I think it's, again, important to keep in mind that this would be a type of revenue increase that would come without other short-term benefits until there's enough interest in the fund to eliminate a tax entirely. So while the various property taxes would presumably not take long to eliminate, income and privilege taxes would take decades to eliminate, and all the while Kansans would be paying more in sales taxes year after year than they do now. And unlike most other tax increases, that revenue couldn't be touched. It would go to this fund permanently. You wouldn't want to touch it, but it couldn't be used to increase spending. It couldn't be used to reduce other taxes until the appointed time. And so this is probably one of the main reasons this type of idea hasn't been extensively tested elsewhere. However, I do think there is a strong argument that achieving sustainable long-term reform for generations to come is worth the drawback of paying potentially higher taxes in the short run. But this is only true if the desired outcome is successfully achieved, which means it is really critical to get the details right at every step in this process. And then one final thing I want to mention before I wrap up is that while I do think this is an interesting idea, I think it could be workable with some modifications. Taking this endowment fund style approach could be a lot more complex than accomplishing many of these goals through more traditional means. Earlier this year, Kansas policymakers demonstrated commendable leadership by finding a responsible way to use excess income tax revenue above an inflation-adjusted fiscal year 2024 baseline to phase in a low, flat individual income tax rate over time, and then after that to reduce the corporate income tax and privilege tax rates. And I do think that's a well-designed law. I think it's something other states should look at following. So moving forward, if you are really serious about wanting to expand the sales tax base, it could be worthwhile to consider modifying Kansas' existing tax trigger law slightly, so any inflation-adjusted general fund revenue growth above a specified amount could be used to reduce various taxes over time, starting with the income taxes. If all state general fund revenue rather than just income tax revenue only is used to reduce income tax and other tax rates potentially, then any sales tax base broadening revenue would automatically help reduce these income and privilege tax rates over time under the existing system. So again, I think this idea does have merit, but I do have some serious concerns about the proposal as currently drafted. I do think there are solutions to these things though. I have a summary there of all the points that I made throughout if you just want to see a quick summary, but I am happy to answer any questions.
Thank you, Catherine. Senator Corson.
Thank you, and thanks for coming and making the trip here. I really appreciate it. That was a lot, and I want to make sure that I understood sort of the central thrust is, in your view, that it would be better if in Kansas we had a lower income tax and a higher sales tax, so people were paying. Is that accurate to sort of generalize that you think the priority should be lowering income taxes, and that if we and then on the flip side of that we would increase sales taxes, and that would be the best way to grow the economy?
Thank you, Madam Chair. Thank you, Senator. I do think there's a lot of economic benefits Kansas could benefit from in moving away from high taxes on income and using some of that, shifting some of the burden toward broadening the sales tax base. So I would definitely prefer broadening the sales tax base to raising any tax rates. But I do think overall, if you increase taxes on consumption, that's less economically harmful. And so that's a pro-growth tax change to rely more on income taxes, or sorry, more on sales taxes and less on income taxes.
So lower income taxes, higher sales taxes. Okay, thank you.
Thank you. Representative Smith.
Thank you. Almost kind of tagging along off of Senator Corson's comment when we were going through this. You mentioned that point, and I guess my question to you is, what prevents people that live kind of close to the border from getting the best of both worlds? They want to live in Kansas. Let's say we focus on income tax first and getting income tax either to zero or to a lower rate. They can live in Kansas and enjoy that, but they just have to take a short drive across the border to go shopping. If Missouri's rate is less, or Nebraska, Colorado, Oklahoma, sales tax is one of the most fluid taxes, so people can, probably nobody from Salina is going to drive to get groceries in Nebraska, but you know, what's your response to that? Because we do have a couple of very large population centers that are very close to the border. How does that factor into play?
Thank you, Madam Chair. Thank you, Representative. That's a good question, and I do think there'd be a lot of inbound migration, especially potentially from Missouri, that could happen if the state were to continue to reduce and maybe eventually eliminate the income tax rate. There'd be a strong incentive to live and work in Kansas over some of the neighboring states if you're right along the line. There is sales tax competition around borders in all the states, and that's a reality to consider. So I do think there are benefits to making sure your sales tax rate isn't that much higher than that of a lot of your neighbors, and there's definitely a strong argument to be made for making sure you're not taxing a lot of business inputs that your neighbors are not taxing, because that could very well cause businesses to go right across the border from Kansas City, Kansas to Kansas City, Missouri, to not have to pay those taxes on their inputs anymore.
Representative Sawyer.
I want to follow up. I was trying to follow all your flow of your comments. It sounded like, though, you did say eliminating motor vehicle taxes would be a good idea. In fact, you said eliminating all property taxes, but the reality in Kansas is that's mostly all that's left on the personal property tax side. We don't tax that much personal property anymore other than motor vehicles. That's the biggest thing. So if we do that, we would be accomplishing that goal, and it would happen fast. And I think I heard you say that when you're going through all that.
Yes, thank you, Madam Chair. Thank you, Representative. I would like to see Kansas move away from taxes on tangible personal property altogether. You know better than me how much personal property there is left in the state, so I'm glad to hear that there's not a whole lot additional TPP that is still being taxed. So it could be strategic to maybe even add all TPP to that initial goal of what are we phasing out initially, or what are we eliminating initially. So maybe not just the car tax, but what other TPP is there too. I think eliminating the car tax is a good idea, but not necessarily a pro-growth idea, especially if you're relying a whole lot more on sales tax revenue.
So I would ask a couple of questions. You mentioned that the car tax was a nuisance. I don't know, you might not be familiar, but I think if I'm right, if I remember the number correctly, it's about $480 million currently, approximately. It's less than $500 million that's collected on vehicle property taxes. That's more than a nuisance to most of us. Would you want to visit that? And I know in the mix you said income tax versus sales tax, but the majority of us are hearing property taxes right now, and I have a theory on that. I think it's because they write the check 2 times a year or 1 time a year, and so they notice it more. But we do collect more in property taxes right now as a state than we do in sales tax or in income tax. And so that's why we're hearing that from our constituents. It's a real issue in Kansas. I know Tennessee has a lot lower property tax. Alabama, southern states, I've looked at their models, trying to come up with ideas, but Could you speak to that a little bit, or?
Yes, absolutely. So it does generate a fair amount of revenue compared to other states where it might be more truly of a nuisance tax. So certainly it is a large burden for plenty of Kansans, but in the scheme of things, compared to other taxes that have real strong negative economic effects, that's more what I'm worried about in terms of what truly should be the priority for Kansas to phase down or eliminate. And I think taxes on vehicles don't make sense. I think they're certainly a burden and certainly something folks want to get rid of. But from an economic growth perspective, I just do want to talk about not all taxes are created equal, and there's different economic effects associated with different taxes.
Would you mind getting us some information, some follow-up for the committee as to economic impacts with different taxes so that we would have a better picture of what you're talking about or how it could impact Kansas? I mean, might be a heavy lift for you, but I think it would help the committee see which direction we should focus our efforts on.
Yes, absolutely. And there are a number of studies in one of the footnotes here, footnote 1, that I referenced that talk all about the relative economic burdens of different taxes. So I would point you there, but happy to follow up with any additional information that would be helpful.
Yeah, and this weekend I happened to be with my father-in-law. He was getting glasses, and the lady was telling, and maybe everybody knows this, I didn't know this, but Missouri actually charges sales tax on glasses and medical. When you go get a prescription, you pay sales tax in Missouri. That's one nice thing that we do not have in Kansas. So there are differences between and anyhow, so I would also ask, property tax is a big issue. So do you have any suggestions, or have you looked at it? I mean, I know I'm a little off topic, committee, and it's late. So I just want to ask really quickly, since you flew in, and maybe you want to send this to us later, but, we've been making some changes in our policy. We've done some excellent things with the sales tax on groceries. We were able to take non-prepared foods to state sales tax to 0. Then income tax the last couple years, extremely good policy. We completely exempted Social Security, increased the personal exemption from $2,250 to over $8,000 individual, almost $9,000. So yeah, we've made some big changes in Kansas tax policy, moving in the right direction. But any suggestions on property taxes? I did get one yesterday, committee, I'll throw out, and I think this is intriguing. I got a phone call. Why are we having locals do car tags? Why aren't we doing those like other states? And that's what you referred to as improving our processes so we could lower our taxes that way. So that's something that we can think of as a committee. But would you like to address that?
Yes, thank you, Madam Chair. So property taxes are definitely a big issue here and throughout a lot of the rest of the country right now. We've seen a lot of people's property tax burdens skyrocket because assessed values are rising so rapidly. And ultimately, the root of the problem is that local spending is increasing and there's not anything that's being done to prevent local spending from growing as assessed values rise. And so ultimately, there has to be a mechanism to encourage local governments to, when assessed values rise, to reduce millage rates accordingly, and a levy limit would do just that. And I think that would be the best solution for Kansas to consider. I know you had the property tax lid in the past. There were a lot of exemptions and loopholes that made that not very workable. I think a tighter property tax lid would be a great solution. In the interim, though, I do think the revenue neutral policy is doing pretty well overall with keeping a lot of folks' property tax burdens low, but there's still plenty of counties that are just pocketing the extra revenue unchecked. So ultimately, the legislature could adopt a levy limit to allow a certain amount of spending growth, inflation adjusted year after year, and capping that amount so that so millage rates have to be reduced to keep everyone's property taxes from growing out of proportion.
Thank you, and thank you for your indulgence, committee. Any other questions for Catherine. Thank you for coming in again. And I'd like to thank Representative Carpenter again. I mean, I know how it is to bring in new ideas and you take a lot of bullets, but you know what? You kick off a lot of thoughts. Like Senator Bowser said, it starts the conversation and it gets us going in a direction I think Kansas needs to go. So thank you very much. Committee, any other business to be brought before us? We'll start again tomorrow at 9 a.m. We have a full schedule again, but there will be a break for lunch. You will be on your own for lunch tomorrow. So committee, thanks for your work today, and we'll see you in the morning.